1.
Good morning, ladies and gentlemen. Welcome to the October 2025 meeting of the Board of Oil, Gas, and Mining here in Salt Lake City. We've got a very full agenda today, so we're going to head right into the briefing session. And I think Natasha Bailiff is conducting the briefing session today, so go ahead there.
Yes, thank you. You get me again. My name is Natasha Bailiff. I'm the Legislative and Planning Coordinator for the division. Currently, Mick is in, or I should say Director Thomas, is in Australia and New Zealand on a critical minerals tour. I believe the governor and some legislators are along, so he's having the time of his life, I'm guessing. As it was said earlier, this is the October 22nd briefing session for the board. And last month we were starting to talk about the board hearing schedule for 2026. We put it on hold so that we could solidify some dates. In front of you should be the draft schedule for the hearing examiner and the board hearing schedule. If you guys can review that in the next month. And when we come together again in December, if you guys could ratify that, we can get everything scheduled. Let me see what else I have here. We have a hearing examiner proceeding on November 19th that will begin at 9 a.m. And the board meeting for December will be on December 3rd, again, starting at 9 a.m. I know that we'll be ratifying this schedule, and we'll also have some briefing items for the bonding rule. I would like to put in another plug for that. If you guys will read and review it, if you have any questions, please reach out to the division. If you need a little buddy to read it with you, give me a call. We can set up a time and talk through it. If you focus on I believe it's R649-13, that's the kind of meat and bones of I don't know if that's actually a phrase, but that's where all of the main items are for the bonding rule. Meat and potatoes. Take bones out of the phrase. I'm really bad at little phrases like that. But
Have you gotten very many comments?
I've not received comments yet, but I do have a deadline for November 7th. Okay. The idea is that the division will receive the comments, we'll review them, and we'll be presenting them along with the rule in December. I know that some stakeholders would like to do presentations as well, so I don't know if we want to put a time limit on the briefing session specifically for bonding, but there will be some presentations on that.
Thank you.
Yeah, and I believe that's it. Keep this short and sweet so that we can jump into the board hearing, but if you guys have any questions, I'm happy to take a stab at answering them.
Anybody have questions for Natasha? Okay,
Amazing.
Thank you.
Thank you.
That's how we like to do these briefing sessions. We now have an opportunity for any public comment. If there's anyone in the audience who'd like to speak to the board, please come forward. Or online, if there's anyone online. Hearing none, seeing none, thank you, Natasha. And as our practice, we're going to move right into the dockets for this month. Docket number 1 is docket number 2024-007, cause number 199-05. In the matter of request for agency action of Perchetti Energy Holdings, LLC, for an order requiring an accounting payment of proceeds from ARB Energy Utah, LLC. We'll give you just a minute to get set up here.
Thank you, Madam Chair. And my computer's decided to update all of a sudden, so I may need to swap out laptops.
All right.
A couple minutes.
No problem.
Can you hear me?
Madam Chair, I think I'm finally ready.
Yes, we're ready.
Could we have a appearance of council, please? We'll start with Perchetti.
Yeah, Mitch Mayo of Lear & Lair PLLC on behalf of the, I guess in this matter, co-respondent or sur-respondent, Perchetti Energy Holdings LLC.
Thank you. And for ARB?
Yeah, good morning, everyone. Peter Donaldson, representing ARB Energy Utah LLC. With me is my partner, Tyler Cahoon, and our trusted associate, Ashley Del Balzo. And we thank you for your time and attention to this.
And division?
Yeah, Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Thank you. Before we get started on this issue, couple of items. I see there are 2 Perchetti matters on the docket today. And when we finish with this, we're going to move to the second one, which is number 10 on your list. We're going to do it out of order so we can do them both together. And then we understand here at the board that there was a motion filed very late yesterday afternoon. I guess the question for ARB is, what was the basis for that motion?
Well, it's in the motion itself. It's pretty short and sweet, but the basis is, I'm happy to address it. What I think actually makes the most sense, I do agree it makes sense to address these both together, both matters. And so I'm happy to kind of do that. The short...
Let me ask,
Yeah.
Perchetti, are you ready to respond to this motion today?
I think, yes, happy to respond to the board today. I think this is, it clearly wasn't intended for the board to be able to digest it. It's not a serious motion in that sense, and the fact that it's been sat on for 2 months and filed last minute. But I'm still prepared to address it because the board has exclusive and plenary authority over regulating oil and gas companies. So I'm happy to address if the board would like.
And why was this filed the day before the hearing?
So, again, we're preparing for the hearing today on an order to show cause in the first agency action between these parties, and that order was issued October 1, and this is part of our response. But if there is an issue with it being filed, it's not our intent that the respondent not be able to respond. We think the respondent should be able to respond. We think the division should be able to respond. And if and it makes sense to do that, but we should do it in an orderly fashion and not just, sort of willy-nilly or off the cuff deal with it. And there's no exigency time-wise here. But, if you want me to get into the substance of that motion, I can, but I do think it's a serious motion. I completely disagree that it's not a serious motion. The essence of it is that the very subject matter of that order to show cause is in front of the district court. And so it's not appropriate to have both this body and the district court addressing the same subject matter. We have a final decision from the board on that agency action. It's in front of the court. And
let me interrupt you.
Yeah.
Because this was filed so late, and we as a board and probably Perchetti have not had time to review it, I don't believe we want to hear that motion briefed today. I think we need to we need additional time to review this. And we would like to have some additional briefing done on the matter. And we're going to set up, and this is just me speaking from the chair, we would like the briefing done in 2 weeks from today so that we can understand the positions and rule on it.
And just to be clear, I'm assuming you don't mean that you need more from ARB on this. Just you want Perchetti and the division to
We need
respond.
Perchetti to respond.
Okay.
Yeah. My counsel is keeping me on legal track here. We are going to go ahead with the proposed hearing today. And so I believe we'll start with Perchetti. Could you present the case, please?
Yeah, well, I don't have a case necessarily to present, right? This, and just to remind everyone, I apologize. I didn't mean to say it was a silly motion. It's not a silly motion. It's a silly practice of holding things to the last minute and bombarding a court with them. It happens all the time in federal court and district court. It's commonplace. It's why I chose not to practice there, frankly. It's disrespectful of the court and of their time. It's disrespectful of the other parties, and it's intended to grind the process to a halt. But I didn't mean to say it's a baseless motion, right? That loads the issue. It might well be taken, and I appreciate the board's willingness or interest in hearing both sides before they make a ruling. That being said, just before I begin on kind of the case at hand, it's important to note that for those of us who've been involved in all these Perchetti hearings, ARB has filed something the last minute before every single hearing. It's always been substantive, and their response has always been, if we need more time to discuss it, that's totally fair. Let's just continue it to next month. There's nothing pressing. So I'd just like to throw that out there before we begin. But I also want to remind the board how this came about. A year ago, the order was entered, almost to the date, by this board, and it was formalized in written order on December 19th. So as of December 19th of last year, everyone knew this was over. This issue, as Mr. Donaldson correctly pointed out, has been fully resolved by the board. And this issue, we need to put a fine point on it. This issue is what amount of proceeds and penalties and interest is Perchetti entitled to from January 2020 through April 2024. That issue is not before the board. That issue cannot be heard by the board again because a district court has jurisdiction over that judgment at this point. However, the board has full jurisdiction, as it's well aware, to still regulate oil and gas operators and their activities. The board has absolute authority to come in, as they did in this instance, and ask the parties why they haven't complied with rules and orders the board made. And that's what's happening. And so we'll brief on that jurisdictional point, but that ties into why we're here. Because what the board did back 2 months ago, I believe it was at the August hearing, was the board made the decision, sua sponte, on its own, and it said, listen, I'm not happy with the relief that's been requested, so I'm not going to grant that. But I do want the division to bring this back before us so that we can determine whether or not we want to assess administrative penalties and potentially cease production at this facility. That was the board's instruction. The board has full authority to call parties in and ask them to account. For whatever reason, between the division and board, that process wasn't filed. Instead, what happened was the board and board counsel, the board, prepared and filed an order to show cause. Now, Mr. Donaldson, coming from a purely litigation world at district court, I can see why that caption might have caused him to think this is double jeopardy. We've got two different jurisdictions dealing with the same issue. However, had he read the actual order to show cause itself, nowhere in there does it say, come in and tell us why we shouldn't change our underlying order. Come in and tell us why we shouldn't increase the interest amount we awarded. The reason it doesn't say that is because the board knows that issue is not on the table. Regardless, the issue that is on the table is essentially, why haven't they done anything to comply with your order? It's a separate regulation. It's a separate statutory provision. It's a separate grant of authority for this board, and it's been exercised properly. And so what I read from the order to show cause, I think appropriately, was ARB was supposed to be here today ready to answer questions from the board, the division, and myself. And I'm happy to begin with those questions. But before I do, I'd like to note, in kind of the procedural cuteness that happened, ARB doesn't have a witness here today. ARB filed a motion to appear remotely and electronically for their witness, but only for the second matter. They chose not to do it for the first matter, and the reason was it undercut their sneaky motion, their later motion that they were planning on filing 4 hours before the board closed for the day, on the day before the hearing. And so I don't know how the board wants to proceed with this. I think at a threshold issue, we have to decide whether Ms. Meeks can be allowed to testify. If not, then ARB failed to meet yet another of the board's orders and didn't show up today with anyone to answer questions.
Can I raise a point of clarification?
Go ahead.
My understanding is we're going to deal with the other issue. Are we actually hearing the substance, even though there is a motion to dismiss the order to show cause? And Mr. Mayo's leading out, making a case when the order to show cause was directed at ARB. So I'm just confused at what we're doing at this point.
We're going to proceed to show substance in this matter.
It's my understanding, and correct me if I'm wrong, that the board would like to not waste its docket time here today, not waste its preparatory time, and essentially hear the matter, take it under consideration pending resolution of the jurisdictional question. Is that true?
Yes.
That's
To ARB, do you have any witnesses who will testify today that maybe need to be sworn in?
So let me make 2 points. First, we do object to going forward because we have made a motion to dismiss. Second, we don't have a witness available. I can answer the questions that I know the answer to, but
I have no interest in asking counsel questions.
I guess third, the problem here, the fundamental problem is that it really is improper to be going forward on this. There is no jurisdiction for this. There's nothing cute about that. It's just that the fact is this very issue that's the subject of the order to show cause is pending in court. We don't live in a country where we can do bills of attainder, where we decide that we want to make legislation against a particular party. What this board can do and does in a situation like this is adjudicate actions, which it's done. It adjudicated the action. It reduced it to a final decision. That decision is now in court.
So what is
so
pending?
hold on.
What is pending in court right now? What is pending?
The enforcement of this board's order.
The
I
collection.
thought a judgment already happened.
The collection
Yeah.
of the order.
Yeah,
Judgment
the
amount.
judgment itself and the enforcement of that judgment. That is a court process. And so now there's this this idea that, okay, let's have the board also jump into the ring and essentially do the same thing. Essentially try to enact measures that lead to the enforcement. Mr. Mayo said that
Excuse me,
yeah.
could you just explain to me why ARB has not complied with the board's order?
The very simple answer is it goes back to the reasons that it wasn't able to comply previously. Market conditions and the inability to resolve the larger dispute with Perchetti. I'd note that in the second matter that's on the agenda for today, it asked for an accounting, and under ARB's accounting, Perchetti owes well over $100,000, but there's been no payment for that. There's been no credit offered for that. Perchetti's made a request for in-kind payment, and the parties have started to work through that, but they haven't resolved anything. And maybe this is a way to deal with this, because I don't want to waste anybody's time. Under the new matter, if we proceeded in the ordinary course, a mediation would be required. And all I'm saying, the only reason I bring that up is because that could be beneficial to resolve the first issue as well.
We don't want to get into the second issue right now as part of this matter. Let me clarify that you do not have any witnesses who are going to testify today on your behalf.
No, we do not. We have a pending motion to dismiss because we don't believe the board has jurisdiction over enforcement of its final order that is in court at this point, and that's the mechanism for enforcement. And the order to show cause, all the rules cited there presuppose a pending action, and the action isn't pending. The decision was rendered, it's in the courts, and the board, it has to follow the rules and the law.
Back to you, Mr. Mayo. Do you have a response?
No, I think it's the height of irony for ARB to come in and admonish the board to follow the rules. But regardless, what Mr. Donaldson so aptly does, he's really skilled at this, and I don't know if anyone noticed, he said this exact issue is before the district court. He didn't tell us what exact issue he's talking about. And I wonder if he, and I can understand the mistake, I wonder if he understands that the board has independent ability to penalize operators, and that money goes to the division. It does not go to Perchetti. And so I think maybe there's a fundamental misunderstanding that ARB has that this is come in and figure out why we shouldn't penalize you, i.e. penalties in the accounting, when really what this is come in and tell us why we shouldn't penalize you for the division. And I think it's obviously two totally separate issues. One is royalties my client is entitled to that result from production. One is an administrative penalty levied that goes to the division. Its sole purpose is to ensure compliance. I don't know how those could be the same issue. The only reason they're the same issue is because they involve the same operator doing the same I'm not doing operations. And so that's the only overlap that I see, to be totally honest.
I just want to lodge a standing objection. If Mr. Mayo wants to proceed, he can proceed, and the board can proceed, and I have, I've prepared, some remarks as well.
Mr. Mayo, are you ready to proceed, or what is your position
I
at
am,
this
and
point?
I think, honestly, because ARB chose intentionally to show up without a witness, chose intentionally to file a motion that they're well within their rights to file, but chose to file it at a time that, frankly, they don't have good cause. They haven't tried to articulate good cause. This isn't a court of general jurisdiction. You are not bound by the rules of civil procedure whole cloth. You're not bound by the rules of evidence whole cloth. Your job is to faithfully and efficiently regulate oil and gas operations in the state of Utah for the benefit of all. And so, with that being said, because there are no witnesses prepared today, because yet again they did not comply with a board's order, a clear, unequivocal order, I think it's appropriate to move for a finding of willfulness, that their noncompliance was willful, that it is willful, that it's unabated, that there's no efforts to fix that, and to assess $10,000 penalty a day starting, in my assessment, December 19th of 2024. I don't think there's any reason to give them the benefit of the doubt of this year, but at the least, starting today. I think that's the appropriate move. I don't know what else besides the only other option I can think of, Madam Chair, is for me to just go through the questions and documents that I was planning on addressing with ARB's witness, but it will just be in silence. So I'm not sure, the other alternative besides they chose not to show up today, they chose not to satisfy the board's order or the board's questions. As state regulator, this is willful noncompliance, and it's time the board make that finding. That would be my position.
What was the tenor of the questions you were going to ask, ARB? Can you just give me kind of a summary?
We've talked to Ms. Meeks before. She was a witness in the October hearing of last year. Bright, articulate, knows ARB's finances pretty well, and so I was going to ask her probably the same questions the division and board were going to ask her, point blank. Why isn't ARB paying? There's a ton of revenue coming in. There's a ton of money going out. Why hasn't ARB paid this? If ARB can't, they said at the last hearing, they don't have his money anymore. They don't have it. They haven't suspended it. They said point blank in response to a question Mr. Moon asked, yes, we can pay within a year. They haven't made a single payment, haven't even tried. So I just... My hope was that she would give us direct answers to those and say, yes, we made some mistakes, or yes, as a company, we had a bad approach, but we're on the road to fixing it, or we didn't have the money because of COVID. Blame COVID. That's fine. Just come in and tell us something. Give us some justification for why you've kept the money. If she had given answers that weren't clear, I was hoping to confront her and have her explain kind of some of their personal stuff that ARB has that really confuses the issue pretty badly. And if the board would like me to proceed that way, I will. If the board is inclined to kind of, find for willfulness now, I think that's an equal approach. I just don't want to necessarily get into it if we're not going to get into it, if that makes sense.
ARB, do you have a response to that?
Yeah, the very first thing I would say is that the order to show cause does not require evidence or a witness on its face. And we're here to respond to the order to show cause. The motion that we filed responds to the order to show cause. We're here to challenge the board's jurisdiction on the order to show cause. It's not willful. We're not acting willfully. On its face, the order to show cause encompasses the exact same core issue as the pending core action. That is enforcement of the board's final decision in this agency action 199.5 in its December 19th, 2024 order. Our motion sets forth that the statutory framework of the Administrative Procedures Act dictates that once you have a final agency decision, and that's the subject of court enforcement, the agency doesn't have jurisdiction to enforce that. The order to show cause doesn't cite any authority that would allow the board to jump in with the court and simultaneously impose additional penalties or other incentives to enforce the order. That's what would be happening. The rules cited for the issuance of the order to show cause, they're all procedural rules, and they all presuppose that this action, 199.5, has not become final. But we know that it is final, and that's why it's in court. I'd also note that the amount determined to be owed for working interest was about $500,000. The board already tacked on another $325,000 in penalties and interest and accruing interest going forward. That concluded this agency action, the matter that we're talking about right now. At that point, the board had the opportunity to seek enforcement of the order in court, which it did not do, and that allowed the petitioner to seek enforcement of the order in court under Utah Code 63G4502.
And Madam Chair, not to
501,
interrupt, but we did read the motion, so I'm not sure we can read to us today for what it's worth.
Do I get to respond or not?
Well, if it's reading your motion, I don't think anyone needs it. That's
Do
what
I
I'm
get
trying
to
say.
respond or not? I would ask that I not be interrupted.
Please proceed for a moment here.
So petitioner did that. At that point, the board was divested of jurisdiction over enforcement. And so we don't believe it's appropriate for the board to simultaneously seek to enforce the order. Let's tease out what would happen if we went down this road.
Let me just ask you, is the court matter concluded? Is there a judgment?
There is a judgment. It's not concluded. The matter is still pending, and it's not concluded.
I wasn't involved, but my understanding is that
Is it my turn or is it Mr. Mayo's?
I think this is a board hearing where the board's concerns are what matter.
Let me see if he can clarify this for me.
Yeah, it's my understanding that essentially, after 8 months of pursuing ARB in the district court and getting no response, a default judgment was entered, and it was pursued until at the 11th hour, ARB appeared and said, hey, we've got some things that'll really help resolve this. So that's my understanding of where it's kind of in that gray area. Again, I'm not involved, and I could be mistaken. Mr. Donaldson can correct me if that's not the case. I'm sure he will. But what I'd like to point out is, unless the board disagrees with this statement, Mr. Donaldson is wrong. The board has no intention today of trying to enforce its earlier order in 199.05. The board will not, no matter how well I do today at this hearing, the board will not send a sheriff out to sell the property The board will not order foreclosure. The board will not seize assets to collect on the judgment. The board is not seeking to enforce the order. And Mr. Donaldson, despite his arguments, is just intentionally
Madam Chair,
or
I think this goes
unintentionally-
beyond answering the question. I've been interrupted. I had a presentation, and I mean, if we're just going to hear from Mr. Mayo, doesn't seem right.
Please, thank you for the clarification. Please go ahead, Mr. Donaldson.
Let's think about it this way. Let's tease out what would happen if we continue down this road, okay? Mr. Mayo's asking for administrative penalties. He's asking for things.
Objection. The board is asking for administrative penalties. Mr. Mayo is just a party who received the order to show cause.
I just heard him say you should find willfulness and enter administrative penalties going back to the date of the order. So
Can we go back to the caption for this, which says, an order requiring an accounting and payment of proceeds from ARB? And so, with the matter at hand, where are we here? Because I'm very confused what direction we're going. Can you help me understand that?
right. Order and accounting for payment, that is exactly what this board already determined. Again, already tacked on $325,000 extra interest per day. And again, what I'm hearing both from the board and from Mr. Mayo is this idea that administrative penalties can now be tacked on $10,000 a day. But let's tease that out. What would happen if that were to happen? Well, once that becomes a final order, I guess, because then it means that the final order by the board previously wasn't, and so now we're kind of adding to it, adding something else to it, then that becomes appealable in court. And if that's appealed in court, now you have two pending court cases over the same administrative agency matter. And so that's exactly the chaos and confusion that the Administrative Procedures Act was trying to avoid.
Mr. Donaldson, what is your position on the $10,000 a day fine that's been proposed here beginning December 19th?
It absolutely is not authorized. The board doesn't have jurisdiction to do that at this point. Essentially, it would amount to legislation against a particular party rather than an adjudication of a pending issue, because the issues before the board on the accounting and payment have already been determined, and the enforcement is in the courts. So again, if this board were to order that, it would be an error, a legal error. It would be appealable. There would be a second court action over that issue, while the first court action is still pending over enforcement of the final order.
Are you saying that the board has no authority to take action against ARB?
In this matter, 199.5, that's exactly correct.
Madam
The board
Chair,
does not.
I
Please let me,
apologize. I thought
please
you were
let me
done.
finish.
That's my
Please let me finish. No, it doesn't. And I understand that the board is frustrated that we keep coming back, and Mr. Mayo has, been very zealous in advocating for his client, but there is a process that needs to be followed here. There is a statute that needs to be followed here. There are rules that need to be followed here. And I don't think it's appropriate to find a willfulness. If ARB could have paid, it would have paid by now. And the pending, and the decision that the board already made on that is final. It stands. It's being enforced. The simple answer as to why ARB hasn't paid, or the respondent hasn't paid, is again similar to the answer as to why it didn't do so initially. It's a combination of market and business conditions, and the fact that there is a larger dispute between the parties they haven't been able to resolve. And
Mr. Donaldson, could I have Perchetti's response to whether or not the board has authority?
Yeah, I mean, I think Mr. Johnson kind of finally narrows down his true objection, and his true objection is the cause number that's on the top of this. And so I'd like to solve that problem by making a motion, which may be a little bit wonky, so bear with me, but a motion to convert this order to show cause to a notice for agency action for penalties assessment. I'm sure board secretary can assign a new docket and cause number if we take a 2-minute break. Parties are here. The pleading will say the same. I think Mr. Donaldson's concern is this cause has been decided, and that's a fair point. But that doesn't matter. You know, if I called a motion for summary judgment, a motion for judgment on the pleadings, but the entire thing was summary judgment, it would still be a summary judgment motion. The title doesn't matter. I think the point of this is, does the board have jurisdiction to come in and ask operators why they haven't complied with orders and statutes and rules? Well, of course it does. And not to mention, you know, I think in Mr. Donaldson's mind, ARB only became liable for violating the board's rules once the order in cause 19905 was entered. That's not true. The record is replete with evidence of ARB flouting rules of the board that have never been addressed in a board hearing. And so the board doesn't need to address or reference 19905 at all, other than as a citation in its notice for agency action. The board has emergency authority. The board has, the ability to move its rules, deadlines around for good cause. This is designed to be the efficient administration of regulation. And so I would suggest that if the concern is the caption says 19905, we simply convert this as a notice to a notice of agency action, have board counsel assign, or board chair, board secretary, assign a new docket and cause number, and we proceed as planned.
Mr. Donaldson, do you concur with that? Do you agree with that?
Absolutely not. This is the fundamental problem, is Mr. Mayo saying, hey, if you want to be a cowboy court and do whatever, you can do whatever. It's not just simply asking why ARB hasn't paid. He's asking for penalties. He's asking for measures to be taken that would go towards enforcement of the final order. That's what he's asking for. It's not appropriate. If that were to happen, again, you'd have an appealable issue to a court, and then you'd have two actions pending over the same agency action. We don't just, I mean, is there precedent for that? I mean, I'd be very interested in the division's position where, let's just change the caption and we'll just start a new agency action today.
I actually would be interested in the division's position as well.
That completely goes against the rules. We have to do things in an orderly fashion. I've indicated why ARB hasn't been able to pay. If ARB could, and if we could resolve the issues, we would. We haven't been able to. But that's that issue, again, the enforcement of the order in this case, this agency action has already been initiated in court. The agency action, the agency decision is final. Again, I think what makes the most sense, pending the new agency action as well, and again, under the accounting that we have, Perchetti owes ARB well over $100,000 on that he hasn't paid to ARB. We should mediate. We should take a timeout, deal with the motion if we need to deal with the motion, and mediate the case to see if we can get it resolved.
Could I get the division's perspective at this point? Do you have an?
Sure. Sure. I must say I'm a little confused. This was pretty clear, the order to show cause. There's 4 questions that were going to be proposed to ARB. We have them all. I don't think I need to read them. We all know what they were. ARB was asked here to answer some questions from the board, which, as the regulator of the state, the board is well in their right to ask ARB why they have not complied with an order. I have not heard, maybe they were in there. I have not heard answers to the 4 questions. I'm confused why the questions just have not been answered. The purpose of this hearing was my understanding, for the board to get answers. They want to know why their order has not been complied with. I don't think it's a difficult question. This does not involve enforcement of the order at all. It's purely from a regulatory standpoint. Quasi-judicial body wants to know why their orders have not been complied with. 40-6-11 is very clear. Statute, just like your WAPA is, so is 46-11. It says, the board, I'm paraphrasing a little bit, after an adjudicated proceeding conducted in accordance with Utah Administrative Procedures Act. Sorry, let me start again, because I muddled that up. If the board determines after an adjudicated proceeding that a person has violated this chapter or a permit, rule, or order made under this chapter, the board may impose an administrative penalty. We're here to find out if ARB has violated an order. That was my understanding, and I have not heard a clear explanation on whether they have or not. Once they answer those questions, then it's up to the board to decide where they go with this. I can't say they violated because I don't know what the background is. I'm with the board. I don't even know where this order is in currently, what the enforcement status is right now. But as to the ability of the board to ask ARB to answer some questions, they're within their right, and I don't understand why we're trying to dance around what's being asked here today.
And I'm happy to answer the questions.
Before you start there, let me just ask the board if they have any questions at this point. Let's maybe take care of some of those questions, Mr. Moon.
And my question is, just why have we been talking about all these things and not just answering those questions? So I'm looking forward to hearing the answers to the questions.
I'm happy to answer any questions.
Okay, and could we answer Mr. Haynes' question?
Yeah, go ahead. What's the question?
Board's questions.
I don't have a specific question. It's the
Yeah.
4 questions. Whether somebody wants to lead off with those questions from the board, however we want to propose those, I have no preconceptions on that.
Just for simplicity, Mr. Haynes, could you go ahead and pose
Sure, I'd
the
love
questions?
to. Okay, the first question. The board has asked ARB to answer as to why ARB has not paid the required proceeds and interest as outlined in the board's December 19th, 2024 order.
Can I jump in real quickly, not to delay things, but what it says is it asks ARB the company, to appear and testify under oath. So we don't have that today. I'm happy to have Mr. Donaldson give us his incredibly tactful answer on why they haven't complied and market conditions have prevented this operator, not any other operator in the state, but this operator from paying its proceeds of production. But without it being under oath, I frankly don't see the value in having them answer for what it's worth. And I think if Ms. Meeks, who is permitted to appear remotely in the following matter in a few minutes, if she's willing to answer questions under oath in this matter, then it makes sense to have ARB answer questions. Otherwise, I'm not sure it makes sense to have ARB's counsel. Otherwise, we're just arguing about the compliance rather than getting them to come in and explain to the regulator why they haven't complied.
Can we get her now?
That's not part of this case.
You can't.
For good cause, the board could allow her to appear remotely and testify in this case. Obviously, the fact that all of us stipulate to that would be good cause, but that's really the only option. They either show up with witnesses to testify under oath today, or they violated this order. And frankly, we can ignore the order to show cause altogether and just say, we're assessing administrative penalties because you didn't comply with our order today. I mean, we can pick an order or a rule and assess penalties based off that because they're not really following any of them.
I sort of feel like we're going around in circles here, saying and restating the same things. We need to get to the meat of this particular docket. And this is for an order requiring an accounting and payment of proceeds. and why our order hasn't been complied with. Can I have a simple answer to that question?
Why the order hasn't been complied with, why the payment hasn't been made.
Yes.
Market conditions, inability to pay, inability to reach a resolution. There has been a request for payment in kind, and the parties are working through that, but hasn't happened yet. And then again, the time period subsequent, Perchetti owes ARB over $100,000.
Objection.
And
That's the next matter. Irrelevant.
well, it's part of the answer to the question. And so ARB hasn't had the ability to pay due to the market.
Board, do you have questions?
Yes. Are you not making any money, or is production not producing any revenue for you? Can you be more specific when you say market conditions?
Yeah.
What is the totality of what activity you're doing in Utah relative to your oil and gas operations?
Yeah, there are revenues, but the expenses are exceeding the revenues. And so there hasn't been sufficient to make the payment.
How long has that trend continued, where expenses outweigh the revenues, and how are you able to continue operating under that formula?
I mean, it's not going to be sustainable over the long haul, but as the board knows, prices fluctuate, and the cost of overhead or the overhead fluctuates as well, and ARB is doing everything it can to secure funds that would allow ARB to meet its obligations, and that's the end goal here.
What is your estimated time frame for extending under this current conditions? I mean, are you at a point where you can say by January 1 we can no longer sustain operating under these conditions, and therefore we have to fold, or what?
No, just the opposite. Folding isn't contemplated. ARB's working again on transactions to get an infusion of capital to be able to meet its obligations and resolve this issue as well.
Do you have a time frame?
Imminent is what I've been told, but there's not a specific time frame because no deal has happened yet. If, again, depending on what happens with the price in the market, a change in the price could change everything. But it hasn't happened yet, and so we don't have a time frame, a timetable. In the meantime, interest is ticking on the award, and it is what it is, and it's going to be what it's going to be. That is on the board's decision. The statute that's been cited, yes, allows the board to impose penalties. That's what happened. That's what already happened. And when ARB is able to meet its obligations and pay, it's going to pay. And it's possible that would start through in-kind payment, and then cash payment.
Mr. Walker has a
Yeah.
question.
Yeah.
Okay. I would like to know if anybody has an objection to bringing on this witness that you have for the next issue. We swear her in because, as we all know, attorneys aren't witnesses. I don't want to listen to all of you guys. I want to hear from the witness. Do you have objections to bring that witness on?
So we filed that request to appear, and it actually had the wrong case caption number on it. It should have been for this case, because we wanted to be able to do that. Our client told us yesterday that she wasn't going to be able to appear, so I don't have a witness.
Isn't she going to appear in the next topic?
That's what I'm saying. That was an error on the case caption. It should have been for this case. We did it out of an abundance of caution so that she could appear if she were available. Then we were informed she was not going to be able to be available for that. And in addition,
we had
and
this
it- and-
docket out months ago, and you don't have a witness available to do this.
That's
Is
not
that,
exact-
Is that my understanding?
Yeah, that's not exactly correct.
That sounds to me like willfulness.
Oh, hold on, that's
No, don't tell me to hold on. It sounds to me a lot like willfulness. And you hold on.
okay. I apologize.
You understand?
Yeah,
Okay.
but it
So she is not available for what reason?
I don't know the reason, but what I would say is it hasn't been several months. It's been since October 1 that this order issued. Because again, we're still talking about the first agency action that concluded that's in court. Okay, so then because the other agency got dismissed, the division didn't do what the board had indicated that the division should do. Maybe there was some backroom discussion, and this was the solution is to issue this order to show cause, but it's just not appropriate. It's not an appropriate order to show cause.
Okay,
That's
so you're
why-
objecting to having this witness
That's
brought forward at this
absolutely at this point. Yes, we do object to that.
Okay, Mr. Mayo, do you have any objection?
I have no objection, but as
And
Barb
she's
made
not-
clear, they're not going to make her available, but I
okay.
think she should be compelled.
Okay,
She's not available. That was a couple of weeks ago. I guess
Mr. Haynes,
about
do you,
3 weeks.
just hold on.
Yeah.
Mr. Haynes, do you have any objection for this other witness being made available and presenting?
No objection, no.
Okay. So it's your decision not to have this witness available?
It's not my decision, but yes, ARB's decision, I guess. I mean, she's just not available. And frankly, there's no jurisdiction for her to be made to appear to testify in this matter.
Are we still giving questions?
Yes, go ahead. Mr. Church has a question.
Okay, we're talking about market conditions. I've heard you refer to that. The order that was initially given was October of 2024. And that order has not been complied with for 12 months because of market conditions. Are you saying that you're no longer able to operate in Utah because of market conditions?
So market conditions is kind of broad, I admit. It's not just market conditions, but it's also the condition of ARB's business. Yes, as far as expenses and revenues, ARB hasn't had sufficient funds to make the payment.
So why is there not another operator? Have you been objecting to another operator taking over these wells?
Yes.
You cannot operate, and yet you do not want another operator to operate.
I don't think it's correct that ARB can't operate. ARB is operating with respect to this particular obligation that it accumulated. ARB doesn't have the ability to pay it at this time.
So you're operating at a loss, basically.
As far as the overall operations, I'm not sure about that. What I know is that there's not enough cash to meet this obligation. There's been a discussion about in-kind payment. That's what that's what Perchetti has demanded. Perchetti's company has asked for that, and there's been discussion on that, and that could happen. And also a cash infusion could happen that would allow the obligation to be met.
It could, but it's not happened for a year.
It hasn't happened.
So are other operators and royalty owners in these properties being paid?
My understanding is yes. My understanding is that
The only suspended interest is Perchetti?
It's not suspended. They confirmed that at the October hearing because they don't have the money.
Well, you have to have the money because it belongs to somebody else.
so my understanding is that this is an unusual circumstance with Perchetti, in part because it is part of a larger dispute where Perchetti owes money to ARB and that hasn't been resolved, and where the amount that was owed has grown to an amount where ARB doesn't have the ability to make that payment. But the other, I'm not aware of other issues as far as other working interest holders.
But I think if you've singled out one operator, you have to give us some better explanation other than market conditions, because that should affect 100% of the well.
Well, it's a matter of, again, market conditions and the business, the condition of the business, ARB's business, just doesn't have the cash to make the payment and to meet that obligation. They're working on that. And again, there's been discussion about in-kind payment, but they haven't been able to meet that. Now, for right or wrong, the net amount owed, again, because of the market, has gone down because from the time period covered in the order to the present, it's approximately $150,000, somewhere in that neighborhood that Perchetti should pay to ARB. So the number has gone down as far as the net total amount, but his situation is unique, or I keep saying his, it's Mr. Perchetti's company, but Perchetti Energy Holdings situation is unique in that there are not other working interest owners that have that. And these dealings involve interests and ventures outside of Utah. And
Objection, not relevant.
well, I'm just saying that it is a unique situation. That's all I'm saying. And if ARB could have paid this long ago, it would have. It would have loved to pay the initial amount and not have any penalties or interest, but it couldn't. That initial amount was awarded along with severe penalties, almost double the amount, and then interest going forward. And that's where we're at today.
Mr. Mayo?
Yeah, I just wanted to briefly make sure I heard correctly the testimony, because Ms. Sierra asked questions and I think incredulously asked him again, hoping for a different answer. Is it ARB's position? I know it's not under oath, so we're not going to hold ARB to any of this, unfortunately, but is it ARB's position through council that ARB has been producing uneconomic wells for more than a year and a half and has no ability to pay revenues except with a cash infusion from a different source, not production?
No, my understanding is that it's this obligation that ARB, because it has grown to be so much, it's this obligation ARB hasn't been able to meet. But my understanding is other obligations are being met.
Had the witness been here, we would have had a lot of testimony today about obligations.
And I'd add to that, and the obligations to Perchetti from the time period subsequent to the period covered in the December order, those have been met. Not only have they been met, but if we actually did the accounting in the second case, we would see that Perchetti owes ARB for that period. So we're really talking about a discrete period of time where ARB was not able to make the payment, penalties got imposed, interest has been accruing, and ARB has not been able to take care of that historic payment obligation. And that is why Perchetti is seeking to enforce that obligation in court. And so it all goes back to that historically, because from the time of that order to the present, ARB has met all of its obligations to Perchetti, and my understanding that it's current with everybody else. So what we're talking about is a discrete amount owed from the past that ARB has not been able to catch up on yet.
Mr. Haynes, what's the division's position on the $10,000 a day fine beginning in December of 2024? Do you have an opinion on that?
Well, the opinion is that under statute, if you find that ARB has violated your order and this hearing has complied with the Administrative Procedures Act, you have the ability to assess it. I am still confused by everything that's being presented as to where that order is. Could you explain, has there been a judgment on trying to collect on that order?
Yes. Yes. My understanding is yes, there is a judgment, and the parties are seeking to, Perchetti seeking to enforce that judgment.
And what enforcement actions are being proposed? Can you divulge that?
The usual things that are imposed, and the same things that would be imposed if a penalty were levied in any case by this body.
They're set
the
for a
court-
sheriff. The
hold on.
assets are set for a sheriff sale currently. The sheriff sale is set for December 19th. That's the short answer, but now.
Okay, well, there you go. So either way, the court takes that up and enforces that. And so again, what would it add to, to say, hey, we're upset that you haven't paid this yet, so we're going to add this to it. You can't squeeze blood out of a stone, and ARB's doing what it can and is hoping to avoid that sheriff's sale. But it hasn't been able to yet.
Yeah,
Mr. Haynes?
Thank you for providing that, because I don't know why we didn't just lead with that. Why didn't we just start with the order is being enforced in the court? It's currently in the point where they're seeking a sheriff's sale. Because now I actually know what's going on. It took us an hour for a 15-second answer. I'm just confused why we're dancing around just answering the question.
Could I ask you one thing? And are there any other remedies available under 40-6-11 other than the fine?
Putting me on the spotlight, I don't have a definitive question for you.
I've
That's
got-
something maybe when you deliberate,
Yeah.
you can think about.
Okay.
Can you go back? Okay, so we got two things happening December 19th, 2024,
Can I
and now
bring-
something December 19th, 2025.
Okay.
What's this second thing? And I guess I should let Mr. Donaldson answer. What is the second thing in 2025 that we just talked about here?
So
Let Mr. Donaldson, please.
You mean the what's happening in the courts, or the?
No, you just talked about a sale of assets or
Oh,
auction
okay.
of assets. What's
So
going on there?
so again, what you have is, okay. This is what's happened. This board made its final decision. This board imposed the penalties. Everything that Mr. Haynes is saying that you can do, the court did that. That got reduced to a judgment, and that judgment is being enforced through the typical enforcement mechanisms that you use to collect a judgment. What Mr. Mayo referred to is that there's been a writ of execution for a sheriff's sale of ARB's assets to satisfy that judgment, satisfy that amount. And so that is currently what's happening. Now, ARB
And
has...
does that
ARB
happen to be on December 19th, or is this coincidence, or is this?
Well, Mr. Mayo said that the sheriff's sale is set for December 19th. ARB's objected to the writ of execution. There's going to be a hearing on it. Again, that's all being litigated in the court. But yeah, all of that is in front of the court. Mr. Haynes said that, it took us an hour to get to this. Respectfully, we didn't need to take that hour. It was enough to know, and should be enough to know, that enforcement of the order is pending in court. And so it shouldn't have been taken up in this last hour. And that's what our motion's about.
Mr. Mayo, go ahead, Mr. Church.
Mr. Donaldson, why are we having another property owner on docket next month claiming that ARB is not paying them?
I haven't seen anything about that yet.
Well, we are hearing that, and you are stating that you're meeting all your other obligations, and yet it's coming up on another docket item next month for us.
Well, for all I know, it could be like the new one that Mr. Mayo filed on behalf of Perchetti, in which case the working interest owner wants an accounting, but the accounting is going to show that that ARB's owed by that working interest owner. That's the situation with his latest request for agency action, and I just don't know anything about the other one. It may well be that working interest owner also owes money to ARB, or that some amount is owed by ARB to that owner, and that'll be resolved in the ordinary course. As far as I know, ARB is has been able to resolve or pay with respect to all of the working interest owners other than Perchetti.
Mr. Mayo.
Yeah, Madam Chair, I just wanted to address quickly a question. You put Mr. Haynes on the spot a little bit about other mechanisms in the penalty statute passed by the legislature that the board can take. And I just wanted to clarify, because I was kind of anticipating this line of questioning at some point. So I have pulled up on the screen, but I am not plugged in, excerpts from 40-611 for us all to look at. And particularly at the bottom, 4I, if a violation of, and this is of any rule or order of the board, remains unabated and the maximum penalty amount has accrued, the division may request an emergency order from the board requiring the operator to suspend operations of the well or facility that's in violation. Operations may only resume upon abatement of the violation. Now, to me, that seems, at first glance, really punitive, right? Plugging someone's operations, shutting them in, damages them. But as Mr. Donaldson has said really convincingly, ARB is losing money every month. We'd be doing them a favor by ceasing operations. And I think it's honestly the smart thing to do. When we turn to section, it also includes here that, and if you look at 5, if ordered to do so by the board, the director of the division may order the immediate closure or shutdown of any well that is operating in violation of this chapter. If the closure or shutdown will not cause waste, again, losing money, there's no waste here to be had, or is necessary because of an immediate threat to public health, safety, or welfare. I can't think of any more imminent threat to public welfare than operators in the state of Utah who don't respect the Board of Oil, Gas, and Mining. So my suggestion is there are other mechanisms the board can take, and if it chooses to assess penalties starting in December of last year, the maximum amount has run. It is willful, it is unabated, and I think the board should cease production until the violation is remedied.
So are you advocating for
Absolutely.
cessation of operations?
Absolutely.
Okay.
Yeah.
Division, do you have a position on ceasing operations?
Yeah, as I represent my client, the Division of Oil and Gas, I would say I have a slightly different interpretation on the codes that Mr. Mayor just presented. First of all, which allows the division to request an emergency order to suspend operations if a violation continues. That is based on our violation rules, which it talks about in 4E that we've been set out. And so when the way I read that, when we have violations which are primarily held to safety standards and health, safety, and environment, when we cannot get compliance with those, then we seek suspension of operations until compliance is made because there's a hazard there.
Are there any violations pending on the ARB properties?
There are not to my knowledge. Additionally, 5 that was brought up talks about the board's ability to close or shut down a well. There are caveats put on there as long as it will not cause waste, which that's another discussion. Will waste happen if closure happens, or if it's immediate health, safety, and welfare issue. So there's 2 caveats that would have to be explored. I will also point the board to 40-6-13. I don't have a copy of it up there.
I don't either, sorry.
But by statute, there are restrictions on the board's ability to shut in operations past the ability for an operator to cover costs. So that is a boundary put on that ability to shut down operations.
Okay.
And if I could briefly just talk at that for a second about the, if we go back to 4E, as Mr. Haynes pointed out, he has a slightly different interpretation, but I'm going to walk you through the way I read it because I think his is absolutely reasonable. I also think mine is fairly reasonable as well. And it says, before initiation of an adjudicative proceeding on penalties or assessing an administrative penalty, and except for circumstances provided in subsection 4B. The division shall provide a notice of violation, blah, blah, blah. However, if you look at 4B, 4B is if the board determines that the violation is willful, the board doesn't need to go through the procedural nonsense. If someone is intentionally violating, willfully violating your rules, you don't need to protect their right to process. That's what those two say to me in conjunction. There is a standard process where you submit, there is a violation out there, and I would argue that, you know, different from the division, I think the non-payment of proceeds of production is when it's for 5-6 years through board enforcement actions and beyond, and now there's no money and we're running uneconomic wells, I think that moves it to the level of that is a clear violation. So that's just the read we have that's slightly different, references the willfulness determination.
Can I move to
May I
ARB to respond?
Yeah, thank you, Madam Chair. I think a point that is being missed is that an inability to pay a historically owed amount is not willfulness. It's just not. And I think what we're hearing is characterizations of what is supposedly happening, but we have to deal with the issue before us. The issue before us is this agency action, 199.5, the order that was made in that agency action, and what the law tells us as to how that order is to be enforced. And ARB has not had the ability to pay. We have appeared, we've made a substantive motion over jurisdiction that hasn't been resolved yet, and none of that's willful. And so I don't think that applies, and I don't think it is appropriate to say that the inability to pay a historically owed amount or an amount that's been ordered that is being enforced in court is willful. It's not a situation where we have the funds, but we are simply refusing to pay with no basis or reason whatsoever. It's not that situation, and it's not a situation where other parties are being impacted, because it is a discrete amount that's owed historically, not ongoing. We're not only current from the time of the December order, but again, the net amount is owed to ARB by Perchetti, again approaching $150,000. So we can't just ignore that. And so there isn't, I understand I'm sensing the frustration. I understand it. And perhaps I'd be making the same arguments if I were in Mr. Mayo's shoes, but the reality is there is no willfulness here, and there's no reason to short circuit the statute and the procedures that are provided for, and ARB's substantive rights in that regard.
I'd like to ask a question about what's the...
And again, I am happy to answer any questions.
Mr. Donaldson, do you believe the trial court has the jurisdiction to shut down operations?
I believe that it does, fundamentally, yes, because it does have equitable jurisdiction. There was a separate action, the board will recall, that was brought to, again, part of the same collection efforts, essentially, but a separate action that was brought to try to remove ARB as an operator, and it was determined that the board doesn't have jurisdiction over that, and that issue also is pending in court. And so, yes, I do believe that the district court has that jurisdiction.
Thank you. Mr. Walker has a question.
Yes, we've heard mention of this 150,000 several times. Have you provided the statements and the details to Perchetti on what that 150,000 is, and can you explain that to what that 150,000 is composed of to the board?
So my understanding, that's really the second matter, the separate matter, and I personally have not provided any information in that regard. That matter just barely was initiated. It's on the agenda for today. And again, we would be fine in the ordinary course with an accounting in that matter. And again, the required mediation in that matter, which I think would go a long way towards getting the global issue between these parties resolved. Because right now what you have is a historic amount owed that ARB has not had the ability to pay yet, and then a new request for agency action to cover the time period from then until now, in which ARB's accounting is that Perchetti owes money. All the accounting information with respect to the present agency action was provided, was considered. The board looked at what it wanted to look at and then made its decision, including the decision to impose penalties, significant penalties, almost double the amount owed in that final agency decision that is now being enforced in court. And so, you know, that accounting information was provided. We've barely started. The new agency action request was filed, ARB's responded, ARB's objected, and in the ordinary course, if it were to follow, we would have a mediation. Again, I think we need to do that. We need to get in front of a competent mediator to see if we can resolve this.
Okay, but can you give me a general idea what this 150,000? How's a royalty owner owe the operator?
Well,
150,000?
Perchetti, again, part of the larger dispute between these parties is Perchetti has consistently and to this day has refused to sign a joint operating agreement. And what happens under those agreements is there are mutual obligations, reciprocal obligations. Perchetti is supposed to pay for overhead and expenses. He has not done that. He is not doing that. And that's my understanding of why, on the net basis, Perchetti owes ARB for the time period from that's not covered by the December order to the present.
I guess I am, hang on, Ms. Sierra.
To that response, didn't we already conclude that other existing agreements applied to Mr. Perchetti, and therefore there was no need to have him sign a joint operations agreement? And also, the follow-up to that is, why can't you keep talking about he owes us, why can't you just deduct that amount and still have to pay him whatever else you have to do? And you keep bringing up he owes, just deduct it from whatever the amount that is owed to him and just go from there. Is there an issue with that?
I understand I think I understand your question. I guess I'll answer the second question first, which is, even with the deduction, ARB just hasn't had sufficient cash to make that payment of that historic amount that's owed. I apologize. Remind me the first question.
The joint operating agreement?
I don't think the board actually reached a determination that, you know, Perchetti is deemed to have signed joint operating agreements. What I understood happened is that the board used existing joint operating agreements to determine the amount that, excuse me, that ARB owed. But I don't think it was determined that he actually, you know, is deemed to have signed a joint operating agreement. But that was used as the metric to determine what ARB owed.
Yeah, I don't think we said that he signed, but that existing joint operating agreements would apply.
Right. Yeah, I that's my understanding as well, that the board looked at the existing joint operating agreements and essentially used those as the metric to to what applies. But again, because he hasn't actually obligated himself, he hasn't been paying since that time. And again, to your point, I think Perchetti's position is, well, I don't have to pay because they owe me on a net basis.
what's-
They owe me.
What's frustrating is if they would have just stopped operating a year ago, if Perchetti's a 25% owner and ARB claims that they owe that Perchetti owes him $150,000, that means they've got a net $600,000 operating loss. If he'd just stopped operating a year ago, they got this $600,000 from somewhere that they lost. That could have been paid to Perchetti. Why would you continue to operate at a loss? I don't understand.
And I think the answer to that is overall, again, this is a unique situation, and it's not that operations from then until now and going forward are at a loss. It's simply that there's not enough left over to take care of this historic payment obligation.
Mr. Mayo.
Yeah, a couple points of clarification. The board didn't make a determination that the JOAs apply. ARB's president and general counsel testified multiple times, as did Mr. Cahoon, that in the August hearing, these 30 JOAs apply, and we swear the balance owing is $490,000. And then at the October hearing, ARB's president and general counsel and Mr. Cahoon both said, we swear it's these 53 JOAs that apply, and the balance owing is $506,000. So to be clear, there isn't a JOA finding, but yes, there's the ability to apply the same JOAs that are the basis for the judgment. You know, the truth of the matter is, why operate at a loss? I think that begs a lot of really interesting questions. They're operating at a loss and looking to secure outside funding to pay that. That smacks of Ponzi scheme to me, right? That is the definition of a Ponzi scheme, paying off early investors by securing future investments. Perchetti invested in production. If he can't receive his payments out of production, the production should cease. Not wait until Mr. Servant can find some magic money pot and then use that to pay off his earlier investors. Some agency has to be the one to say, we smell a rat, and I think, unfortunately, it's this agency.
We've covered sort of from A to Z this morning. And in the end, I guess I am confused on exactly what Perchetti and ARB expect from the board today. Could you clarify that succinctly for me? Mr. Mayo, would you go first, and then we'll have Mr. Donaldson?
I'm happy to. You know, I think what we want is nothing, right? We didn't file this. We didn't ask for this. We're responding. What we want is the Board of Oil, Gas, and Mining to be respected, to be responded to, and for Utah operators to treat Utah and its regulating agencies like they, pardon my language, give a shit. I think the truth of the matter is, what we want out of this is we want everyone to be here today ready to give testimony under oath to help answer questions, so we all don't have to prepare and come to these hearings every month and deal with the latest objection. What we want substantively out of this hearing, or what we think the board should come back and decide, is that ARB had no reasonable basis not to make a witness available to testify under oath. That alone is a willfulness determination, and I think at the least the board should say $10,000 administrative penalties starting today for the next 21 days, because they won't be able to make those payments either. And to be clear, in order to come clean, to clear the penalty issue and stop production being shut in, they have to not only pay the penalties assessed to the division that I'm hoping the board will enter today, but they also have to cure the violation. They have to correct the problems. So my suggestion to the board would be to determine that because ARB chose not to show up with witnesses to testify under oath, that is a direct and clear violation of the board's order to show cause, regardless of which caption it has on it. It violates the board's rules, and that is a willful violation, because the argument that ARB decided 3 days ago she needed to appear remotely, but decided today with no explanation she can appear, is garbage. I
Thank
think
you.
that's willfulness.
Mr. Donaldson, do you have a summary?
Yes. I guess on the highest level, ARB wants to be able to resolve this issue with Perchetti. Specifically today, we would ask that any substantive decision be deferred until our motion to dismiss is fully briefed and decided. We don't see any need to rush anything. Again, part of that dovetails with the substantive argument in that motion, which is this is all pending before the court. As far as the new matter, again, we're fine with the accounting. We would appreciate, and again, we think it would be helpful to have a mediation ordered by the board in that new matter. We understand and sense the board's frustration that we're here again and that these issues haven't been resolved, that Perchetti has not been paid. We think getting into mediation would go a long way towards making progress in resolving that. Again, the inability to pay an amount that's owed from the past is not willfulness. Filing a legitimate motion to dismiss for lack of jurisdiction is not willfulness. ARB has not acted willfully, and if there was a, and the process hasn't been followed to initiate the kind of penalties that are being talked about, we have to follow the procedures and laws. All of us as citizens rely on that due process, and not just having administrative bodies or courts or anyone else acting out of passion or being upset with a party that doesn't have the ability to make payment. And so we would ask that our motion to dismiss be briefed and heard and decided, and before any substantive decisions made. Between now and the next hearing, we may well be in a different position, and that's ARB's hope is that we are able to secure funding to take care of this historic obligation to resolve the issues with Perchetti. And if Perchetti's really interested in that, that's what Perchetti should be asking for as well, rather than just asking that extremely disproportionate penalties be issued in order to enforce a payment obligation that's already been determined to be existing by this board, and that's already being enforced in the district court. So we would ask that in that second matter, it be set in the ordinary course, that a mediation be ordered.
Let's not go into the second part.
Well, I mean, it ties together, but that is what we're asking.
Division, do you have any final thoughts?
Yeah, I'll just weigh in really quick. Unfortunately, like everybody else, I haven't had a chance to closely review the motion that was filed. So I'm hesitant to opine on any of the legal arguments made in there. As for today's resolution or action by the board, I'd just point out what this really comes down to is the board's authority to act. And if the board feels like there has been a violation of an order, they have that authority to act. The question is violation, and that's up to you to decide. We've heard that why compliance hasn't happened, partially, not really. But that's what it comes to. If you find there's a violation, you can act. If not, it's up to you how you proceed. But until that motion's being fully briefed, I'd be hesitant to weigh in on the other argument. Thank you.
Thank you. Board, do you have any questions?
One quick question. Is ARB up to date with all of its payments, royalty, administrative costs to the division for the wells that are in operation?
As far as we know, yes. Mr. Haynes may have more information on that, but as far as we know, yes.
So there,
Again, this is an outlier.
so there's no violation
Sorry, could you up to date on what exactly?
on payments that the company normally has to pay to the state, royalties, administrative costs, et cetera, permits?
I'm unaware on payments to the state where we're at on that. The only issue the division is aware of is the RAA that's being filed in relation to non-production payments by one of the working interest owners that the division is currently in negotiation investigation for.
Is production being reported monthly by ARB on all these wells?
As far as I know.
Board, do you have any other questions? Okay.
Can I just add one caveat? If the board does decide to go to a full briefing on the jurisdictional issue, I would suggest that we make this a tight schedule. We can have our responsive briefing to you by the end of the day, Friday.
Okay.
I don't think there's any reason to prolong this 6 weeks to the December hearing. So that would just be my thought.
Thank you. I think the board probably needs to deliberate on this a few minutes, so we're going to go off record. Come back in about,
Whenever we get here.
yeah, hopefully 15 or 20 minutes, but it's negotiable. We're off record.
1.
We are back on the record, and I'd like to, this is what the board has concluded. We would like to see additional briefing from Mr. Mayo by this Friday at 5 p.m. If the division would like to respond, please, also Mr. Haynes, you're welcome to do that. Then we would have from both Perchetti and ARB, we'd like draft proposed orders for your preferred outcome for the motion to dismiss. And once we get that, the board will issue its written order regarding the outcome of the order to show cause.
Just to clarify, I intend, based on this announcement, to put a proposed order attached to my response,
Okay.
which will be filed on Friday. Can we also set ARB the same deadline of Friday to
Yes.
provide their stipulated or their draft order?
Yes, we'd like to move this along. So yes, if you could all file your documents by 5 p.m. Friday,
Okay. Thank you so much.
it would be appreciated.
May I ask, Madam Chair, ordinarily on a motion, you have the ability to reply to the motion. We'd like to do a brief reply, say the middle of the following week, like by Wednesday. I'm going to actually be out of town and out of pocket with my family on Thursday and Friday, so I'd like to do the reply that next week with our version of the proposed order.
Madam Chair,
We could give you a couple of extra days if you could file it by Tuesday of next week. We want to continue to move this matter along.
Yeah.
And I think that's the extent of the board's decisions, but the board may have comments. So anyone who'd like to make a comment, Mr. Church?
Yes, Madam Chair. Mr. Donaldson, I just wanted to let you know that I felt it was very inappropriate to have a last-minute filing of this motion. And frankly, I am not really happy with the board's consideration of hearing this motion and your filings on it. I just felt it was out of line, and I frankly didn't see the substantive of it either. Just to let you know.
Or
Thank you.
And I also want to, before you get into that, and I think we're going to move right on.
Yeah.
I want to admonish ARB and council for what I consider willful violation of the board's orders and requests that we made as far back as August 27th and October 22nd as formal parts of our hearing.
Board members, does anyone else have a comment? Seeing none, that concludes this matter, and we are going to move on to item 10, which is also the second Perchetti matter.
So the board is taking that matter under consideration pending additional briefing, and will issue an order.
Yes.
Thank you.
Are you ready to proceed on the next docket item?
I am.
All right.
I think all of us appreciate the time and attention the board gave to this. I know these are complicated.
Yeah.
Mitch Mayo, I guess to make the record clear, Mitch Mayo.
Let me read the docket into the record.
Thank you.
Thank you. This is docket number 2025-054, cause number 199-12. In the matter of the request for agency action of Perchetti Energy Holdings, LLC for an order 1, declaring that administrative remedies have been exhausted as an additional accounting would be fruitless, and in the alternative 2, requiring an accounting and payment of proceeds from ARB Energy Utah, LLC for production from 125 wells in Grand County, Utah. Thank you. Appearance of counsel, Mr. Mayo.
Thank you, Madam Chair. Mitch Mayo of Lear & Lear, PLLC, on behalf of the petitioner, Perchetti Energy Holdings.
Thank you. ARB?
Mr. Donaldson and Mr. Cahoon and Ms. DeBalzo for the respondent.
Will Ms. DeValzo be testifying?
Oh, no, none of us are going to be testifying.
Okay.
My understanding is the issue is determination of whether the request that administrative remedies be deemed exhausted is to be granted or not,
Okay.
or whether it's going to be set down in the ordinary course.
Thank you. Division.
Yeah, Assistant Attorney General Andrew Haynes on behalf of the Division of Oil and Gas and Mining.
Thank you. Back to you, Mr. Mayo.
Thank you, Madam Chair. You know, I think we have some rare agreement. I think Mr. Donaldson and I are of the same mind here. The point of this hearing is, and the thought behind this hearing was, the board will be hearing this other matter first, and by the time it's over, it probably will have a good idea as to whether it thinks continued accounting hearings involving ARB and Perchetti are a good use of the board's time, are an effective way to accomplish the goals set out in the statutes, or whether we believe that Perchetti has done his effort and essentially exhausted administrative remedies required so that he can then pursue the non-payment of royalties, the continual non-payment of royalties in a district court instead. That's what we're here to do. Before we do that, though, before we just kind of jump into argument about whether it's futile, because I'm firmly, and I'm going to be honest out front, I don't think there's anything this board can do to make ARB do what you want. I think the truth of the matter is you're going to have to stop production, take their ability away at some point. So I think it's clearly futile for us to keep coming back and saying, will you please try another way? Give them a little more leeway and try one more time to get them to pay us. I think it's futile. I think the board can feel that. But before we, to kind of bolster that point, I think one of the underlying questions here, and bless you, one of the issues to deal with is some statements that were made in the prior hearing. And, Mr. Donaldson said, I'm not here to testify, I'm not under oath, but I'm answering a bunch of factual questions for ARB on the record. And one of the things he said repeatedly echoes something that ARB's president said in the October hearing last year, and that's that ARB doesn't have the money. And so, Mr. Moon asked a question, and I said, you're asking the right questions. It begs the question, where did that money go? And I think there's only one clear answer, right? And I think I've been dancing around it out of politeness. The truth is someone stole it. They received money. They have used it for other purposes, not for the purpose it's intended, and they no longer have it. And I don't know any other way to put a point on it than that. And what I'd hope is if the board, at the beginning of the last hearing, I asked, I said, well, I'm disappointed there's not a witness here today. I think the board should make one of two decisions. It should say they've willfully violated our order by not bringing someone here today, or they should say, go ahead and ask your questions as if the witness were here so we can lay that factual record on there. And we didn't do either of those things. And so if I think there's some information that I have that the board is going to find incredibly compelling, but because of ARB's unwillingness to participate meaningfully in the process by providing testimony and answering questions, the easiest thing an operator can do, the record is a little devoid. And so if it's at all possible to kind of establish why there is no point to continuing having these hearings, they are correct. They have no money. So I think we need to ask them, and I think Mr. Donaldson, who made that statement today, can probably be asked the questions about where the money went, and I can walk him through them. I don't expect he'll have much firsthand knowledge of those things, and I don't expect him to. But I think the board might be really curious to hear some of the information that we have to present that has been secured through subpoenas and court orders in various courts around the country. So I guess I would move to allow a little latitude to question ARB's only attending witness, which is counsel. Not a fact witness, but willing to answer questions on the record.
Please proceed.
Thank you. Mr. Donaldson, I know this is a strange situation we're in, but I'm going to ask you a couple questions since you testified in the prior hearing on behalf of your client who was unable to attend for some reason. Just to be clear at the outset, ARB doesn't have any jurisdictional objections to us proceeding in this cause. Is that right? And I'd hate to remind you you're a witness at the outset, but we'll try and do this as witness attorney rather than attorney's argument.
Well, I don't think that's appropriate. I don't think that's correct. This was not set for an evidentiary hearing. I'm not supposed to be a witness anyway. I mean, I'll answer your question.
I'd like to
That-
remind the
that-
board that ARB chose to provide and ask the board to exercise its authority at the last minute, again, to allow them to provide a witness to be here today and testify under oath in this cause. They chose then to change their mind, and Mr. Donaldson took the position in the earlier hearing that he can satisfy the board's concerns in the first hearing that no one showed up by answering questions, but in this hearing, he's totally unprepared to answer the questions. And I think if that's the case, I would prefer for the board to just say, we don't need to hear Mr. Donaldson's answers, but we would like to understand the background. If you can proffer the evidence that you think you would adduce today, I think that's the appropriate response, and we can keep the hearing tight.
Again, this is a purely legal issue of whether to proceed, and I think it can be resolved on, the face of the pleading and the objection and response. But to answer, I'll answer your question anyway because it is kind of legal, which is
I've withdrawn the question.
okay.
Madam Chair?
Mr. Mayo, would you go ahead and proffer your information?
I'm happy to. I'd anticipated, based on the filing, that Ms. Meeks, ARB's controller, who testified as their controller last October, a controller, I didn't know exactly what a controller was, but it's essentially the top financial person at a company. They make sure that the finances are accurate and that they do accurate financial reporting. And so clearly the main question here is, where is the money? They didn't have it last year. They said they would be able to get it and pay it this year. Clearly they have been unable. And so I'd hoped and planned to be able to address some questions with Ms. Meeks, who's not here. Those questions revolve around some really concerning bank accounts, bank records in ARB's name that have been subpoenaed and secured from JP Morgan Chase and from Frost Bank. And I've got excerpts of those exhibits here, but I'd like to give the board a little flavor as to where we believe the testimony would have shown the money has gone. And I think the reason that it's relevant to this hearing, to get ahead of Mr. Donaldson's certain objection, is it is futile to continue to come back to this board and ask for money when the money is being misused. And so at first, I'd just like
And
to
I
jump
just
in.
need to interpose an objection here to any presentation of evidence today. There was absolutely zero notice of any evidentiary component today in this hearing. I've already explained that we misidentified the caption in seeking to make Ms. Meeks available. It was for the other case, and she wasn't able to do that. We proceeded. And what I'm hearing too is that we're not going to be talking about the new request for agency action, but again, more of the prior agency action and issues related to that. So that's wholly inappropriate. There's no basis for evidence to be considered or taken today, and we would be completely ambushed because we haven't received a shred of evidence having to do with this action. So it's a violation of due process. It's a violation of the rules. It's a violation of the Administrative Procedures Act. We can't proceed that way. Again, we can't be a cowboy court in this fashion. He's made his statement in his request for agency action. We objected, have a response, and I think the board can hear argument based on that.
I'm going to overrule that. I think because this is a financial situation, testimony and evidence should have been anticipated. Please proceed.
Thank you, Madam Chair. I appreciate that. I'm not going to belabor it because there's no point. There's no witness. There's no opposing party. But I am going to give you enough so that you don't have to just take my word for it. The truth of the matter is, and if I can, and I don't know why, but it's not. I'm not showing up on the screens. I think I'm plugged in and ready to go. If technical can help me get up on the screen. Yep. Did I kick it loose at some point?
Let me just double check. It's fundamental.
I can begin.
And I just want to make sure it's clear that any evidence that hasn't been provided to us in advance to be presented here would be an absolute violation of the rules and due process, and I'm going to object to it. It's completely out of bounds and improper. No matter how impassioned everyone feels about these issues, this is a nation of laws, this is a state of laws, and we need to follow the law.
Madam Chair, you know, the objection is heard and lodged. I'm aware of their concerns with due process, and frankly, I can sympathize. Right, I've had to participate in 3 or 4 hearings versus ARB where I was underprepared because they presented things at the last minute in a complicated format.
We
So I
sent
can
everything in
understand-
advance, Mitch, and
I
you
can
know that.
understand the
We sent
concern.
everything in advance. You haven't sent us a shred of anything for this matter.
Okay, can we
Okay.
get you guys to quit interrupting each other?
Yeah.
It's, to me, I'm gonna end up admonishing both of you guys, so let's stop that.
That's fine if it goes
Let's
both
be
ways.
adults. Thank you.
Well, we're having trouble getting it up on the screen, but I can just talk through what the presentation would have looked like or the questions. And there is multiple litigation going on. As ARB has said and repeatedly, there are other business disputes between the parties that are being resolved by other tribunals across the country, and that's fair. As part of that legal process, Perchetti has subpoenaed bank records for ARB and has been provided those bank records by JP Morgan Chase and Frost Bank, 2 of the banks that we know of, or that Perchetti knows of, I should say, that ARB has accounts with. I'm not a finance expert. I'm not an accountant. I'm not a forensic accountant. So that's my preface. But I don't think it takes a forensic accountant to understand what's going on here. To be clear, there are declarations from both JP Morgan Chase and from Frost Bank identifying what records they provided and why, and it was a response to a subpoena. So they're fully authenticated. But even if we didn't want to consider evidence, I could make argument that was unfounded because this board is not bound by the rules of evidence. Your job is to find out the information. These are our bank accounts, and any idea that they are prejudiced by looking at their own bank accounts is a tough pill to swallow. But if you go into the records, I basically, when you look through their bank statements, what you find is during the operative time, right? This accounting that happened prior and the accounting that we're facing now occurred between the time Perchetti purchased his interest in January of 2020 and the first cause, 199.05, which is not at issue right now. That went through April of 2024. This cause that is at issue, 199-12, is asking for an accounting from May of 2024 through the present, but is really saying, listen, I don't think the board should do this anymore. So the bank records that we looked at were from that relevant time period. And as Mr. Donaldson said repeatedly just a few minutes ago in the prior hearing, we don't have the money. And the reason is market conditions. The reason is market conditions. Okay, that's fair. If you look at these bank records, and I'm happy to walk the board through if and when the screen comes up and if and when the board would like it, but if you look at the bank records, you see a couple things that stand out really clear. One, ARB moved $8.5 million out of its accounts into a brokerage account over a 2-year period during this time period, essentially investing its proceeds of production or giving them the benefit of a doubt, commingling proceeds of production with personal financial stuff.
And I need to interpose an objection here because Mr. Mayo is purporting to offer evidence. He has no foundation. He just said, you are bound, we are bound by the rules of evidence. Under the rules of evidence, there is no evidentiary basis for him to testify or introduce records or present any kind of evidence without a witness. Mr. White knows this is the case. And so not only is it a due process problem that we haven't been provided any notice of any of this purported information, but now you're going to have Mr. Mayo just telling you what he thinks it means, and he has no foundation, he has no personal knowledge, he has no ability to testify, and he's not under oath. It's wholly improper to get into these issues of evidence. Again,
Mr.
we can't
Donaldson,
just shoot from the
I'm going
hip.
to overrule this motion. We'd like to hear the information.
Thank you. To give the board a little comfort, it happens all the time in district court as well that you proffer evidence. Were my witness here
Only
today?
when a witness is there, Mitch. You know that.
If my witness were here today, they would testify as such. It's happened numerous times
But
in
they're
cases
not.
I've been involved in. So the proffer of evidence is perfectly appropriate for the board. You give it whatever evidentiary weight you see fit. And I will short circuit this. In a period of 23 months, between February of 2023, 10 months before the request was brought, and January of 2025, 1 month after the order was entered, so during the time frame, ARB transferred $8.5 million to Pershing LLC, a brokerage firm that does margin lending. That's my proffer of evidence. $400,000 per month invested in a brokerage firm out of ARB's accounts, but they don't have Perchetti's $400,000 in proceeds. The second piece of evidence that you can see really clearly in there, and I think is really almost beyond the point of objections because it's so silly, there are, and I need to look at this because I have a hard time remembering that it's true. When you look at the bank records, there are $500,000 in transfers from ARB's accounts. These are ARB Energy Utah owned accounts. From ARB's accounts to ARB's CEO's ex-wife, and they are labeled child support, alimony, divorce settlement. Between October 2020 and January of 2025,
Same
52
objection on
months.
that and all of this. I just want it to be clear in the record.
It's clear.
I want it
You
to be clear in the
object.
record that I object to the introduction, the purported introduction of evidence. It's not even evidence. The rules very clearly say we get to cross-examine. There's no one here to cross-examine. This is completely out of bounds. I just need it to be clear.
There was
You
no
can
one here.
overrule it if that's your decision, but it's not proper for Mr. Mayo to be proffering evidence. He has no basis to do that.
I am going to overrule it. Please proceed.
Thank you. The point is, if ARB was legitimately transparent and trying to operate and trying to do the right thing, we could all understand a situation where they didn't have money to pay their bills. It's happened to all of us. It's happened to every good company. But when you have so much smoke and everyone says, but wait, where did the money go? Are you really operating wells intentionally at a loss and trying to get future funding to pay them? That can't be the truth. Are you really not? You're okay running a business that loses money? Why are you doing this? I think it begs the question, and I'm happy to spend 6 hours, set up a separate evidentiary hearing and notice it properly and have my witness here to walk through these exhibits if that's what the board wants. But because the board has an affiliation with the rules of evidence that allows them to use them or not use them in a way that helps them with the efficient administration of these hearings, I would say that's unnecessary. Again, I'm happy to do that. I would relish the chance to walk you through these and show you so that you see in black and white what I have seen, but I will tell you a summation, not evidence. You brought me in to ask questions, and I'm answering my questions to the best of the ability. $9.3 million transferred out during the operative time frame to a brokerage firm and for the CEO's alimony payments to his ex-wife. And so when they come in and say, we don't have the money because of market conditions, I say no. When they come in and say, we should have a straightforward argument on whether it's futile or we should set this for mediation so we can resolve it, we've been through mediation. When we filed the first accounting, the board set it for mediation, and if I recall, and the division can support this, the division's update was ARB stopped participating. We didn't get any meaningful participation from them, so we have to have a board hearing. So if the board is looking at this and trying to decide whether they want to continue to have these hearings or whether they think ARB has made it so that this process is not going to achieve results, you have to look at the full picture. And my proffer from reviewing this, and this is not evidentiary, fine. This doesn't have to be evidentiary value. But you know and trust all of us to different degrees. What I'm telling you is, if you'd like, I'm happy to walk you through these. ARB can argue against them as much as they would like, but the paper says what it says, and there is no justification, zero justification for paying $500,000 in alimony and child support and divorce settlement payments to your ex-wife, and then coming to the court and saying that exact amount of money, I don't have that anymore, but it's market conditions. The board has done everything that it can to pursue these accountings. It's tried as hard as it can to hold them accountable. And I think sometimes we get to the end of the line and say, we don't need you to come in every month. We have a very clear idea they're not going to pay you next month either. And we don't want a request for agency action filed 6 weeks from now. So we don't think we can do anything to force them to comply. So you've exhausted your administrative remedies, and you can pursue remedies for royalties in court. And that would be my argument.
Thank you. Mr. Donaldson.
As an initial matter, I'd ask for all of that factual predicate to be stricken from the record. Rule 63G 4 206 E and F talk about the way the evidence is supposed to be treated in a hearing. This is the Administrative Procedures Act. This governs this body. This governs every other body in the state of Utah that is an administrative body that's hearing evidence. And it makes it very, very clear that the presiding officer shall afford all parties the opportunity to present evidence, argue, respond, conduct cross-examination, submit rebuttal evidence. All testimony, this is the key one. Turn with me to subsection F. All testimony presented at a hearing, if offered as evidence to be considered in reaching a decision on the merits, shall be given under oath. And you've heard Mr. Mayo say, well, if my witness were here, this is what it would say, this is what it would mean. But there is a reason we have the rules of evidence. And it's because we are trying to get facts from people who have personal knowledge to testify about those facts, not lawyers just looking at a piece of paper and telling us what it means or what happened, which is what you're having. Now, Mr. Mayo kind of backs up and says, well, it's not really evidence, but you know who you trust. He's already said it. He's already said it and expects you to take it as a given that what he is saying is true when there literally is no record evidence of it. He wants you to make a decision based on what he's saying when there's no record evidence of it and the Administrative Procedures Act hasn't been followed. So I do need to be clear about that. And to the extent that that's been the practice here, I can't speak to that. I'm here on this matter, and I know what the Administrative Procedures Act tells us, and we all know that. We can read it, and it tells us that it has to be given under oath so that we have the opportunity to cross-examine and deal with it. And that's setting aside the objection that I made previously, which is you don't get to ambush a party at a hearing and dump evidence out there, supposed evidence, without telling them where you're going to be going beforehand. Mr. Mayo's a lawyer. He knows this. That's, I would argue, an ethical responsibility as well. So we don't ambush with supposed evidence. So I just need to get that out of the way. So that's kind of point number one on my side. Point number two is it's very curious to me that when it's convenient for Mr. Mayo, we get to blend the cases together. And so he gets to talk about, well, where's the money? Referring to, again, a discrete and existing payment obligation from the past that's already been fully adjudicated by the board. And we get to blend that together with his new request for an accounting that, as we've said, and we're at the pleading stage, meaning that we're at the stage where you request agency action and you get a response and objection. There's not really necessarily evidence, an evidentiary component to that. But at that stage, we have indicated that for the time period in question, Mr. Perchetti owes money. But he wants you to make a decision based on supposed evidence that has not been introduced. So that's not appropriate. And again, it's also not appropriate to blend the two cases. We have to talk about the time period in question. That time period is from May of 2024 to the time that he filed his request for agency action. There's been no discussion about the accounting during that time period, what's owed, what isn't owed, under the working interest that his client holds. So we can't blend those together. And I've heard repeated statements about what I supposedly said that are just simply not true. Never said ARB has no money. I never said ARB is operating at a loss. And when I said market reasons, I didn't say ARB is operating at a loss. I said ARB didn't have the ability to make this discrete payment that's owed from the prior matter that we talked about. And so I just didn't say that. And then when I said market conditions, I indicated to the board it's broad. It's also internal business issues with ARB. So I just don't appreciate Mr. Mayo saying what I said when it's not what I said. And so I just need to note that. But fundamentally, there isn't a basis to treat this any differently than any other matter. It's a new matter. It needs to be treated on its own. And based on the allegations in the request for agency action, it should be set down in the ordinary course. Again, a mediation would be part of that, and that would go a long way towards resolving this. I'm just not, from the face of the pleadings, there's not a basis to just throw out that requirement. We never mediated with Perchetti in the first action. The parties agreed at that time that an in-person settlement conference would satisfy that mediation requirement. So it actually never happened. We've never had the opportunity to sit down with a neutral. In any event, there is no basis to skip the exhaustion of administrative remedies that's required. If Mr. Mayo were to go to court right now, those administrative remedies would not be exhausted, and we need to follow the procedure, especially. The other matter is the other matter. This matter that we're talking about, especially when there is a net deficit on the amounts that are owed. And I haven't heard Mr. Mayo say otherwise, either in his papers or in his supported presentation of evidence. So with that being the case, how could there possibly be a need to just throw out the rules and the administrative requirements? I don't see one. And we would simply ask that it be set down in the ordinary course.
Let me ask Mr. Mayo, is there any statute or rule that would allow the board to declare that administrative remedies have already been exhausted?
My apologies. Yeah, that's outlined in the rules. I mean, the truth is it's from the Administrative Procedures Act. And the exhaustion of administrative remedies is required in both the board's rules and in the Administrative Procedures Act, but for when that becomes futile. So there's case law that interprets when it becomes futile, and whether you're bound by that, honestly, is questionable, depending on the extent of the decision. But I also think sometimes lawyers complicate things. If you have a sense that you can meaningfully move the needle by giving just a little more time and a little more due process, then you absolutely should say administrative remedies have not been exhausted. If you think that this accounting we're dealing with now is going to be the same as what you've dealt with, you can say, we've reached the end of our administrative powers, and you don't need to keep coming back to us. So I think to point you just squarely back to UAPA and to the board's rules is probably the best way to direct you to that.
Okay, thank you.
If I could just hit on
May I
a couple
respond to
things
that
real
briefly?
quickly before, I just wanted to, what Mr. Donaldson said the last time, a couple things about testifying. It's kind of weird to hear that I'm prohibited from testifying factually when he testified factually in the hearing, moments ago. But I understand that lawyers have to lawyer. But the second thing he said is, testimony has to be given under oath. I am not a witness. I am happy to be sworn in, to take the oath, and to state my proffer. I am happy to answer the board's questions. Let's say, for example, the board said, Mitch, you're under oath. Will you show us one of those documents that you're talking about? I'd be happy to do that. So it's not a question of not wanting or willing to be under oath. I'm trying to provide the board with the simplest, straightforward answer they can. And I think when you're talking about, do we have the ability to exercise jurisdiction in a way that's going to meaningfully help? Knowing whether there's money and whether there's going to be money is a pretty big part of that equation. So I just wanted to hit on those before we move past.
Thank you. Mr. Donaldson, do you have a response?
Yeah, a couple things. My response to that is, even if you were put under oath, even if Mr. Mayor were put under oath, he couldn't testify. Doesn't have personal knowledge. Mr. White, Mr. Haynes know this. These are basic law school issues on evidence, and so that doesn't cure anything. Putting him under oath, he has no ability to proffer because he doesn't have a witness here, anyone that can actually get this evidence in. But more fundamentally, I think Madam Chair's question was very salient, which is there statutory authority that allows you to ignore the exhaustion requirement? And we're not aware of any. We didn't see any cited in the request for agency action. It was simply a citation to the general rule that allows for declaratory relief, but the Administrative Procedures Act tells us that you have to exhaust your administrative remedies. And that's, I believe, 63G 401. And so to just say, hey, you can do what you want, board. And I said this last time, and it's true. And if I were one of you, I would feel the same way. Like, you want to feel like you can do what you feel like you need to do to solve a problem. At the same time, you're in a unique position, both because you make policy, which is like a legislative body, but then you adjudicate disputes. But when you're adjudicating disputes, you're sitting like a judge would be sitting. And so you need to follow, so the rules need to be followed. And I know that, judges all the time, you hear this phrase, I'd like to do X, Y, and Z, but my hands are tied. Well, why are their hands tied? Because they follow the law and follow the rules. And we need to do that here. And without hearing any answer to your question, Madam Chair, about any statutory authority that would allow you to ignore the administrative requirement, this should be open and shut. There is no basis to make some kind of ruling that you could do that, and I think that type of ruling would be tossed on appeal if it came to that. But we don't need to get there. If we set this down in the ordinary course and set a mediation, the parties can get together, they can try to resolve this. If it doesn't get resolved, it doesn't get resolved. If it does, it does. That's how it's supposed to work. We're not supposed to be operating out of passion or prejudice. And again, absent some rule that would allow for the suspension of the administrative exhaustion requirement, it's not authorized, it'd be improper, and we would object to that.
Thank you. Division, would you like to weigh in with any thoughts?
Sure. So let's just summarize really what we're doing here. There's two choices that are being proposed in the RAA. The first is seeking a declaratory ruling or an order that Perchetti can have an order from the board saying you've exhausted your administrative remedies. Alternatively, we set the matter for investigation by the division to investigate and negotiate the non-payment of royalties for the specified time period. From the division's point of view, we are happy to move forward with that investigation if that's what the board directs. Speaking as to the order that the party has exhausted their administrative remedies, the division does have concerns. That is an extraordinary remedy that is being sought. judicial review under UWAPA is reserved for parties that have been aggrieved by an agency action. Until you take that agency action, there can't be a judgment that exhaustion administrative remedies has taken place. So from the division standpoint, as I indicated, we are ready to proceed as directed. And if that is to investigate and negotiate the non-payment of royalties, we're prepared to do that. Thank you.
Thank you. Back to Mr. Mayo.
Yeah, I'd like to just remind the board what division's position was at the October hearing last year. And that was, we really don't want to get in the business of doing these accountings. And if you can take that into consideration, we're not set up to be a financial accounting for these complex matters. We don't want to be involved in this. And the truth is, with how obvious it's now becoming that the money is gone and won't ever come back, stolen, lost, whatever you want to say, it's imperative that Perchetti protect himself regularly. And I think if the board decides that administrative remedies have not been exhausted, it probably should prepare for a new request for agency action filed every month on why proceeds for that month haven't been filed, because the only way it sounds like to protect ourselves is to file that, go through a pointless investigation and mediation with this particular set of parties, and then a year later come before the board in a couple of really contentious hearings, get a board order that they won't comply with, and then we can take that order 18 months from now and go to court and deal with it. The problem is, the minute that's done, we'll have another 18 months to process through the system, and it seems to me like that is the definition of futile, right? Making us go through the same steps over and over again. To do what? To protect ARB's procedural rights? That's why we have to go through this process? To make sure the board has had enough of this discussion? That's why we have to go through this process? It doesn't make any sense to me why, as much as the decision may seem right, that you need an order, that's why we're asking. The board has full authority to enter declaratory rulings. And we think this is one of those issues where the board should exercise that and say, listen, we're not in the business of doing this repeatedly, and if we can't, with the mechanisms we have, get an operator to come in and make it right, then go somewhere where they have mechanisms, right? If the board can exercise the rights to foreclose, great. If the board can order a sheriff's sale, fine. But the truth is, all the board can do is hear it and say, we're not really sure, we're not set up to be accountants, we think it's this much, go to a court and figure it out. And all we're asking is, have some mercy on everyone here and let the process die here at the board, because we're not talking about administrative remedies for anything else but for unpaid royalties. And I would argue, for what it's worth, the equivalent could be given to ARB, right? They've made statements here today that are a complete surprise to me, and I think a fabrication, but I won't say that because I don't have any basis, but that Perchetti now owes $150,000 over the last 18 months to ARB. They also, I think the board could make this order double-edged and say, given the status of this and the complexity of what's going on, we don't believe either party is required to exhaust administrative remedies as it comes to a royalty accounting, because what they're saying is, we've got money owed to us too. Great. If you do, let's let a court decide how to shake it out, because coming back to this board is going to create more of these here.
So what prevents Perchetti from beginning a district court proceeding based on the alleged non-payments of proceeds?
Well,
now,
for the current cause, 199.12, what prevents him is the requirement that he exhaust administrative remedies. And because this board, and to be totally clear, this is belt and suspenders. Right? There is nothing definitive that says this is an administrative remedy we have to exhaust. But I don't think Perchetti wants to pursue tens of thousands of dollars in legal fees and a year of legal process to find out that a court in Texas disagrees. And so the easiest way to do this is answer the question, can the board effectively do these royalty accountings between Perchetti and ARB? And if so, do they think the result is going to be effective in securing compliance? And if you can't answer those two in the positive, then you have no choice but to say it's futile, or you're essentially punishing my client because there are administrative remedies available. And I know that's not the board's intention, is to make it complicated.
okay, so I'd like to go to Mr. Donaldson and then to the division. And at that point, I'd like to see if the board has questions. Mr. Donaldson.
I think the discussion's been helpful. If it's true, as Mr. Mayo says, that administrative exhaustion would be futile, or there's some other reason for it not to apply, there should be nothing stopping him from going to court right now, and we shouldn't be wasting any time on this issue. And so, that might be one solution, is to stay this so that his client can go to court and make that argument, and a court might accept that. But otherwise, and the other background piece here is we are talking about a scenario, and again, just like Mr. Mayo, I don't have personal knowledge of the facts. I don't have the ability to testify from the standpoint of personal knowledge that would comply with the rules of evidence. But my understanding is that there is a deficit during this time period in which Perchetti owes ARB. And so that kind of frames the background as well, and I haven't heard anything to the contrary. And so for that reason, there would be no reason to not set it down in the ordinary course. But if Mr. Mayo and his client want to go to court, then we would be willing to, hit pause on this matter, and they can go to court and see if the court would be willing to waive the exhaustion requirement. We don't think it would, and we don't think it could or should be waived. But I think you made a good point in saying that he could go to court to do that right now. But you can't do both, and that's an issue now in this one, like it was in the last one, where his client is trying to hit all these things from both sides, both through the courts and with this body that has been open and sympathetic to his arguments and his position. But we don't think that's appropriate. So if his client wants to go to court, they should go to court. Otherwise, this should be treated like an ordinary request for agency action.
Will your client argue in court that administrative remedies need to be exhausted before the board?
I don't know that, but yeah, I would think so. But I don't know that because that's a future event that hasn't taken place, and that's subject to all kinds of factors and communications with my client that haven't occurred, and so it's kind of a hypothetical. But my position, just to be very clear, is that administrative remedies should and must be exhausted per the rule. So I'm not going to stipulate that they have been or that they can be tossed out. Of course, I'm not ready to do that at this point. But if there is an argument that they don't apply, that could be made to the district court. But I suspect that we would argue that administrative remedies need to be exhausted because fundamentally, anyone who practices in administrative law knows that that's one of the main tenets, as Mr. Haynes has said.
Moving to the division, Mr. Haynes.
Yeah, I'll just leave a final comment. I'd just like to let you know what exhaustion of administrative remedies can mean in this situation. If a party requests the board, petitions the board for unpaid royalties, we have the 60-day negotiation investigation by the division. At that point, the board has no requirement to have a hearing on that. So at that point, you do nothing, and administrative remedies are exhausted. That's by statute. There's no requirement that it goes any further. So that's what that would mean.
Thank you. Board, do you have questions at this point?
This is
Miss.
one just real quick. You had going back to Miss Meeks, just the other day, just a day ago, he's had a request for her to participate electronically, but she's not available.
So my office did that, and we put it in the wrong case number. It was for the other case because we didn't expect any possibility of evidence in this case. We took that measure so that she could be available, but she was not available. We had not been able to confirm availability, and then when we tried to, we were told she wasn't. That's in the other case. So
Well, regardless,
Well,
you
it's-
spoke to her, but she didn't.
no, well, our client contact told us that.
That she would be available, and that's why
No,
you
that
submitted.
she would not be.
Board, do you have any other questions? Mr. Walker?
Yeah, Mr. Haynes, on the prior proceedings, what was was there any positive outcome from those 60-day negotiations? Please remind me of where we.
If I recall from the prior proceeding, we hit a point where ARB was no longer responsive, and then we didn't hear from them again until we had a hearing on that matter.
Okay, and how much time what did we go through there?
So it's a 60-day negotiation. I believe I don't have the exact date, but there was a point where ARB would not respond to the division anymore.
I believe the first hearing was in March of last year, and the RA was filed in January, so it was probably pretty quick, close to that 60 days, just based on my
Yeah,
recollection.
I'm sorry, I don't know the exact time frame.
Mm-hmm. Okay.
Mr. Church?
Mr. Mayo,
I think, did you have something?
Yeah,
to add
yeah,
there,
all I
Mr.
wanted to
Donaldson?
add to that is I want to be clear that my law firm, we were not involved in the early stages of that first case. We didn't appear till the end of May.
Okay.
So after the
So you-
investigation had already been done and all of that.
Okay, so you can't answer or add anything to what Mr. Haynes just said, is that right?
No, I have no reason to. I wish we had been involved. Maybe things had gone different, but we weren't.
Okay, thank you.
Mr. Church?
so, Mr. Mayo, in this request for agency action, your alternative is to ask for an accounting. Is that from the period of the last hearing? So that's a date specific. It's not to.
It's not from the last hearing, it's from the last date that was included in the first request. So the first
Okay.
request went through a period of time, and essentially the next month's production forward to the present,
Okay.
we still haven't been paid for that.
So, Mr. Donaldson, then, you're the personnel for ARB, the accounting people, will all have firsthand knowledge of what has happened with the wells since that last hearing, that last declaratory order that we had put out. Is that correct?
They would have knowledge of the matters that are in
Personal
there.
knowledge.
They would have personal knowledge of the matters that they've been asked to deal with.
Because of the reason I
accounting and
asked
so
that
forth.
is on the first ruling, many of the questions we ask, ARB's personnel, the witnesses said they did not have personal knowledge because they were not involved at the time. So if we go with this alternative 2, all the witnesses will have a direct personal knowledge of what's happened for ARB. Is that correct?
I don't know, Mr. Church. I just don't know what the timing is of who it would be that was dealing with the accounting at what different times and what they would have knowledge of. But for sure, any witness that comes before this body would have personal knowledge of the things that they worked on, the things that they did. If it was accounting computations, they would have knowledge of that.
Okay, very good. Thank you.
Can I just interject real quick? If it got to the point and the board did want to have a hearing, just a reminder, you do have subpoena power. You could subpoena the parties that you want to be there to answer those questions.
Thank you. Board? Okay, could we have a summary, Mr. Mayo?
Yeah, I guess the best summary is probably non-legal and maybe a little more just as a human being. I think we're all exhausted. I think we're all worn out. And more than that, I think it feels like we've spent 3 hours this morning chasing our tails and ended up in the same spot. Our promise is the next time they'll bring witnesses and they'll have firsthand knowledge. And if you just would follow the normal rules, we promise we would comply. I don't buy it. And frankly, I think if the board buys it, it's a mistake. The truth of the matter is, the real question before this board is, do you want to continue to have every month a new request for agency action filed, not just by Perchetti, but it sounds like, according to Mr. Church's question in the past hearing, other interest owners as well? Or does the board want to say, listen, we have reached our limit with this. We can't do what needs to be done to ensure compliance with the rules. It's exhausted. And I think that makes sense. That would be my position. Of course, you know, in a perfect world, if Mr. Donaldson could actually speak on behalf of his client the way that us lawyers wish we could and say, yes, we will absolutely participate in the mediation. I promise we'll do our best to get there. The truth is, it's a client, right? And we can say what they say to us, but we can't definitively determine that. And the truth is, you know, you saw the Hedges when they came in. He can't say definitively that they'll have a witness with firsthand knowledge at a hearing if you set a hearing. He can't definitively say whether we'll resolve things. I mean, one of the problems with this is, you know, this idea that if we just sat down in the room and mediated and negotiated, we could solve this. I have been personally involved in 10 conversations like this, 4 of them in front of this very board. How many times have I been approached by ARB or its counsel outside of those moments to try and settle things? 0. So I understand the way it sounds to a board who pops in every 6 months and then pops back out. But I hope you can understand that this is a concerted plan of attack. Defend, defer, deflect, defray, point every other way you can. When you're in court, the board has jurisdiction and they're dealing with it. We have to pause. When you're before the board, the court has jurisdiction. We're dealing with it. You have to pause. You know, to say to the board, listen, this should be in district court to exhaust administrative remedies, and then say, well, yeah, but when we get there, we're going to argue that it should be back before the board, is the most laughable thing I've heard an attorney say before this board. And so if you don't understand what he said was, pause what you're doing so we can spend a year fighting in court and then force them to send us back to this exact moment. That is the definition of futile. And I hope this board comes to the determination that there's no reason to entertain these silly posturing about procedural rules they care about. On that, I'll rest.
Thank you. Mr. Donaldson, do you have a closing?
Mr. Mayo said that something to the effect that, you know, we shouldn't need to be, well, that we're exhausted and worn out. I have to say that, yes, this morning has, you know, taken a toll. We've spent some time, we've invested some energy, we've invested some thought in all of this. But it didn't need to happen. It didn't need to happen. It was Mr. Mayo's choice to bring the other action that was dismissed for lack of jurisdiction, that in the order to show cause says, based on allegations that were made at the hearing in that action, here's your order to show cause in that first action that we don't believe is appropriate. And this new agency action didn't need to be filed either. Those were both done by Mr. Mayo and his client.
To be clear, the order to show cause was issued by the board. I have no authority.
The order to show cause was issued by the board, but in the order to show cause, it says that it came from allegations from the other request for agency action that ended up being dismissed. Perchetti didn't need to bring that request for agency action. Perchetti didn't need to bring this new request for agency action. So, you know, that it's exhausting and tiring and everything else, that was a creation that they chose. They have a remedy. They've been pursuing their remedy in court. That's where it could have stayed. And again, if I didn't say that, again, Mr. Mayo, I believe, is mischaracterizing what I said. What I said is there is an exhaustion requirement. If he doesn't believe that and doesn't think it's controlling, he would be welcome to go to court, and we would deal with whatever he argues there as needed. But I also said that if we set this down in the ordinary course and we have a mediation, that would give us an opportunity to resolve this. And that's our position.
Thank you. Mr. Haynes, do you have a report from the division?
No, we have nothing extra to add. Thanks.
Board, do you have any additional questions? Mr. Walker.
Yeah, Mr. Donaldson, what court, if we grant the request for agency action, what court would this end up in?
You're talking about if we do number 2 or
Yeah, yes.
I don't know.
I think he means if we.
No, if we do the declaratory judgment.
Oh, if you issue a declaration declaring that administrative remedies either that administrative remedies
exhausted.
don't need to be exhausted or they should be
No,
deemed
that
exhausted.
they've been exhausted. If we say, okay, we're exhausted,
If you say that they've been deemed exhausted, it would end up in one of the district courts that has jurisdiction to hear the appeal of that decision, if that's the final decision in this matter 12.
okay,
It's either a Texas court or a Utah court, most likely.
okay, thank you.
Thank you. Now we have a decision. We can go to lunch and discuss this over lunch and come back, or we can deliberate now, come back, make a decision, and then go to lunch. Is there a preference?
Let's do a working lunch.
Okay.
We'll be back at
We'll be back at 1 to issue a decision from the board. Thank you. We are off record.
one.
Welcome back. We're going to proceed with the final portions of cause 199-12. Do I have a motion from the board, please?
Yes.
Mr. Walker.
I move that the board grant Perchetti's request for agency action inasmuch as the request seeks investigation and negotiation. The board hereby sets the matter for investigation and negotiation to be completed by the Division of Oil, Gas, and Mining within 60 days of today's date, December 22nd, 2025, by 5 p.m. If the matter cannot be resolved by negotiation as of that date, any information gathered during the investigation and negotiation shall be given to Perchetti, who may then seek a remedy in a court of competent jurisdiction.
Do I hear a second? Second. All in favor, please say aye.
Aye.
Any opposed? Motion carries. Thank you. I think that concludes that matter.
I'm assuming board counsel is going to prepare that order, or would you like us?
We're going to have you prepare the order, Mr. Mayo.
I'm happy to do that.
May I just ask, is mediation required as part of that? Which I think it's
I
statutory.
don't think
but-
so. No.
Negotiation, but not mediation.
Right.
Thank you.
Thank you.
Thank you. Appreciate the time.
And while we're waiting for Crescent Uinta, which is 130-41, we have several issues that have been continued. I'm going to read through those while the next matter gets set up. This is docket number 2025-049, cause number 132-81. In the matter of the request for agency action of SM Energy Company for an order pooling all interests, including the compulsory pooling of the interests of certain non-consenting and unknown owners within a 1,920-acre or substantial equivalent drilling unit established for the production of oil, gas, and associated hydrocarbons from the lower Green River, Wasatch, Colton formations of sections 19, 30, and 31, 2 South, 1 West, USM, Duchesne County. This matter has been continued to the November 19, 2025 hearing examiner proceeding and December 3rd, 2025 board hearing. Next item. Docket number 2025-050, cause number 132-82. In the matter of the request for agency action of SM Energy for an order pooling all interests, including the compulsory pooling of the interests of certain non-consenting and unknown owners within a 1,280-acre substantial equivalent drilling unit established for the production of oil, gas, and associated hydrocarbons from the lower Green River, Wasatch, Colton formations, comprised of sections 30 and 31, 2 South, 1 West, USM, Duchesne County. This matter has been continued to the November 19, 2025 hearing examiner proceeding and the December 3rd, 2025 board hearing. Next item. Docket number 2025-045, cause number 600-10. In the matter of the request for agency action of Uinta Gas LLC for an order establishing separate special diagonal drilling units and overlapping drilling unit boundary well drilling units for the production of oil, gas, and associated hydrocarbons from portions of the Mesa Verde, Blackhawk, and Mancos formations from long lateral horizontal wells comprised of portions of sections 2 through 4, 9 through 11, 15 through 17, and 20 through 22, 9 South, 17 East, SLM, Duchesne, and Uinta counties, Utah. This matter was continued from the September board meeting. The matter has been voluntarily withdrawn, and the board has dismissed it without prejudice. So from that, we're going to move on to our next hearing item, which is docket number 2025-047, cause number 130-41, in the matter of the request for agency action of Crescent Uinta LLC for an order establishing laydown 1,920-acre and laydown 2,560-acre drilling units for the long lateral horizontal well production of oil, gas, and hydrocarbons from the lower Green River and Green River Wasatch formations in sections 9 through 36, 2 South, 4 West, USM, Duchesne County, Utah. And next we have appearance of counsel. Mr. Chicken. Mr. Kirk.
Brent Chicken, Steptoe and Johnson, PLLC, on behalf of applicant Crescent Uinta LLC.
Thank you.
Yeah, I'm Assistant Attorney General Andrew Haynes. I'm here with the Division of Oil, Gas, and Mining. However, I'm here to introduce, this is Nico Micheletti. He's a recent graduate from the University of Utah Law School and recently barred. He's been with the Natural Resources Division with the AG's office for a couple of years as a clerk, and now he will be assisting in these matters. Thank you.
Congratulations. That's a milestone in your career.
Thank you very much. Thank you very much.
Thank you.
Heard you.
Back to Mr. Chicken.
Thank you, Madam Chair. I will try and make sure I can truncate what we can here. I know you have a full schedule left today, and to avoid just duplication between my intro and witness testimony. This is a fairly straightforward, and I might even say a vanilla application based on what the board has been hearing and the development plans being granted by the board in the last 2 years. Crescent Uinta is today asking for 9 lay-down 1,920 acre overlapping spacing units for 3-mile wells, and 6 lay-down 2,560 acre overlapping DSUs for 4-mile wells. This will be Crescent Uinta's first real foray into these, you know, I don't know if we've heard them say super long lateral, extra long lateral, but 3 and 4 mile well development programs. Along with this, we are asking for up to 37 horizontal wells per DSU, 330-foot lateral DSU boundary setbacks, 100-foot heel toe setbacks, and 100-foot inner well setbacks. At present, the subject lands are governed by multiple different orders, which we'll refer to as existing orders. So orders 139, 155, 130-02, 130-05, and 130-36. The latter obviously being the most recent order earlier this year, which kind of trued up this area on the 640 and 1280 overlapping spacing. And so that's what we have out there right now, are multiple lay-down 1280s for 2-mile wells and multiple section line 2560s encompassing 2 1280s. And the previously mentioned setbacks and well counts are in existence already on these lands for those smaller spacing units. So there's 1280s with 37 wells, same setbacks, and there's 2560 section lines with 3 wells stacked, pretty much what the board is used to seeing in that respect. The one thing I guess I want to mention, and our testimony will have this as well, is that, along with the overlapping spacing scheme, you get the concept of total lateral footage. So even though each one of these overlapping spacing units can have up to 37 wells, they are cumulative for any piece of land. So that means you're never going to have more than 37 wells from the subject formation on any one piece of land. So some of those could be 2-mile laterals, they could be 3 or they could be 4, but we're not adding, and I just want to make that clear that we're not stacking this up so that somehow you can drill 90 wells in a 1280. That's not the case. Based on the evidence and technical data that we'll present today, Crescent Uinta believes that the RAA is going to continue to provide the flexibility it needs to learn about these more productive wells. That ostensibly we're hoping to see better rates of return. More production, more royalties, more severance tax, and more production revenue for the state, for the royalty owners, for the operator, and the non-operators. Along those same lines, I will ask the board to please take administrative notice of the testimony In some of those prior orders, 13032, 13035, and 13038. And these are some of the board's most recent orders where they have granted 1,920 and 2,560 acre 3 and 4 mile DSUs. As the board is aware, the division timely filed a response to the RAA, but that response does not oppose the relief sought in the RAA, provided that we bring evidence to you today that gives everybody comfort in the science behind drilling these type of wells. Crescent Uinta has put a great deal of thought and work into this RAA, including lots of preliminary and follow-up meetings with division folks and contact with federal agencies, other operators, and the tribe. And Crescent Uinta absolutely would like to thank the division for its efforts here and for being willing to kind of constantly be able to push the envelope and find out ways to do this better and better, more efficient, more economic. And we do believe our land geology and engineering presentations today will meet the division's necessarily high expectations. I have 3 witnesses today. Sitting to my left is Staff Landman Roxanne Eveland. She has appeared before the board in the past as a fact witness on land matters. Our geology witness is Travis Plemons, senior geologist, and our engineering witness is James Tucker, who is the vice president of reservoir engineering for Crescent Uinta. Mr. Plemons and Mr. Tucker have not appeared today, but all 3 witnesses' resumes have been provided, and so when we could swear everybody in, and then for geology and engineering, I will provide foundation and ask that their testimony be accepted as expert witness testimony. And so unless there's other preliminary questions, I think we can swear folks in.
Thank you. Could we have you stand?
Do you swear that the evidence you're about to present is the truth, the whole truth, and nothing but the truth? So help you God? Yes. Thank you.
Starting with our land witness, Roxanne, if you could please state your full name, your title with Crescent Uinta, and confirm that you have testified as a fact witness in land matters in prior hearings before this board.
Yes, Roxanne Evelyn. I am a staff landman with Crescent Energy Company, Crescent Uinta LLC, and I have previously appeared in front of this board for other like matters.
Okay. With that, we'll move on to our first exhibit. So our first exhibit, L1, is our general locator exhibit. Roxanne, if you could please describe what you're depicting on this exhibit.
Yeah, so Exhibit L1, just wanted to point out that the red, like rectangular box that you see on this exhibit, that encompasses the lands that are the subject of our request today. You'll see that red rectangular box on most of our exhibits, so we'll establish that that's our request lands. These lands are located in Township 2 South, Range 4 West, all in Duchesne County. And you'll see that they're just north of Duchesne City and west of Roosevelt.
Okay, and so our subject lands today encompass approximately a half township?
That's correct.
Okay. Moving on to Exhibit L2. This shows the outline for the notice. If you could please describe what is depicted and who was provided notice of this request for agency action today.
Yeah, so what we see here within the yellow shaded area that's also bounded by the blue dashed lines, this is the area where we were required to provide notice to all working interest and unleased mineral interest owners for this matter. You'll also see on this exhibit the blue shaded area that's bounded by the green lines. This is like an additional buffer area that Crescent just chooses to go ahead and notice the working interest and unleased owners in this area as well. Just to ensure complete transparency for all the owners in the section, making sure that we're capturing as many people that we believe need to be informed of this matter. All of these working interest and unleased mineral owners were noticed as required by certified mail with return receipt requested.
Okay, and just to clarify, it is your position that all parties whose all parties whose legally protected rights, for purposes of your request for agency action, were sent a true and complete copy of the request for agency action as evidenced by the certificate of service on file in this matter?
Yes, that's correct.
Okay, thank you. Moving to Exhibit L3, can you please describe the type and area mineral ownership depicted on Exhibit L3?
Yeah, so within our request area, the minerals are comprised of fee minerals and some tribal minerals. The tribal minerals are under lease that is held by Crescent. And within this area, Crescent owns greater than 90% working interest in all of these sections. There are actually some sections that we own 100%, but we do own greater than 90% of the leasehold within all of these sections.
Okay. Moving on to Exhibit L4. First, I'll just ask a question that this is a graphical representation of the existing wells identified in Crescent's request for agency action, correct?
That's correct.
Okay, and can you please describe what else you're depicting on Exhibit L4?
Yeah, so this depiction of the existing wells shows both the existing horizontal wells drilled on the 1,280 acre spacing units that are in existence, as well as the vertical wells. A few things I wanted to note here. As our request noted, there are 30 existing long lateral horizontal wells and 32 vertical wells. These wells are all operated by Crescent, and as I stated previously, we do own more than majority working interest in each of the existing wells.
Okay. We'll move to Exhibit L5. Which I made a mention of some of these orders, but I think this does a better job of putting the board on the right spot to what is happening out there as far as existing spacing. Can you please describe what we're depicting here?
Yeah, so within our requested area, again, it's a little bit harder to see here, but it's bounded by the red outline. We are currently covered by Order 139-155 for the laydown 1,280 acre DSUs. That order was amended by 13002 and 13036. 13036 was just increased density and reduced setbacks for that order. For this particular request, we're not asking to change any of the setbacks or asking for any additional increased density. So just as a review, we do currently have well density of 37 wells per section, with the inner well setbacks at 100 feet, the setbacks for the heel and toe of the horizontal wells at 100 feet, and the section boundary setbacks at 330 feet. Again, just to reiterate, we are not requesting increased density or any additional wells. And then also just wanted to reiterate that our requested 1920s and 2560 DSUs will overlap these underlying 1280 DSUs. So the 1280s will stay in place. Nothing changes on the division of interest for these wells. They all remain on a 1,280 acre basis, and the vertical wells remain on a 640 acre basis.
I believe that's 640 acre with 4 well density. Is that accurate?
I believe so, yes.
Okay, thank you. Moving on to Exhibit L6, which is kind of getting at the specific 9 previously mentioned 1920s. If you can please describe what we're showing here.
Yeah, so what you see here are the laydown 1,920 acre spacing units that we are requesting. They are in both the solid red and the dashed red lines, and just by way of example, you'll notice that the dashed red does overlap some of the existing or the solid red. So for instance, by way of example, sections 19, 20, 21 are shown as a laydown 1920. Sections 22, 23, 24 are shown as a laydown 1920, and then 20, 21, 22 overlaps those other two. So just wanted to point out that, you know, that's what you're seeing there is our 3 kind of in each row with 1 overlapping the other 2. You know, these 1,920 acre spacing units are being requested to facilitate the drilling of 3-mile horizontal lateral wells. And again, just they will overlap all the existing drilling and spacing units that are in place.
Okay. We'll move to Exhibit L6, which is the 2560 overlapping DSUs being requested. If you can please describe what's shown on Exhibit L7.
Yeah, so the requested 2560 spacing DSUs are overlapping as well. So they're in the dark solid blue and the dashed blue lines. Again, you'll see some overlap here. You know, and one of the reasons why both on the 1920s and the 2560s that we're asking for kind of a little bit of a, you know, I guess you would call off-pattern DSUs is to provide us flexibility and optionality in our development plans, you know, so that we can look towards minimizing surface disturbance. We can look towards, you know, the efficient strategic, you know, alignment of where the facilities are, where the infrastructure is. So that just allows us some flexibility there to be able to choose, you know, what's going to work best for that development plan.
Okay. Sorry, just making sure I'm not going beyond the other one. And I think, actually, I'm going to move to the next slide, which is Exhibit L8, which is the last slide. And this kind of shows them all together. But I would just like you to reiterate for the board what I kind of mentioned, which is these are 640s, 1280s, 1920s, and 2560s, the latter 2 being requested today. These will all overlap, but the well footage for each one of those is cumulative, and the request today, if granted, would follow that same cumulative process by language in the order, correct?
Yes, that is correct.
Okay. So I don't know if there was other items you wanted to talk about on Exhibit L8, but please, you know, flesh it out, any other pieces that you think the board should know.
Yeah, and on this one, it's a little bit busy, but it's just like, as council mentioned, it's just the requested drilling spacing units, kind of all on one map, so you can see them all together. Again, our anticipation would be to drill, you know, a mixture of 3-mile and 4-mile wells, but the overlap kind of allows us to be strategic in that regard and to be able to give ourselves operational flexibility.
Okay. Were exhibits L1 to L8 that you've just presented prepared by you or under your supervision, direction, and control?
Yes.
And do you believe the relief sought in the RAA will protect correlative rights, maximize resource recovery, prevent waste, and in large part because of the operational flexibility will also help minimize surface use?
Yes.
Okay. I have no further questions for Ms. Eveland.
Thank you. Division?
Yes, thank you, Madam Chair. Just a couple questions for the petitioner's witness. Are there any other working interest owners in the identified subject lands?
Yes, there are other working interest owners.
And they're provided with notice?
Correct.
Did you hear anything back from these other?
We did not receive any type of official response back to our request.
Okay, that is all. Thank you.
Thank you. Board, do you have questions? Mr. Moon?
So on Exhibit L4, if you could go to that one. One more, 5. 6. There we go. Okay, I was close. So what's the purpose of the overlapping dashed lined drilling units. Because if you do that, then you're leaving, the 3 sections along the west edge. Just kind of explain that.
Yeah. Well, I guess one thing I wanted to point out was if you go 1 township to the west, to 2 south, 5 west, we also own the acreage there. For instance, by way of example, if we were to drill in 32, 33, 34, that may appear that leaves 31 stranded.
Mm-hmm.
However, we do own the acreage to the west, and we could come back and pick that up with those sections if we needed to. And that's what I kind of meant by leaving open some operational flexibility so that we can kind of look at this as a bigger picture and how to best lay out our development strategy here.
Okay. Yeah, that makes sense. I don't know if there's any drilling units that cross township boundaries, but I guess we need to start doing that. So, okay. Second question's, I'm going to have to explain these to royalty owners that call me up and say, what's going. So division orders, normally operators don't provide the acres in the drilling unit. That would be a really nice thing to do, because a lot of times they aren't 1280s, they're 1,296 acres, and most royalty owners aren't going to know what that is. I just think it would save a lot of questions to your division order people if that were put on. Is there any reason that you wouldn't put on the net or the gross acres in the drilling unit? Any thoughts on that?
I mean, like the division orders in general aren't my specialty, but I would say no, there's not any reason why you couldn't put the total acres in the unit. I would say though that that is readily available to the owners. I mean, if they knew where to look, they could find the total acres in each of the sections. But your point is very valid. That I think it is helpful for them to know the
how would
spacing.
you though? Because that's even a little hard for me. I usually have to call the company because because a lot of the sections aren't 640s and
Correct.
et cetera.
Yeah, that's correct.
And in this case, where you have 2 milers, 3 milers, 4 milers, I guess the royalty owner could look up the specific well and see that it goes 3 miles, and say, well, it's a 1920 or whatever. But
no, actually, I think that's a good idea.
Yeah,
that would be
it would
very
just
helpful.
be helpful to have that number. So,
Mr. Church.
So help me understand the 37 wells per unit. When you have overlapping units, 2 to 3 overlapping, are we talking up to 90 wells through some sections?
No, it would be a total of 37.
So
yes.
total of 37.
On all of the
cumulative all
different, the
units.
cumulative, yeah. So for the underlying 640s, 1280s, 1920s, 2560s, it's a cumulative 37.
Won't exceed 37.
Correct.
Okay,
Not
thank you.
exceed 37.
And Mr. Church, to further, and that's why I pulled this one up. For example, I don't know that this is the case, but I would assume that 23 and 24 here are a 1280,
That's correct.
right? And so there's already 4 wells in there. That footage is gone from that 37 already. You don't get to do that again. So while they might be able to use 22, 23, and 24 to drill 3 milers, they've used those 2 milers times 4, or those 8 miles of well that are in there already. That's been used, and that's taken away from that 37, so that you don't have exactly what you're talking about, which is 16 and a 640, 22 and a 1280, 37, and then you have like 95 wells. It's not that. It is a total total productive footage concept, and it appears in all of these orders. So every order makes it clear that that's what it is. So that if you were to exceed that footage, you would be outside of the order.
As you plug wells, do you get some of your 37 back to drill new wells? Or you just 37
I
one
would
time?
have to think about that, Madam Chair. I guess conceptually you could say, oh yeah, sure, you know, if you plug one, you get those 2 miles back.
Right.
But there's only so many places you can put holes in the ground before those holes are running into each other. So I would want to think about that, and I would also think that I would want the division's input
That'll
on
be an
that to see what,
question one
right,
day.
to see what they would say. Let's wait till this whole entire box is all green, and then maybe we'll be talking about that. But until we get to there, I would reserve my comments on that.
Does the board have any further questions? Seeing none, let's go to the division.
No, you did.
Division, do you have any questions for this witness?
No, Madam Chair.
Thanks.
Okay. You are excused, Ms. Eveland. I would like to call my next witness for geologic exhibits, Mr. Travis Plemons. Mr. Plemons, if you could please state your full name, title with Crescent Energy, and confirm that you have not testified before the board before.
Yes, my name is Travis Plemons. I'm a senior geologist with Crescent Energy, and I have not testified in front of this board before.
Okay, but you did submit, along with this exhibit package, your resume outlining your experience and education in geology?
Yes, I did.
If you could just briefly summarize that education and your experience for the board, since it's your first rodeo here.
Sure, yeah. So I have a Bachelor's of Science degree from the University of Oklahoma in petroleum geology, and I also have a Master's of Science in geology from the University of Oklahoma. I previously have worked with Finley Resources in 2018 on the eastern portion of the basin. I've also worked with BPX Energy and Silverbow Resources working the Gulf Coast trend, and I've been at Crescent Energy for the past year working the Uinta Basin.
Okay. Subject to voir dire by the division and the board, I would like to offer Mr. Plemons' testimony today as expert testimony in petroleum geology.
Any objections from the division?
No, Madam Chair.
Board, do you have objections? So admitted.
Thank you very much. We'll move to our first geology exhibit, which is Exhibit G1, which is a type log I think the board has seen before, but Mr. Plemons, if you could please describe what's being depicted on this exhibit.
Sure. So this is a type log from the Lake Fork Ranch 322B4. It's in 2 South, 4 West in the land that we're talking about today. The log track on the bottom is gamma ray. So the bluer colors are showing carbonates and classics, while the darker kind of higher gamma ray readings are showing more shaly intervals. And then on the top track, we have resistivity. And then listed at the top are the formations. So we have the Uinta Formation, the Upper Green River Formation, Lower Green River, and the Wasatch.
Okay, and the inset map in the lower right-hand corner, the Lake Fork Ranch 3-22B4 well is indicated by that blue star, correct?
Correct.
Okay, so this type log well is pretty solidly, if not almost dead center, in our subject lands.
Correct, yeah.
Okay, thank you. Moving on to Exhibit G2, if you could please describe the geologic cross-section and how that was developed.
Sure. So this is a structural cross-section that is parallel to the current development across the associated lands that we're speaking of. So we have Garden Gulch, Douglas Creek, what we call the carbonate marker, Castle Peak, Eatland Butte, and then the upper and middle Wasatch formations, and really just showing that on this trend, it's relatively not a lot of structure going on. Also want to point out that in the locator map to the right, all of the existing wells, as we've mentioned previously, are operated by Crescent Energy.
Okay, and so the type log wells that are shown here, they're the 5 well names that are across the top running from A to A prime?
Correct.
And so, and one of these, the second from the far right, is your actual type log well from the previous slide, correct?
Yes, that's correct.
Okay, thank you. Move to Exhibit G3. the structure map. If you could please describe what's being depicted here.
Yes, so this is a structure map on the top of the Wasatch Formation over the lands in question. And really, again, just showing that structurally, there's not a lot of structure going on in the requested area. Also, just want to point out, relevant to the previous conversation, that it's operationally gives us flexibility to have the overlapping units, drilling parallel to structure where we don't see a lot of structure when we're drilling the well.
Right. And so I guess the follow-up question to that is, this structure that you see here helps to confirm that the east-west orientation of the requested wells, as well as the existing wells, is the proper orientation for maximum recovery.
Yes, that's correct.
Okay, thank you. We'll move to your last exhibit, G4, where you are kind of showing the potential 37 well being requested kind of wine rack development. If you could please describe in a little more detail what's being shown here.
Yes, so thanks. Yeah, so what we're showing here is a type log. Again, I'm just showing the gamma ray, and then what we have here is the 30-section well, a hypothetical 30-section well development that we've been previously talking about. And again, just to reiterate that all of these units it's all encompassing, in that there will never be more than 37 wells in a section per this order. But this just shows in what we would call a gun barrel view that how hypothetically we would develop that.
And so it's clear that this development plan you're showing here would encompass, if I could write, for example, this is a 2-miler, this is a 3-miler, this is a 2-miler, this is a 3-miler, but as long as those are, you have the flexibility to drill those distances, but that maximum footage is never going to be exceeded.
Yes, that's correct.
Okay, thank you. Were exhibits G1 through G4 prepared by you or under your supervision, direction, and control?
Yes.
And do you believe that the request for agency action before the board today is going to protect correlative rights of all parties, prevent waste, maximize recovery, and minimize impacts?
Yes.
Okay. I have no further questions for Mr. Clemens.
Division.
No further questions, Madam Chair.
Board members? No questions. Let's proceed.
Okay, thank you. I will call my next witness, Mr. James Tucker. Mr. Tucker, can you please state your full name, title with Crescent Energy Company, and confirm that you have not provided testimony to the board in any prior matters?
My name is James Tucker. Vice President of Reservoir Engineering for Crescent Energy, and I have not provided testimony before.
Okay, but your resume is included in the exhibit package that was timely submitted to the board in this matter?
That's correct.
Can you briefly summarize for the board your education and experience with respect to petroleum, petroleum engineering?
Yes, I'm a graduate of the Colorado School of Mines, where I received a Bachelor of Science in Petroleum Engineering and a minor of Economics. I began my career at Devon Energy, working in the Rockies, specifically in the Uinta Basin. I have overseen the development of Crescent Energy in the Uinta Basin for the last 3 years since the EP Energy transaction.
Okay. Subject to board and division voir dire, I would like, and based upon his history and background, I'd like to offer Mr. Tucker's testimony today as expert testimony in petroleum engineering.
Division.
No objection, Madam Chair.
Board. So accepted.
Thank you very much, Madam Chair. We'll first go to Exhibit E1, which is a little bit of a where are we going in the basin. Mr. Tucker, if you could please describe what's depicted on there.
So I think as many of you are well aware, the activity in the basin has expanded rapidly since 2020 and into 2022. The first chart in the top left depicts the number of permits that have been submitted. The green represents wells that are 9,000 to 10,000 feet, roughly, and the yellow bars reflect permits that have been submitted that are 13,000 to roughly 15,000, 16,000 feet. And the red bar reflects wells that are beyond 16,000 feet, now 20,000 feet. As new entrants have come into the basin, they've introduced ideas that they've brought from other areas in the lower 48. And you can see that trend really taking hold most recently in 2024 and 2025. The second plot on the right just depicts as a percentage of the total number of permits how many of these are extra long or extra long or extra long laterals. As of 2025, that now consists of about 30% of the total permits submitted. Here's a map just showing where many of these wells are located, and as you can see, they do bound much of the Crescent Energy acreage. We also bring some of our own experience from operations in other parts of the lower 48. In South Texas, about 50% of our drilling program the last 2 years has consisted of wells over 10,000 feet, with the longer ones extending up to 18,000 feet. In addition to that, we've drilled what we call advanced trajectory wells, which are shaped differently and not for the discussion of today, but we hope to leverage some of these learnings in the basin as well.
Okay. I will move on to Exhibit E2, which is your last exhibit, which is kind of a combination of lateral, incremental, and economic summaries. Can you please describe what's depicted on here?
This is a very simple depiction of what you might expect in the incremental volumes and incremental taxes and royalty revenues by extending from 10,000 foot laterals to 15 and 20,000 foot laterals. The blue depicts the current wells as they're drilled at 10,000 feet and what they would look like at 15 and 20,000 feet. And the green are the incremental volumes and revenue associated with those.
Okay, and so what we're really looking at here is in the blue, you're estimating 500,000 barrels at 10,000 feet, and so you go 5,000 feet out, you pick up another 250,000 barrels, you go another 5,000 feet, and you're picking up another 250. So you're getting about 250,000 barrels per every mile-ish of lateral. Is that accurate?
That's correct.
Okay. And so, and these prices are based on the assumptions in the lower right corner: $70 a barrel, $3 per MCF.
That's correct.
And so based on this slide, does Crescent Energy see efficiency and economic benefits to developing a 3 and 4 mile well drilling program?
That's correct. As briefly was discussed in the prior exhibits, the 3 and 4 mile laterals give us flexibility to utilize existing infrastructure, minimizing surface use. They also allow us to add more wells per pad, which is a cost-efficient way to develop the acreage. We believe that the drilling efficiencies could reduce cost by about 10% per well, with an additional 10% reduction in costs associated with some of these efficiencies I've mentioned.
Okay. I do not have any further questions. Actually, I do. Were Exhibits E1 and E2 prepared by you or
Yes.
under your supervision, direction, and control?
That's correct.
And do you believe that the relief sought today and for the reasons identified in your testimony will help to protect correlative rights, prevent waste, minimize impacts, and maximize resource recovery?
Yes.
Now I have no further questions for the
Board.
witness.
No further questions on the division's behalf. Thank you, Madam Chair.
I'm sorry, that was the division. Now we're going to talk to the board. Questions, Mr. Moon?
So what are the biggest risks of going out further than 2 miles?
It's a good question. Biggest risks are some of the things that we've learned in South Texas would just be our ability to complete the wells and drill out the plugs after we have fracked them. The drilling execution is something that we have a lot of experience doing. Aside from that, we want to take a methodical approach to doing this, which is why we have the overlapping DSUs. So we want to understand how the subsurface and the geology is changing along those laterals. Those are the biggest risks.
Thank you.
Mr. Church.
So on these extra long laterals, is there any problem with the steering out of that far away location? And what about downhole surveys, instrumentation, how you get the information back? I don't know the current capabilities, so just kind of a short education here.
Yeah. To answer the first question, no, we have not had any issues with steering the wells when you go out 20,000 feet. One thing that is a benefit for our acreage is the number of existing vertical wells, which gives you better control both laterally and vertically in doing that. We utilize MWD tools to understand where we are at in section and to stay in section as we go out further.
Okay, thank you.
Mr. Walker.
Yeah, could you elaborate out a little bit on the 10% efficiency? Is it, all your revenue is linear, and so the 10%, you're picking up, 50% more, but your 10% is for each of those increments going out 15,000, 20%, 20,000. Do you get a little more efficiency each of those?
Yeah, the 10% is a rough estimate, and the reason for that is that there are different drilling considerations in different parts of the field. But you could expect about a 10 to 15% reduction by going from 10,000 feet to 20,000 feet in our drilling costs.
Ah, okay. Okay, thank you.
You're welcome.
Seeing no other questions? Oh, Mr. Moon.
So we haven't talked about effects on your existing vertical wells. Have you found, first of all, have you drilled some 3-milers yet, or you're just getting ready to?
We have not drilled any in the basin. Just getting ready to.
And this question doesn't really pertain to that now I think of it, but are you seeing, like other operators have seen an uptick in vertical well production? Usually shut them in and then frack shut in the vertical and frack the long horizontal. And then there's some uptick from bringing those back on, but then they're seeing a longer term increase, or at least no detriment to the existing vertical wells. Is that your experience?
Yeah, I believe it is case by case and a little situational. What we did present in our setback request late last year was evidence that we also see uplift after drilling horizontal wells on the vertical wells, and we don't typically see detriment to the longer term performance either. So I guess I won't comment more broadly just because it's a little bit case by case, but generally speaking, we have seen positive to no impact on the vertical wells.
Are there cases, though, where you do shut in a vertical well a little sooner than maybe you wouldn't have because you've drilled a long horizontal well close to it? Or not necessarily?
And shut in, to clarify that question, you mean shut in for a long duration?
Yeah. Like it's the end of its life, now's a good time to shut it in because now we've got a long horizontal. We've already shut it in to frack. Is that a consideration?
So our typical mode of operation is, for safety purposes, we will evaluate all horizontal and vertical wells to shut them in and ensure that there's not any safety issues at the surface. What we will do is evaluate the remaining value on all the vertical wells prior to development, and if it makes sense to have some synergies with shutting in or plugging a well, we'll do that. I will say that that's not typically been the case. A lot of the wells have remained economic.
Good. Mr. Micheletti, on your first day, do you have any further probative questions?
No, I do not, Madam Chair.
Is that your final answer?
I believe so.
Thank you. Back to you, Mr. Chicken.
Well, let me see if I can wrap this around. First, I would like to ask that exhibits L1 to L8, exhibits G1 to G4, exhibits E1 to E2, and exhibits R1 to R3 be admitted to the record as evidence.
Division?
The division has reviewed the exhibits submitted by the petitioners and sorry, I misheard the question. No objection.
Board, any objection? Exhibits admitted.
Based on the exhibits and testimony and information shared today, we would respectfully request that the board approve Crescent Uinta's request for agency action in cause number 130-41, and subject to that approval, I am happy to prepare the order.
Board, do we need to discuss? Are we ready for an order? Do I have a motion
I would move that we approve this request for agency action.
and a second? A second. Been moved and seconded. All in favor, please say aye.
Aye.
Any opposed? Motion carries. Thank you, and if you would prepare the order, that would be wonderful.
Yes, Madam Chair. Thank you. Thank you, board. Thank you, division. Thank you, council.
And let's see. Uinta Wax is the next one. Is that Mr. McDonald? Okay. Did we scare you away? Are you going to have witnesses, Mr. McDonald? Okay. While you're getting ready, I will read this into the record. Thank you. This is docket number 2025-048, cause number 130-42. In the matter of the request for agency action of Uinta Wax Operating, LLC, for an order partially vacating the board's orders entered in cause numbers 139-151 and 130-12 as pertaining to long lateral horizontal wells and instead establishing two overlapping three-sectional laydown horizontal drilling units for the production of oil and gas and associated hydrocarbons from the lower Green River Wasatch formations through extra long lateral horizontal wells comprised of sections 20 through 22, 4 South 5 West USM, and section 19, Township 4 South 5 West USM, and sections 23 and 24, 4 South 6 West USM, all in Duchesne County, Utah. Thank you. And when you're ready, Mr. McDonald, please proceed.
Appearances, Fred McDonald of council with Lear & Lear on behalf of the petitioner, Uinta Wax Operating LLC.
Division.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Thank you.
With me today, I'm trying to get Mr. Horner on his camera on. Robbie, could you turn your camera on, please? There we go. With me today to testify on behalf of the petitioner are Mr. Zachary Archer, the senior landman of Uinta Wax LLC, Mr. Robert Horner, the senior geologist of Uinta Wax LLC, and Ms. Kayleen Bridwell, the senior engineer, ESG advisor, regulatory manager of Uinta Wax LLC. If one of you could, after you swear in mute the, we're getting some feedback here, okay? At this time, I would ask that the vice chair swear in the witnesses.
Please raise your right hand. Do you swear that the evidence you're about to present is the whole truth, nothing but the truth, so help you God?
I do. Yes.
Thank you.
All right, thank you. If you could mute until you're ready to testify. All three witnesses share the duties with Uinta Wax LLC.
Somebody must have their microphone on. We're getting feedback here. Could you all check and make sure your microphones are off?
I think he has it off now.
Okay, great. Thank you. All right, all three witnesses share their duties with Uinta Wax LLC. The resumes of all three were submitted as Exhibit A as supplemented. If asked, they each would confirm the information reflected in their respective resumes are true and correct. Mr. Archer will be a fact witness only. Mr. Horner and Ms. Bridwell have been previously recognized as experts in geology and petroleum and reservoir engineering, respectively, by the board. I want to double check that the board has approved Ms. Bridwell's substitution as a witness in this matter. We filed a motion on Monday for that.
Do you know if that's been taken care of? Yes, it has.
All right, thank you. I just want to make sure. Presuming the division has no objections based on their resumes and their previous recognition, I would ask that the board recognize Mr. Horner and Ms. Bridwell as experts in those particular fields for the purposes of this cause.
Division?
Yeah, no objections.
Board? Seeing none, please proceed.
Thank you. I also want to confirm that the board received the supplement to Exhibit J that was filed on Monday. I believe that was approved as well.
Yes.
All right, thank you. All right, and as my normal practice, I will be moving for admission of all exhibits at the end of our presentation in chief.
Thank you.
Today, members of the board, Uinta Wax is before you seeking approval of the conversion of several existing overlapping two-sectional long lateral drilling units to two overlapping three-sectional laydown for extra long lateral wells or over 15,000 feet in length. These drilling units are located in Duchesne County. As the board just heard and is aware, the current trend for lower Green River Wasatch production in the Uinta Basin is to drill 15,000 foot or longer horizontal wells. To facilitate that, Uinta Wax is seeking to vacate 5 existing two-sectional drilling units under which long lateral horizontal wells have yet been drilled, as well as the associated overlapping internal drilling unit boundary well drilling units, and in lieu thereof establish the 2 three-sectional laydown drilling units. Uinta Wax is seeking authorization to drill up to 20 of those 15K wells on the requested drilling units with heel-toe setbacks of 100 feet and perpendicular setbacks of 330 feet and the other standard caveats that you're usually approve. This requires a partial vacator and modification of the applicable existing board orders entered in cause numbers 139-151 and 130-12. True and correct copies of the 139 and 139-151 and 130-12 orders were collectively submitted as Exhibit B in this cause. As the Division's counsel astutely pointed out, some clarification of the request for agency action is required. Specifically, Sections 17 and 20 and Sections 18 and 19 of Township 4 South, Range 5 West were erroneously identified as being established as stand-up drilling units under the 130-12 order. However, they were instead established under the 139-151 order. Furthermore, the status of the Section 15 through 18 with respect to longer lateral development, as well as the status of the associated internal drilling unit boundary well drilling units comprised of those former stand-up units, may be unclear from the request. However, the request is very clear that Uinta Wax has requested that the 139-151 and 130-12 orders be partially vacated and modified to the extent inconsistent with the relief requested. In other words, the establishment of the 2 three-sectional drilling units is what is being requested, and notice was given to the production interest owners in those other drilling units that are to be partially vacated without objection. In that regard, if and when Uinta Wax desires development of Sections 15 through 18 with long lateral horizontal wells, it will seek establishment of them either as 2-sectional or as part of 3-sectional drilling units, depending on the success of this long lateral horizontal or extra long lateral horizontal well development with these two drilling units that are requested today. The board has jurisdiction over this matter pursuant to Utah Code Sections 40-6-5, subparagraph 3B, and 40-6-6. Notice was sent via regular mail to all production interest owners within the newly requested three-sectional drilling units, as well as sections 15 through 18, to all working interest owners, including any unleased owners in the surrounding drilling units, and to the Bureau of Indian Affairs, the Vernal Field Office of the Bureau of Land Management, the Ute Indian Tribe, and the Ute Distribution Corporation due to the tribal and/or allotted mineral ownership throughout. The mailings were sent to these parties at their last addresses disclosed by the relevant BIA and Duchesne County Realty records. The record will also reflect that notice was duly published in the Uinta Basin Standard on October 1st and in the Salt Lake Tribune on October 5th. On October 8th, the division timely filed a response to the request for agency action, stating that the division does not oppose the granting of the relief requested, presuming Uinta Wax satisfies the burden of proof at this hearing, specifically including how sections 15 through 18 and the associated internal drilling unit boundary well drilling units would be addressed. As today's testimony will reflect, Uinta Wax will sustain that burden. No other objections or responses were received, and no other party has made an appearance today. With that, I'll conclude or commence my examination of Mr. Archer. Mr. Archer, would you please state your name and business address for the record?
Zachary Archer, 6000 Western Place, Suite 1000, Fort Worth, Texas, 76107. I'm senior landman for Uinta Wax with land supervision over the area at question.
All right, for the record, would you please state the corporate and bonding status of Uinta Wax?
Uinta Wax is a Delaware limited liability corporation in good standing with its principal place of business in Fort Worth, Texas. We're duly authorized to conduct business in the state of Utah and are fully bonded with all relevant state, Utah, and federal agencies. It is the designated operator. We're the designated operator of Uinta Wax LLC.
All right, I'm going to show you, and hopefully you can see it on your PowerPoint, or you should have these in front of you with a physical copy of it.
Yes, I'm looking at it.
Okay, exhibits C, D, E, and F, were these prepared by you or Uinta Wax personnel with your input and review?
Yes, sir. Yes, sir.
All right, turning to Exhibit C, would you please explain to the board what this represents?
So Exhibit C is the regional locator map and notice plat. These are the lands that are subject to this RAA and are located approximately 5 miles southwest of Duchesne, bisected by Highway 191 through Indian Canyon. The red and green outline are the extra long lateral horizontal DSUs subject to this application. The blue outline is the notification area.
In other words, the blue area are all the working interest owners that were notified?
Yes, sir, including sections 15 through 18.
All right, thank you. Now turning your attention to Exhibit D, would you please explain what this shows?
So this is a plat of the drilling units subject to the RA and corresponding ownership. This reflects the 2 requested 3-sectional DSUs. Minerals are all tribally owned or under EDA or leases already earned or to be issued by the tribe.
All right, and who is the majority working interest owner in each of those drilling units?
Uinta Wax is the majority working interest owner in those lands that are subject to this RAA.
All right, now turning your attention to Exhibit E, would you please explain what this shows?
So this plat identifies the existing wells in the subject lands. This identifies that no extra long laterals have been drilled on any of the existing DSUs established under the 131, 151, and 130-12 orders.
And turning your attention now to Exhibit F, would you please explain what this shows?
So this plat reflects the nearby lands where the board has established overlapping 3-sectional DSUs for extra long horizontal wells.
And so you're just being consistent with what the other operators in this area are requesting or have been approved by the board, correct?
Yes, sir.
Okay, I'm going to ask you now to turn your attention to the certificate of service in this matter. You should have a hard copy in front of you. This is a pleading already on file in this matter prepared by my office. Do you recognize the parties and addresses shown on that?
Yes, sir.
Are those parties the parties shown that you talked about on Exhibit C in both the drilling units
sir.
and the blue area.
Yes, sir.
And those are all the parties that received a copy of the request for agency action?
Yes, sir.
All right, how are those names and addresses derived?
Those were derived from our internal land records, including title opinions, search of the VI and Duche County records, as well as our contracted land services companies.
All right, and for the board's information, this was sent regular mail, not certified mail, so there's no Exhibit Z involved with this. With that, that concludes my examination of Mr. Archer.
Division, do you have questions?
Yeah, just a clarification. Sorry, you may have answered this, but I may have missed it. You indicated that you notified working interest owners in the blue area. Did you also
Yes,
notify, does that include unleased mineral interest owners when you say working
Yes,
interest
sir.
owners? Okay.
Yes, sir.
Yeah, no further questions. Thank you.
Board, do you have questions for this witness? Mr. Church?
Yes, Mr. Archer, just want to clarify, there have been no stand-up 2-mile wells drilled in 15, 16, 21, and 22. Is that correct?
Yeah, that is correct.
Thank you.
I'm sorry.
Any other questions from the board?
I'm sorry, no questions.
All right, thank you. With that, I'll commence my examination of Mr. Horner. Mr. Horner, would you please state your name and business address for the record?
My name is Robbie Horner. My place of business is at 6000 Western Place, Suite 1000, Fort Worth, Texas 76107, and I'm a senior geologist with UNO Wax LLC, working the area at issue.
All right, I'm going to show you what have been marked as Exhibits G, H, and I. Do you recognize these exhibits?
Yes.
Were they prepared by you or UNO Wax personnel with your review and input?
Yes.
All right, let's go back to Exhibit G. If you'd please explain to the board what this shows.
This is a type log. It's the same log that we've used in many of our orders for its definition of the Lower Green River Wasatch throughout the basin, including 139, 151, and 130-12 orders.
All right, now turning your attention to Exhibit H, would you please explain what this shows and its significance to today's hearing?
This is a cross-section going from west to east across the 2 DSUs that we are requesting about. It reflects the undeveloped shallow zone potential and uniformity throughout the area. Thus, these are attractive zones for extra long horizontal well development.
All right, now turning your attention to Exhibit I, would you again please explain what this shows and its significance to today's hearing?
This is a regional stress map. Within the area, we have a regional fracture orientation of north 5 degrees west, which supports laydown DSU orientation and reduction of setbacks, as will be addressed by Mrs. Bridwell.
All right, as the division has requested, with the vacator of the existing stand-ups involving sections 15 and 18, can you please outline how does UNO Wax intend to develop those if those stand-up drilling units are vacated as we've requested?
Yeah, we hope to replicate the successes that our offset operators have had in this area, and in the event that we do have successful, we will respace these likely as 3-mile horizontals as well.
So sections 15 through 18 won't be undeveloped by the vacating of the existing stand-ups, is that correct?
We will not strand those, no.
All right, great. All right, is it your expert opinion then that the uniformity of Lower Green River Wasatch members are a common source of supply and, as throughout this area, make the 15K wells attractive, particularly as to undeveloped shallower zones?
I do.
And is it also your expert opinion that the stress orientation supports a laydown drilling unit orientation?
Yes.
All right. Madam Chair, that concludes my examination. Mr. Horner?
Division, do you have questions?
Thank you. No questions with this witness.
Board, do you have questions? Mr. Moon?
So this stress map that we're looking at in the request area has arrows going both directions. How come?
This is a map that we've used before. You might recall that we had a protest with Oviniv that we unsuccessfully protested about spacing in this area, and with the addition of their data it is a transition zone through this area, and we are honoring the data that we have that shows that, but we do believe that this is a strong contender for laydowns as opposed to stand-ups.
Okay, it's a transition area. That's why you have them going both ways. But you
Yep.
predominantly north-south, though.
Yep.
Okay.
Any further questions from the board? Please proceed.
Thank you, Madam Chair. With that, I'll commence my examination. Ms. Bridwell. Ms. Bridwell, would you please state your name and business address for the record?
Yes, Kayleen Bridwell, 6000 Western Place, Suite 1000, Fort Worth, Texas, 76107. And I'm a senior engineer, ESG advisor, and regulatory manager working the area at issue.
All right, I'm going to show you what have been marked now as Exhibits J as supplemented and K through M. Do you recognize these exhibits?
Yes.
Were they prepared by UNOWAC's personnel with your review and input?
Yes.
All right, starting with Exhibit J as supplemented, let's start with the first page of Exhibit J, and please explain what this shows.
We're looking at our 100-foot setback here. Hold on just a second. Sorry, let me scroll up to my page there. And this is based on prior exhibits that our fracture orientation and the larger avenue fracture half length reflects significant areas of resource that could be recovered with reduced setbacks without adversely affecting correlative rights. So on this one, it's showing that we aren't reaching the 100-foot on the heel toe for a reduced setback.
All right, and then the second page, which was a supplement, similar exhibit, but this is relating to the perpendicular setback. Is that correct?
Yes. So this one is just showing that we are not reaching 300 feet on the other side for the setback.
All right, now turning your
And we're
attention.
still,
Oh, go ahead. I'm
leaving
sorry.
a little bit of room. Sorry.
No, go ahead. Repeat what you were saying.
Oh, I was just saying, and we're still leaving a little bit of room too. So we're not like right up against the boundary.
All right, now turning your attention to Exhibit K, would you please explain what this shows?
This reflects the potential for extra long horizontal well development in each member of the Lower Green River through the Wasatch in a wine rack formation, up to 20 extra long horizontal wells that we have planned. And it may include up to 4 wells in the Douglas Creek.
And that's that upper zone that wasn't originally intended to be developed, right?
Correct.
Okay. Now turning your attention to Exhibit L, would you please explain to the board what this shows and its significance to your request?
Yes, this is the Helen Evers drainage calculation that we've established before in prior hearings. This methodology was this is what we've previously utilized. It's showing that the results, there won't be any drainage of the adjacent lands even after 40 years with the 100-foot and 330 setbacks.
All right, now turning your attention to Exhibit M, please explain what this shows and its significance to your request.
This is our well economics, and well economics clearly favor drilling extra long horizontal wells and the requested and at the requested setback reductions.
All right, is it your expert opinion then that the reduction of the setbacks and the drilling up to 20 15K wells in each drilling unit are necessary to recover additional resources that would otherwise be left in the ground?
Yes.
Is it also your expert opinion that the will allow the greater recovery of natural resources with associated greater economic benefit without adverse impact on adjacent correlative rights?
Yes.
All right. Madam Chair, that concludes my examination, Ms. Bridwell.
Division.
No questions for this witness. Thank you.
Board, Mr. Moon.
So on Exhibit I, the next one, J. Okay. So you mentioned it was a transition area. I would expect your angle there to be more of a 45 versus up and down. Can you explain that?
Would you want
Then the
Mr.
5 degree,
What's that?
I think that was, is that what you're asking?
Yeah, the whatever you call it, the natural fracture.
Right, the
The
orientation.
natural, the
Orientation,
average
yeah.
fracture orientation?
Yeah.
Our data suggests that this is a 5 degree.
Oh,
So,
okay.
which I think was shown, and Robbie can jump into on this
Okay.
question. So it was shown, I know it's showing both directions, but our internal data is showing a 5 degree.
Okay.
That's what Mr. Horner was answering your
Yeah.
previous question.
Yeah.
Okay.
Mr. Church?
So this is probably for Mr. Horner. Perhaps looking at Exhibit I, where we see those two stress locations, were that data taken in the actual wells at those locations?
Yes, sir.
And how was the data? Was that FMI, microseismic? How did you obtain that data?
Off of the top of my head, I don't actually know. That was something that we inherited. I would have to look at that to get a better idea.
Okay, but it's data that actually UNOACs obtained themselves rather than from the literature. Is that correct?
Yeah, it's there are two studies that we had run back in 2023 on a reinterpretation of data that we had inherited when we bought the asset.
Okay, thank you.
Mr. Walker?
Yes, can we go back to the gun barrel? I think that's K.
Mm-hmm.
Okay, so on this, you're doing 4 wells per horizon, except for the last 2. Can you tell me why there's only 2
So there
horizontals in
isn't
the
a,
upper and lower?
yes,
Wasatch?
I can. Thank you for your question. There is not a significant barrier between that upper and lower Wasatch, and therefore, based on reserves and experience, we only put 2 in the upper and 2 in the lower to effectively drain the whole of the Wasatch.
Okay, and what's the H in upper and lower Wasatch, roughly?
In this
Your,
area,
uh,
Robbie,
your-
do you know
your thickness?
the height of the upper and lower?
That's a bit of a nuanced question just because the Wasatch is a bit more variable. And so upper targets and lower targets can move around depending on what sand bodies you're chasing. But it is, the upper Wasatch we generally consider to be the top 200 to 300 feet of it.
Okay. So with a, so you
And
might have,
just one
it
thing-
might come back at a later time if you know something different, I guess.
Yeah, and that's one thing in, filing these, it's very intentional that we put potential full development just for the fact that we don't want to be beholden to, drilling targets and overextending ourselves or underdeveloping things. We want to make sure that we have the well counts that we want and the freedom to do which targets we feel are the best.
Okay, fair enough. Thank you.
Any further questions? Seeing none, please proceed.
Thank you, Madam Chair. With that, I would move for admission of Exhibits A as supplemented, B through I, J as supplemented, and K through M inclusive.
Division, any concerns?
No objections.
Board, any objections? Seeing none, so admitted.
Thank you, Madam Chair. With that, I'll reserve my comments until after the division stated its position.
Okay, Division?
Thank you. As was stated initially, the division filed a response as it had concerns to the sections 15 and 16 as they related to 4 South 5 West as they were still in a stand-up orientation. But based on the discussions with council and the testimony given today, the division satisfied with the request upon the vacation of those units. And with that, we have no opposition to the request. Thank you.
Board, do you have any questions before we vote? Are we ready for a motion? Mr.
I move
Galecki?
we accept the request for agency action as proposed.
And a second?
Second.
Been moved and seconded. All in favor, please say aye.
Aye.
Any opposed? Motion has been approved. If you would please prepare the order.
I will, Madam Chair, and I'll make sure the council receives that before we submit it for entry.
Thank you.
I thank also the board and the IT people for allowing that virtual appearance.
Thank you.
Thank you.
And
Thank you.
Thank you.
We are moving on to 4 Point. Is that also you, Mr. McDonald? I'll give you a chance to get organized here.
In that order?
Yes.
Clint Zerman. Okay, thank you.
Oh, good. I thought you were leaving us. I was going to say that's not allowed on your first time. You have to stay for the entire hearing, down to the last adjournment. I'm going to go ahead and read the intro. Docket number 2025-051, cause number 130-43. In the matter of the request for agency action of 4 Point Resources, LLC, for an order modifying the board's orders entered in cause numbers 139-134 and 130-07 to 1, reduce the heel-toe setbacks from 330 feet to 100 feet for the drilling units comprised of sections 29 and 32 and sections 30 and 31, 3 south, 2 west, USM, sections 5 and 6, sections 7 and 8, township 4 south, 3 west, USM, and 1 and 2, and sections 11 and 12, 4 south, 4 west, USM, respectively, and 2, eliminate the 330-foot setback from the Dominica 1-11-4-4 WH well, all in Duchesne County, Utah. Please, appearance of counsel.
Fred McDonald of counsel with Lear & Lear on behalf of petitioner 4 Point Resources, LLC.
Division.
Assistant Attorney General Nico Micheletti on behalf of the division.
Thank you. Ms. McDonald.
Thank you, Madam Chair. With me appearing virtually pursuant to the board's order on the 14th of October are Mr. Clint Cook, Senior Landman, Ms. Sarah Smaltz, the Senior Geologic Advisor, and Mr. Brett Kovach, the Senior Reservoir Engineer. I would ask that the Vice Chair swear them in at this time.
Please raise your right hand. Do you swear that the evidence you're about to present is the truth, whole truth, and nothing but the truth, so help you God?
I do.
I do. I do.
Okay, thank you.
Madam Chair?
Yes.
Oh, I need to disclose that my family has interest in the laydowns, and but I'd like to fully participate in the hearing.
Do you have any objection
No
to that?
objection.
Thank you.
The resumes of all 3 witnesses were collectively submitted as Exhibit A in this cause. If separately asked, they would verify the contents of their resumes are true and correct. Mr. Cook will be a fact witness only. Ms. Smaltz and Mr. Kovach have been previously recognized by the board as experts in geology and petroleum engineering, respectively. Based on their resumes and presuming the division has no objections, we request that they again be so recognized in those disciplines for purposes of this cause.
Division.
No objection.
Board, so accepted.
Thank you, and again, I will be moving for admission of the exhibits as a whole at the end of our presentation in chief.
Thank you.
Members of the board, 4 Point is before you today seeking reduction of the heel-toe setbacks for horizontal wells from 330 feet to 100 feet for 6 previously established drilling units located in Duchesne County. This requires modifications of 2 board orders, the 139-134 order and the 130-07 order, under which those drilling units were established and which originally established the 330-foot setbacks. True and correct copies of the 139, 134, and 130-07 orders were collectively submitted as Exhibit B in this cause. As the testimony will reflect, such reduction not only results in additional resource recovery that would otherwise be left in the ground, but also does not adversely affect the correlative rights of the production interest owners in the adjacent lands for at least 10 years and only minimally, if at all, thereafter. As the board is aware, it has previously granted such relief in many other areas of the basin, and this is the trend requested by nearly all of the operators in there with respect to horizontal well development. As you will hear on one of the existing laydown drilling units, there is an existing short lateral horizontal well that was drilled pursuant to a prior order that has a north-south orientation. The 130.07 order expressly requires any new long lateral horizontal well to be at least 330 feet laterally from that existing well. However, for the reasons you will hear today, 4 Point is also requesting elimination of that particular inner well setback. The board has jurisdiction over this matter pursuant to Utah Code sections 40-6-5 subparagraph 3B and 40-6-6. Notice was sent via regular mail to all working interest owners within the 6 drilling units, to the working interest owners, including unleased owners in the established drilling units adjacent to the affected areas due to the requested setback reductions, and to the Ute Tribe, Ute Distribution Corporation, Bureau of Indian Affairs, and the BLM due to the tribal ownership, and to the Utah Department of Transportation and the Division of Forestry, Fire, and State Lands due to state ownership. The mailings were sent to these parties at their last addresses disclosed by the relevant agency records and the Duchesne County Realty records. In addition, notice of the filing of the request in this hearing was also duly published in the Uinta Basin Standard on October 1st and in the Salt Lake Tribune on October 5th. On October 8th, the division filed a response expressing no opposition to the granting of the request, presuming 4 Point meets its burden of proof, as we will do today. No other objections or responses to the request were filed, and no other party has made an appearance today. With that, I'll commence my examination of Mr. Cook. Mr. Cook, would you please state your name and business address for the record?
Yes, Clint Cook, 4 Point Resources, LLC, at 100 St. Paul Street, Suite 400, Denver, Colorado, 80206.
And what is your current position with 4 Point, and how does it relate to these 6 drilling units?
I'm a senior landman overseeing this area.
All right. For the record, would you please state the corporate and bonding status of 4 Point?
Sure. 4 Point is a Delaware limited liability company with principal place of business in Denver, Colorado. It is the successor by assignment to Ovintiv USA Inc., successor by name change and merger to Newfield Production Company. 4 Point is duly qualified to conduct business in the state of Utah and is fully and appropriately bonded with all the relevant state of Utah agencies.
All right, I'm going to show you on the PowerPoint, and hopefully you also have hard copies of these exhibits. Exhibits C, D, E, F, G, which is a 2-page exhibit, and H and I. Do you recognize or not I, excuse me, H. Do you recognize these exhibits?
I do.
And were they prepared by you or 4 Point personnel with your review and input?
They were.
All right, turning your attention to Exhibit C, would you please explain what this shows?
Sure. This regional locator map showing the DSUs at issue. Here, it shows the 2 stand-up DSUs in blue there, approximately 3 miles west of Mighton, and then 4 miles west of those along US 40 are the 4 laydown DSUs shown in red.
Okay, turning your attention to Exhibit D, would you please explain what that shows?
Yeah, this is, again, just an identifier of the 6 DSUs at issue here with their names. Of note is the Wolf DSU in the southwest there, where the existing north-south short horizontal well that Mr. McDonald discussed is located.
All right, now turning your attention to Exhibit E.
Yes, this is a mineral ownership type breakdown by DSU, displaying that the vast majority of this is fee or Indian minerals with a sliver of state minerals located in the LaPrade DSU.
Okay. And this is, Madam Chair, this is in response to your request to show what the mineral ownership was.
I was going to ask for it.
There it is.
Okay, turning now your attention to Exhibit F, would you please explain what this shows?
Sure. So F is working interest breakdown in each DSU, just displaying that 4 Point is a vast majority working interest owner in each of the DSUs.
Okay, now turning your attention to Exhibit G, let's start with Exhibit G1, the first page of that exhibit, and please explain what this shows.
G1 is the two stand-up DSUs with existing wells on the plat, noting that conversion has occurred in the Far F West DSU, sections 29 and 32, but has not yet occurred in the Murphy DSU, sections 30 and 31.
All right, and the second page of Exhibit G, would you please explain what this shows?
Yes, this is the 4 laydown DSUs where conversion wells have been already drilled in each of those. Noting the Domingue well in the Wolf DSU and its north-south orientation. This is the short lateral horizontal well from which 4 Point seeks elimination of any interwell setbacks for reasons that Mr. Kovach will address later. With conversion, production allocation of all the wells in the Wolf DSU is the same, and consequently no adverse impact upon the correlative rights of the owners in the Domingue well should result from elimination of that interwell setback.
Okay, and finally, turning to Exhibit H, would you please explain what this shows?
Yes, Exhibit H is just a plat showing the DSUs at issue, and then in green is all DSUs where the board has already approved 100-foot heel-toe setbacks.
All right, now I'm going to ask you to refer to the certificate and supplemental certificates of service that were filed in this matter. You should have hard copies in front of you.
Yes.
These are pleadings already on file, prepared by my office. Do you recognize the names and addresses on that?
Yes.
And who are those parties and how are those names and addresses derived?
So these are parties and addresses that were compiled from 4 Point's internal land records, including title opinions, search of the BIA, DFFSL, and Duchesne County records prior to filing the RAA. And this work was done with our oversight by Lone Wolf Energy, who is 4 Point's contracted land service company.
All right, and just to clarify for the record, that includes all the production interest owners in the 6 drilling units, correct?
Yes.
And all of the adjacent or working interest owners, including unleased owners in the adjacent areas because of the requested setback reduction?
Yes.
All right. And again, to the board, these were mailed regular mail, so there's no Exhibit Z involved here on this one. With that concludes my examination of Mr. Cook.
Division, do you have questions?
No questions. Thank you.
Board, any questions? Please proceed.
Thank you, Madam Chair. With that, I'll commence my examination of Ms. Schmaltz. Ms. Schmaltz, would you please state your name and business address for the record?
Yes, Sarah Schmaltz, 100 St. Paul Street, Suite 400, Denver, Colorado, 80206.
And what's your current position with 4 Point, and how does it relate to these drilling units at issue?
Yes, I'm the Senior Geologic Advisor overseeing these DSUs at issue.
All right. Ms. Schmaltz, I'm going to refer you to Exhibit H, which Mr. Cook just testified to. These are all the areas, as he testified, where the board has allowed for the reduction of the heel-toe setbacks. Are you familiar with the geology in these areas as well?
Yes, I am.
And would you say that they have similar geologic characteristics to the 6 drilling units at issue here?
Yes, they have similar, overall they have similar geologic characteristics, and across this area, our main geologic targets for horizontal development in the lower Green River and Wasatch formations are continuous.
And the only geologic difference that might be variance is because of this transitional area where the fracture orientation differs because of the different orientations of the drilling units, correct?
Correct. That main difference is the shift in that maximum horizontal stress direction as we move from east to west across this area, which we're going to be addressing in more detail in the next exhibit.
Okay, let's go to that next exhibit. This is Exhibit I. Was this prepared by you or 4 Point personnel with your review and input?
Yes, sir.
Okay, would you again please explain the significance of this exhibit to the board?
Yeah, Exhibit I displays our interpretation of the maximum horizontal stress direction across this area of interest. The interpreted contours are shown in blue, and the individual observed stress indicators are shown with the black arrows. As seen in this exhibit, the average stress direction in the vicinity of the Bar F West and Murphy DSUs, which are highlighted with the blue rectangles, is north 65 degrees west, which supports their stand-up orientation and is similar to the adjacent DSUs for which reduced setbacks have already been approved. When we look to the west at the remaining 4 DSUs at issue, we observe an average stress direction of north 10 degrees west, which supports their laydown orientation. And again, the north 10 degrees west horizontal stress direction is a similar orientation to the adjacent DSUs to the north and the south where reduced setbacks have already been approved as well. We also show on this exhibit with the blue star and the red star the 2 PVT data points utilized for our drainage calculations, which Mr. Kovach will address in the following exhibits.
All right, is your expert opinion then, except for the transitional fracture orientations, the lower Green River Wasatch geologic characteristics of the 6 drilling units at issue are substantially similar to those of nearby lands where the board has already authorized reduction of the heel toe setbacks to 100 feet?
Yes.
All right, Madam Chair, that concludes my examination of Ms. Schmaltz.
Division, do you have questions?
No questions.
Board, do you have questions? Seeing none, please proceed.
Thank you. With that, I'll commence my examination of Mr. Kovach. Mr. Kovach, would you please state your name and business address for the record?
Yes, it's Brett Kovach, and business address is 100 St. Paul Street, number 4, Suite 400, and that's Denver, Colorado, 80206.
And what's your current position with 4 Point, and how does it relate to these drilling units?
Yep, current position is senior reservoir engineer, and I'm overseeing these DSUs at issue.
All right, I'm going to show you what have been marked as exhibits J, K, L. Do you recognize these exhibits?
Yes.
Were they prepared by you or 4 Point personnel with your review and input?
Yes.
All right, starting with exhibit J, which is a 2-page exhibit. Let's start with the first page, and please explain what it shows.
Yeah, so J1 and J2 are both schematics of our estimated fracture half length at year 5. And so that's kind of using the Halen-Evers equation that the board has seen before, and also leveraging the maximum horizontal stress direction that was shown on exhibit I. And so we can see that the calculations are indicating that with a 100-foot setback, there will be no drainage of the adjacent lands at the north 65 west fracture orientation for the stand-up DSU. And then on the laydown DSU, it's the same deal where at the north 10 west fracture orientation, we would not expect there to be drainage of adjacent lands.
All right, now turning your attention to exhibit K, again starting with the first page, please explain what it shows.
Yes, so both K1 and K2 are going to be showing the drainage calculations utilizing the Halen-Evers equation, which we've shown before and been deemed acceptable. So the parameters that are going to be shown here are from the subject area that Sarah showed in exhibit I. So for this one in particular, we're looking at K1, that's going to be the new to Veep 15H well, which is a Wasatch 5 well, and that's going to be used for the stand-up DSU. And for the laydown DSU, it is the Alice 13.743.18.19.7H. And what we're going to see here is that in both of these cases, our calculations suggest that there will be no drainage of adjacent lands at year 5 and minimal, if any, drainage at year 10 and beyond.
All right, now turning to the issue of the Dominique well, the north-south well existing in the Wolf DSU in Exhibit L. Would you please explain what this shows and its significance to that well?
Yes, so here we're looking at two recent cases where 2024 laydown DSUs were drilled and then hydraulically fractured perpendicular to a legacy stand-up well. So in both of these cases, the Stanley DSU and then the Elton Blackhair DSUs, we observed an uplift in performance on the original north-south legacy well. So in the Stanley DSU, we're seeing about a 35 to 40 barrel per day uplift on the Ute Tribal 413-34WH. And in the Elton Blackhair DSU, there was an observed uplift of around 15 barrels a day on the Ute Tribal 411-1234WH. So what we're seeing here is that the recent cases that we've done this same thing suggest that, if anything, there will be a positive impact to the Domingue well from drilling and completing these laydown wells in the Wolf DSU. And additionally, we take the anti-collision risk, very seriously for all wells, and will of course take the necessary precautions to avoid any collision with the Domingue well.
Okay, and as a reminder again, the Wolf DSU is already converted so that the allocation, as Mr. Cook testified, of the Domingue well will still be the same anyways. It'll be on the same basis. All right, is it your expert opinion then that the requested setbacks are necessary to recover additional resources that would otherwise be left in the ground?
Yes.
Is it also your expert opinion that the requested setbacks should not result in adverse drainage or waste and will be protective of correlative rights?
Yes.
Finally, is it your expert opinion that elimination of the interwell setback from the Domingue well will not result in adverse impact upon the correlative rights of the parties in that well?
Yes.
All right. With that, Madam Chair, that concludes my examination of Mr. Kovach.
Division, do you have questions?
No questions.
Board, do you have questions? Mr. Walker?
Yeah, Mr. Kovach, on Exhibit L here, how long do you have any anticipation of how long that uplift is going to be? Is that going to be sustained, or do you have any evidence so far as if this is long-term or just because of shut-in period or whatever?
Yeah, so, we're looking at a little bit around a year right now, and it's been pretty much sustained that entire time. One thing to note, like these wells were relatively low producers to begin with. So, I would imagine that over time, that kind of incremental uplift will, they won't produce 15, 35 to 40 barrels a day forever. So I think we'll see that number kind of come down, but it does look like it was a, positive impact to the estimated ultimate recovery of those two wells.
Yeah, because you're going like from 6 barrels to 40 barrels. That's pretty darn significant. On the 4-1 well, you did have about 35 barrels prior to that during one period. Do you know what accounts for that? That one tick where the arrow comes in?
Yeah, that one tip where the arrow comes in, you can see the two gray lines that are above that. I apologize, I should have called that out.
Yeah.
That's when those are the Elton Blackhair wells came online. So that one tick up is actually when should be post-frac for those wells. So I think that should be associated with the kind of completion of the Elton Blackhair wells.
Okay. Okay, thank you very much.
Board, do you have any other questions? Mr. Moon?
Just another question about that. Explain why you believe there is an uptick, and then secondly, do you think there's somewhat of a equal detriment to the horizontal well, losing some of the frac into that vertical well?
Yeah, so I think if we consider the kind of completion design of these, original north-south wells, so the 4WH, so the one on the left there, that was a 2013 vintage, right around 400 pound per foot completion design. And I think it had cumed right around 41,000 barrels to date. And then the one on the right was similar. It was actually smaller completion. It was around 300 pounds per foot. And it was a 2 mile well, so it had cumed around 90,000. And, I think when we consider the kind of SH max here and how these fracks would travel, they really would have been they were just far from being optimally oriented. So rather than getting like a transverse fracture on those early wells, you got more of a planar fracture on those early wells. So I think that, drastically impeded their ability to contact the reservoir. So I think part of the reason they see the uptick is when we come back in these modern wells and pump a, modern job, I think you're just stimulating the reservoir quite a lot and kind of opening up additional, pathways for oil to flow into these existing wells. And, as for the impact to the horizontal wells, we haven't seen the depletion be really a problem for these horizontal wells. But there's just a lot of variability in horizontal well performance in general. And I'm not sure that if this was going to impact it, we'd probably be looking at impacting one or two stages. And I don't know if the general variability in well performance probably exceeds that with what we'd be able to tell from, an impact for one or two stages, if that answers your question.
Yeah, because you have no idea where the oil's coming from, which stage it's coming from, correct? I mean,
yeah,
or do you?
We tend to, it's definitely not, is it this particular stage or not? We do as a practice generally pump tracers at the toe to make sure that the wellbore is contributing from the toe of the wellbore. So I guess if you see the toe tracer coming back, that gives you a good indication that the entire wellbore is producing. But to your point, it would be really challenging to isolate and say that this particular stage is giving us X percent without, some additional diagnostic.
Mm-hmm. Thank you.
Mr. Church.
Just as a follow-up on that, do you protect by not perforating when you get close to that wellbore of the pre-existing well?
Yes, I believe we do. Yes. And we'll certainly shut that well in during completion as well.
Okay, thank you.
Seeing no other questions, back to you, Mr. McDonald.
Thank you, Madam Chair. That concludes our presentation in chief. At this time, I would move for admission of exhibits A through L inclusive.
Any objections?
No objection.
Board? No objections, so admitted.
Thank you, Madam Chair. With that, I'll reserve my comments after the division.
Okay, division?
Upon the review of the exhibit submitted by the petitioners and the evidence presented today, the division has no opposition for the board to grant this request. Thank you.
Board, do you have any follow-up questions? Do we need to deliberate or are we ready to vote? Do I have a motion?
I'll make a motion to approve the request for agency action as requested.
And a second? It's been moved and seconded. All in favor, please say aye.
Aye.
Any opposed? The motion carries.
Thank you, Madam Chair. I'll prepare the order and I'll make sure that council has an opportunity to review it. And again, thank you for your time and attention, and thank the IT people again for the virtual appearance of the witnesses.
Thank you.
Thank you.
Thanks.
Okay, let me ask you.
Well, their exhibits just weren't as thorough.
The board is going to break for about 10 minutes.
Okay.
We'll be back at 3:10. Yeah. Yes, we're going to do bond forfeiture.
Should we do 8 and 12?
one.
We are back on the record. Moving on to our next item. We're going to jump ahead to item number 12, which is docket number 2024-074, cause number 076-05. In the matter of the notice of agency action requesting the board issue an order forfeiting the bond covering wells and facilities identified, and that we have several API numbers. I'm not going to read them all. And directing the division to orphan, plug, and or reclaim the well sites and facilities. And I'd just like to say, in the captions of these matters, if you would include the well name, other than when there are so many like there are on this one, it would be helpful. The board, we need to address the respondent, the Dean Carlisle Shimon Trust motion for extension of deadline on the February 5th, 2025 order granting relief requested in the division's notice of agency action. We will turn now to the Shimons.
Could you turn your microphone on, please?
Do they have, I think we only have one here.
Attorney Donald Ray for the Shimon Trust. And
could you move the mic in front? These don't record very far. Oh, there you go. Just move it closer. Thank you.
And Heidi Shimon, trustee for the trust. And we've been working with the division, and I think they filed a response to our motion stipulating to the May 5th extension for the trust to obtain a operator for their field. I think the only caveat there would we request that the May 5th extension be granted, and then subject to weather permitting for us to get in. Hopefully we'll have an operator that's bonded and ready to move forward at that point, but weather permitting, they may need to have additional time at that point to be able to actually get in and make sure all the wells are open and operating depending on snow conditions.
Do you have a length of extension you're going for? Is it open-ended here, or?
No, just so the May 5th, I think we'll have an operator in, bonded, and hopefully
Okay.
worked through all anything that's outstanding to get approvals to move forward, and hopefully weather permitting, they can get in and facilitate whatever needs to be done at the site. But some springs, the snow's still 15 feet in May, so it just depends on what we get this winter.
Division, do you have any comments?
Not specifically. I mean, the motion was filed to allow a longer time to get a responsible operator on site. In as much as they need that time, the division doesn't have a problem. To have kind of open-ended, I mean, I don't know that we need a time frame like that. I think by May, if they have an operator and he's ready to go, we're not going to plug the wells. So I don't know if we need an extension beyond that time. I think it'll be pretty clear at that time where the status is and how that's going to go forward.
And so what happens to the wells in the interim? Are they all shut in?
My understanding is tomorrow, on October 23rd, the division inspectors will go in and make sure that they're completely shut in and good to go for the winter.
And do you have an operator lined up, or are you
We
considering
do have a
operators?
couple of different ones doing some additional due diligence, but really close to have one lined up, yes.
Board, do you have questions for these folks? Mr. Church.
So with does the Shimon Trust own a majority of the royalties in here, or?
They own the land, the facilities, and a number of the wells. There's a couple of other well owners that we're working with. Hopefully, have the same operator run everything. And so, no, they don't own all of them, but we are working with the other landowners to try to have a joint operator running everything.
Okay.
And so do you have mineral interests?
Correct.
Okay, okay. Ms. Walker?
Yes, so is the intent to get an operator to operate the field or to plug and abandon all the wells? Or
No, to operate, yeah.
operate? Okay, thank you.
Do we have any further questions? Mr. Moon?
So, do you know the current bonding status of the wells? And then to the division, if they do find a new operator, I guess our old bonding rules would apply. Would that be an improvement, or hopefully an improvement over the existing bonding? Just kind of
Yeah, I'll let Megan talk to that.
Yeah, currently, if we would not have it at $120,000, we would have additional bonding. Kind of depends on the operator. You know, if it's a larger operator that already has a ton of wells in the basin, and we'd have some negotiations. If it's a newer operator, we would go closer, a bit higher than that to reduce the liability for the state.
Okay, so it'd be a positive for the state too, for risk-wise.
Yes.
But hopefully, this new operator operates the wells, makes money, saves it, and when they're done, plugs and abandons. So, which you're you're surface owner also? Okay, so that'd be a good thing for you too. So good.
Yeah, we do. We own the processing center, the pipeline, the gas sales line. Oh, I'm sorry. Yes, in answer to your question, we do. We own the facilities, the processing center. We own the underground pipe sales line, the gas line, and then the 4 of the 26 wells that are part of the production. So
when
we
you
own the
say you
mineral and
own
the
the
surface.
well, what do you?
I'm sorry. We have 4 wells in the project. Sorry.
Okay.
Of the 26.
But you actually own some of the gathering lines, you're saying?
Yeah, yeah. And the network and everything involved in it. So
Okay, you just need somebody to operate it.
just need a new operator to come in and help us go forward. The great thing about it is we met with our geologist that was in the early days. The very first gas company that came was in 1989 and has gone forward. And so one of our early day geologists, we met with him yesterday, and their studies have proven that there's 2 trillion cubic feet of gas in just our area that we comprise, ready to be harvested. So we're very excited and appreciate the board and appreciate the division allowing us to hopefully continue.
Thank you.
Thank you. Any further comments from the trust?
Nothing further.
You good?
Thank you.
I have one more question.
Oh, I'm sorry. Steve, Church.
I don't know whether the division or Ms. Shimon can tell me, what was the basic overall production of these wells prior to them being shut in by division? Any range of production?
There at one point, there were 6 wells that were on my idle well list, and that were partially part on, and they were marginal producers. I'm not aware of all of the production for the rest of the wells, but there were some wells that were on the idle well list that we were following in the past.
Okay, thank you.
In the past, historically, when all the wells are up and going and we have a responsible operator that understands methane gas, coal bed excavation in that, rather than the traditional like offshore in that, it's very unique in the coal beds. So in the history of the wells and that, when the project is successful, it's about 1.8 MMCPF, or about $2 million a day in revenue that's generated from the project with just the 25 wells. Our goal when we get a new operator in, and they've already done the geological studies, is that it will be expanded by 30 wells in the first phase and potentially up to 100 wells in the final expansions. And we do have all of the engineering already done, ready to go. We're just waiting for the permission to move forward.
So do you lease your interest, or do you non-operate with them? You lease, okay. So you're gonna require new leases from this new operator where the wells are shut in?
Correct.
Okay.
Any further questions? Are we ready to make a motion? Do we need to discuss this? Mr. Walker looks like he might have a question.
I'm not sure what the motion will be.
I know, because it's the motion
says to abandon.
Just we deny the motion? or
To
we
orphan,
just
plug,
motion?
and reclaim. Okay. The motion's going to be that we grant
Extension of time.
relief. Right. And we'll ignore this. A motion, please,
I move that we grant the motion for extension of time.
and a second. Do we want to say to May 5th?
Yeah, to May 5th,
Thank you.
2026.
Wow. Do I have a second? It's been moved and seconded. All in favor, please say aye.
Aye.
Any opposed? And I don't know, will we have anything written on this that needs to be signed? We will prepare a motion. Thank you.
Thank you.
Have a good afternoon. Okay. Yeah. Okay. Yeah. Yeah, that's fine. Just make sure Gary gets it to me. All right.
You can ask him right now.
No. You're confusing. This is division Gary. You know board Gary.
Oh, yeah. A totally different animal, right?
Evil twin.
Are you ready, Mr. White? Okay.
Almost there. Just need to try to figure out how to make this work.
We're going.
Okay, I think I'm there.
Okay. We're moving back to item 8, docket number 2025-052, cause number 196-54. In the matter of the notice of agency action requesting the board issue an order forfeiting the bond covering wells and facilities identified as API numbers 43019, 31622, and 41019, 50023, and directing the division to orphan, plug, and or reclaim the well sites and facilities.
Okay, correction. You said 43. It should be 40. You said 41.
I'm sorry, the second number is 43-019-50023. Mr. White.
Thank you, Madam Chair. Assistant Attorney General Gary White on behalf of the Division of Oil, Gas, and Mining. And seated to my left is Joshua Payne, Compliance Manager with the division. We're here this afternoon to ask the board to forfeit bonds and direct the division to plug and reclaim. The operator of record for this matter is named New Water Financial, but as you'll hear as we present the matter to the board, New Water Financial's actually been defunct for quite some time, and another entity, Electrical Contractors Inc., while not the operator of record, has some involvement here. But just to make it clear at the very beginning, we're not asking for relief against Electrical Contractors Inc. or ECI. We're simply seeking that relief against the operator New Water Financial. So to orient the board to the matter, you'll see on the screen before you an aerial map of the facility and 2 wellheads at issue here. I'd ask that Mr. Payne describe to the board what's going on at the site as shown on the map.
So as Mr. White already stated, this is the aerial view of the facility with the 2 wellheads. You can see over in the upper right-hand corner, you've got the Harley Dome 1 XSWD, and then just below that is the Harley Dome 1, both disposal wells. And then on the facility itself, that consists primarily of 22 tank batteries, 5 of which are saltwater, and then the rest are, 5 of which are oil, and the rest are saltwater.
Thank you. We've provided some additional pictures of the facility for the board. I don't know that I'll have Mr. Payne provide an explanation for each of these, but as we go through and show the board pictures, if you have a question, just please let me know. I just want to make sure the board's oriented to what's happening here. So as you can see from the photos, we have leaks in tank battery number 1 at facility 226. Some other photos of tank number 2 and battery number 2. These are some of the contents in building number 2. And Mr. Payne, these remain on site today, correct?
Yes, they do. And just as a point of clarification, the building itself has quite a few barrels of different chemicals. I just want to point out that the division will only be responsible for EMP waste in that cleanup. The rest will fall under the other government agencies that are responsible for those types of chemicals.
Thank you. This photograph shows the Harley Dome tank. Another photo of tank number 2 leak. And tank battery number 2. And then tank battery number 1. This shows a photograph of Harley Dome 1, the wellhead. And this is Harley Dome 1X wellhead. On the slide before you now is a summary of the subject wells and facility. Mr. Payne, if you can describe to the board what we're dealing with here.
As previously stated, you've got the facility itself that has the tank batteries on site, and then the 2 wells, as previously mentioned, are both disposal wells. They have been inactive. All 3, both the tank and the facility and the 2 wellheads have both been inactive for quite some time.
Thank you. This is a map that shows regional location for the facility and the 2 wells. These are located in Carbon County, 19 miles northeast of Cisco. For the background facts here, as stated at the outset, the division seeks bond forfeiture here, orphaning, plugging, and reclamation for these 2 wellheads and 1 facility located in Grand County. The operator of record is New Water Financial LLC. New Water has actually been bankrupt since 2012. ECI obtained New Water's assets in the bankruptcy proceeding. However, since that time, they have failed to submit an operator change request after acquiring those assets. Additionally, ECI, despite numerous attempts from the division, refused to complete the required actions to clean up the site and otherwise abate violations. Over the years, both New Water and ECI have faced enforcement orders from the division. In December of 2022, the division issued a status update and request to allow transfer. We've included that in the exhibits. We thought that there might be an agreement with ECI to get the site cleaned up. However, ECI no longer communicated, and they did not respond to the status update and request to allow a transfer. If Mr. Payne can explain what that potential transfer was about for the board.
Again, just expanding a little bit on the background, when ECI obtained these wells in the facility out of bankruptcy, we admonished them and encouraged them strongly to file for an operator change, which they did not do. And then moving forward into the 2022 timeframe, after working with us extensively, or us trying to work with them extensively, they had another operator lined up to supposedly take over these wells and submit an operator change, which also fell through as part of that stipulation. Again, as part of the exhibits, that signed stipulation is in there during that time frame. But in summary, no operator change came into fruition.
Thank you. And it's because there was never a change of operator that the action today is against New Water, because New Water remains the operator of record with the division. So the violations of law that we're looking at here that would justify the bond forfeiture, Utah Administrative Code R649-3-1.16 indicates that an operator is to comply with the conditions of permits issued by the division. Here, New Water does not comply because it does not have field presence as it relates to the subject wells, and that's been the case for quite some time. Under that same rule, the division is required to take action to forfeit bond when there is non-compliance as to the conditions of a permit issued by the division, or if the operator defaults on the conditions under which the bond was accepted. The remedy that the division seeks here today is that the board order the division to collect the forfeited amounts as provided by applicable law and use those funds collected from the bond forfeiture to complete the plugging and restoration of the well to which that bond coverage applies. The bond information for the two wells, there's $15,000 each. One of those is an individual bond held by Wells Fargo, and the other $15,000 bond is held by the Utah Treasurer's Office, also in the amount of $15,000. And then for the facility itself, there's an individual bond held by the Utah Treasurer's Office in the amount of $10,000. So the total bond forfeiture sought by the division today would be $40,000 for the two wells in the facility. And because I've been through this before, I would ask Mr. Payne to help the board understand whether these amounts will be sufficient for the work that needs to be done.
In this instance, it's grossly under bonded. The estimated amount that comes from our engineering group is $400,000 for the tank battery reclamation cleanup. It's pretty extensive between the 22 tanks. And then $75,000 each for plugging of the wells, for a total of $550,000.
Does the board have additional questions about the bonding issues? Okay.
Yes.
Oh, go ahead.
Mr. Church.
So the assets were awarded by the court to ECI.
Purchased in a bankruptcy proceeding.
They were purchased. And so they have no claim to any salvage from the tanks. Is that correct?
Typically, that's the way it works. Because of those assets being a liability to the state, when it's orphaned, the state basically does what we can with the salvage, which doesn't even come close to giving us any additional funding. The private groups or entities can make a lot more out of salvage than what the state can.
Okay, but ECI is still an operating entity. You say the other entity's in bankruptcy, but does ECI have any obligation beyond the treasury bond that is awarded to the tanks?
No, according to statute and rule, ECI, because they never filed and became an official operator range, according to the state, has no anything that we can go after at this point.
Do they have any other field operations in Utah?
Now, ECI is not a oil or gas operator in the state. As their name states, they're an electrical contractor. They were basically looking to recoup some of their money that they had dealt with New Water Financial, and that's how they came into play. And we see this quite a bit, unfortunately, in the state. When an operator goes bankrupt, we'll have groups that think they're getting into some money to recoup through these failed fields or failed wells. And it ends up just basically plaguing the state, and we end up plugging in the end.
Mr. Galecki.
So when a company goes bankrupt like that, does the state participate in the bankruptcy?
I can't speak to what the practice was during the bankruptcy here, which I think was initiated in 2012. But I can speak to the current practice of the division. This actually comes up quite often. In situations where an operator declares bankruptcy, the division's practice is to ensure that the bond monies are safeguarded. There have been times when parties have argued that, for example, a cash bond might be part of the bankruptcy estate, but the division takes the strong position that no, that bond money is reserved for reclamation purposes to comply with statute. And based on what I've seen in the years that I've been here, The bankruptcy courts understand that, respect that, and typically honor that. We actually just had one of these on the mining side where the order was signed just this week. So that's the typical practice.
I guess it's tough because it's grossly under, the bond, so what? I mean, it's just a fraction. It's grossly under bonded. And so it seems like it's a normal practice.
I can't speak to the bonding issues, but the bonds do remain with the Utah Treasurer's Office and with Wells Fargo, so at least we can get something.
One more question.
Mr. Church.
So are these officially orphaned wells? And if they are, is this something that we can get out of an orphaned well grant from the federal government?
Right now they're not orphaned. That's why we're here today, is to forfeit the bond and orphan the wells so that they can move to the orphan program. And then I would call upon Megan to speak to the grant money, since she handles that.
Megan Crocker with the division. We're currently working with the Department of Energy to secure that $5 million in orphan well plugging bonds, and so we hope within the next month we're going to get that $5 million and then start plugging next year. And these wells would probably be plugged in 2027, potentially sooner, depending on how fast we can get contractors out there.
There isn't any additional leaking that will come from those wells in the next year or so. There's nothing left in the tanks, or?
I don't know the details on that. Our field staff has been out there specifically. Depending on the situation, we may go out there sooner. It really depends on contractors, and we're working on a master service agreement so we can get one company to do all of the pluggings. And if they can do things faster, then that'll definitely be something we will work towards.
What about getting rid of those chemicals? Can you get rid of those chemicals?
So again, as far as the chemicals in the building, the only ones that we can actually do anything with are the ones we have jurisdiction over, and that would be any that are directly tied to E&P waste. And then to speak back to the leaking of the wells or any, potential hazards for the site, our inspectors do a pretty good job as far as when they go to the orphan phase. That's where the field presence begins on our end, as far as making sure that those aren't a hazard. And if they are, then we bump them up on priority to get them taken care of.
Okay. More questions? Ms. Sierra.
So we don't know how much oil is in the tanks right now that's just sitting there?
No, not right now. That would be something that we'd have to have our inspectors go out and gauge. From my understanding, there's not much. I think they're pretty well empty. Again, when our inspector went out and took that inventory for those pictures that were on the slideshow, nothing was posed as a immediate threat. To include those tanks that you could see were leaking, that's pretty typical of tanks that have been empty for quite some time. They rust out at the bottom. Not a big... Yeah, basically. And it's just residual stuff in the tank, nothing. In fact, I'd be surprised if there were any full tanks out there. Maybe with some of the saltwater tanks, but definitely not the oil tanks.
More questions?
Yeah. Yeah, on the tank batteries, then were these this saltwater brine tanks, or are these oil tanks out there? Or what?
It's a mixture. It's a mixture of both. There's 5 oil tanks, and then the 17 saltwater tanks is part of this whole disposal operation.
Okay. Thank you.
And so you need authorization from us to call the bonds and transfer these, and what beyond that?
I've got a handy slide for that, Madam Chair.
Okay, thank you.
So the relief requested today by the division would be that the board issue an order forfeiting the bonds covering the subject wells. That would be the $40,000. Orphaning the subject wells and directing the division to plug and reclaim. And as to the bond forfeiture, collecting the amounts against those 3 accounts, 1 with Wells Fargo and 2 against the Utah Treasurer's Office. And then finally, directing the division to recover from respondents any costs in excess. I will speak candidly that I think that's extremely unlikely, given the defunct nature of this operator for many years. But we will request that in the order and see what we can do.
Thank you. Board, are we ready for a motion? Mr. Galecki?
I'll make the motion that we approve the division request for agency action as proposed.
And a second? It's been moved and seconded. All in favor, please say aye.
Aye.
Any opposed? Hearing nothing, your relief is granted.
Thank you, Madam Chair. We'll submit a proposed order.
Thank you. All right.
9 and 11. We'll get 2 left.
Oh, we're knocking these off here. Yes. We thought we were gonna. We thought we were gonna do 7. Yeah, he doesn't put up with any nonsense. Well, no, he's a no nonsense.
Oh, no. Thank you, board members.
Thank you.
Thank you.
You survived. Good job, Carter.
Okay. This is docket number 2025-053, cause number 470-21. In the matter of the request for agency action of Anschutz Exploration Corporation for an Order 1, establishing 2 1,280-acre or substantially equivalent stand-up drilling units for the production of oil, gas, and associated hydrocarbons from the Lower Mancos Formation, comprised of sections 20 and 29, 10 south, 25 east, SLM, and section 32, 10 south, 25 east, SLM, and section 4, 11 south, 25 east, SLM, all in Uinta County, Utah, and 2, providing exceptions from certain requirements under the board's orders entered in cause numbers 190-03, 190-13, and 190-14, and Utah Administrative Code R 649-3-31. Mr. McDonald.
Fred McDonald of Council with Lear and Lear on behalf of the petitioner, Anschutz Exploration Corporation.
Division.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Thank you. Back to you, Mr. McDonald.
Thank you, Madam Chair. With me today, appearing virtually pursuant to the board's October 9th order, are Mr. Brett Willis, the supervisor of Colorado and Utah land, Mr. Zach Gonser, the senior staff geologist, and Mr. Kamal Malik, the senior staff reservoir engineer. And I would ask that the vice chair please swear them in at this time.
Please raise your right hands. Do you swear that the evidence you're about to present is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
I do.
Yeah.
Thank you.
Thank you. The resumes of all 3 witnesses were collectively submitted as Exhibit A in this cause. If separately and independently asked about the contents of their respective resumes, the witnesses would confirm the same. Mr. Willis will be a fact witness only. Mr. Gonchar has been previously recognized by the board as an expert in geology in several causes wherein he worked for Newfield Production Company. Presuming the division has no objections, we would ask that he again be so recognized for purposes of this cause based on that previous recognition and his resume is submitted.
Yeah, no objections.
Board. So accepted.
Thank you. As this will be Mr. Malik's first time appearing in front of the board, I will qualify him as an expert in petroleum engineering at the commencement of his testimony. Again, I will be moving for admission of all of our exhibits at the end of our presentation to Chief.
Thank you.
Members of the board, Anschutz is before you today seeking approval of 2 drilling units for Lower Mancos production in various lands within its Uinta County holdings. Specifically, Anschutz is seeking to establish 2 two-sectional stand-up drilling units with authorization to drill and produce up to 4 long lateral horizontal wells with 660-foot setbacks from drilling unit boundaries and with the other standard caveats that the board has adopted for long lateral horizontal well development, including other drilling units that you've approved for Anschutz. The lands at issue are currently not subject to any board order. However, portions of them are within designated oil shale areas for which the board has adopted regulations and issued supplemental orders setting certain operational restrictions upon oil and gas operations, all intended to protect the oil shale resource. True and correct copies of these orders, which were entered in cause numbers 19003, 19013, and 19014, and the applicable regulations that were adopted at R 649-331, were collectively submitted as Exhibit B in this cause. However, as you will hear from Mr. Malik, these operational restrictions are outdated and do not account for current horizontal drilling techniques. As a consequence, Anschutz is requesting the board exempt Anschutz from certain of these restrictions, as I've outlined in the request for agency action. The board has jurisdiction over this matter pursuant to Utah Code sections 40-6-6-5, subparagraph 3B, and 40-6-6, and as relating to the oil shale exemption, we're asking that the board exercise its discretion under Utah Administrative Code R 642-2-1, subparagraph 2. A copy of the request was sent via regular mail to all production interest owners within each of the requested drilling units, including to the School and Institutional Trust Lands Administration and to the BLM's Utah State and Vernal Field offices, since the oil, gas, and associated hydrocarbons underlying the lands include state and federal ownership, as well as to the owners and the lessee of the oil shale. The mailings were sent to the parties' last addresses as disclosed by the agency and Uena County Realty records, as well as Anschutz internals records. Notice of the request and of this hearing was also duly published in the Uena Basin Standard on October 1st and in the Salt Lake Tribune on October 5th. On October 8th, the division filed a response to the request stating its non-opposition to the request, presuming Anschutz meets its burden of proof at today's hearing, including specifically how the oil shale intervals will be identified and protected through Anschutz operations, which we will do. In that regard, also on October 8th, Enfit American Oil and its sister entity, EAO Real Estate Corp., which are the oil shale owner and lessee, filed a letter in support of granting Anschutz's request and expressly stated that they had no concerns about adverse impacts upon the oil shale resulting from Anschutz's requested exemptions. No objections or other responses have been filed and no other party has made an appearance today. With that, I'll commence my examination of Mr. Willis. Mr. Willis, would you please state your name and business address for the record?
Sure. My name is Brett Willis, and I am the land supervisor for Colorado and Utah land. Our business address is 555 17th Street, Suite 2400, Denver, Colorado 80202.
And your duties include supervision over these proposed drilling units, is that correct?
Yes, that is correct.
All right, would you please state for the record the corporate and bonding status of Anschutz?
Anschutz is a Delaware corporation in good standing with its principal business in Denver, Colorado, and is duly authorized to conduct business in the state of Utah. Anschutz is duly bonded with all appropriate state of Utah agencies relevant to this cause.
All right, I'm going to direct your attention to the PowerPoint. Hopefully you can see it, and also you have hard copies in front of you of exhibits C through G. Do you recognize these exhibits?
Yes, sir, I do.
And were they prepared by you or Anschutz personnel with your review and input?
Yes, sir.
All right, turning your attention to Exhibit C, would you please explain to the board what this shows?
Yeah, so Exhibit C is a regional locator plat illustrating the subject drilling and spacing units. The blue outline is the Moose North DSU, consisting of sections 20 and 29 of Township 10 South and Range 25 East. And the orange polygon illustrates the Moose South DSU, consisting of section 32, Township 10 South, Range 25 East, and section 4 of Township 11 South, Range 25 East. Both DSUs are approximately 6 miles southeast of the town of Bonanza.
All right, turning your attention to Exhibit D, please explain what this shows.
Yeah, Exhibit D is a zoomed-in version of the Moose North DSU. The Moose North DSU is comprised of sections 20 and 29 of Township 10 South, Range 25 East, and is comprised of 1,280 acres. The north half of Section 20 is owned in fee and subject to a lease granted to Anschutz covering 50%, with the remaining 50% being unleased. The remaining lands are federal lands subject to lease UTU-93937 administered by the BLM.
And Anschutz is the lessee under that lease?
Yes, sir.
All right, turning your attention now to Exhibit E. Please explain what this shows.
Exhibit E is the Moose South DSU, which is comprised of Section 32, Township 10 South, Range 25 East, and Section 4, Township 11 South, Range 25 East, which is comprised of 1,280.46 acres. Section 32 is state-owned and subject to lease ML-54051, administered by Sitla. Section 4 is owned in fee and subject to leases granted to Anschutz and third parties, with some unleased.
And is also Anschutz the lessee under the state lease?
Yes, sir.
All right. Now turning your attention to Exhibit F, would you please explain what this shows?
Exhibit F illustrates the applicable oil shale orders. Order 190-13 applies to sections 32 and 4 through reference to an incorporation of the Order 190-03. The north half of Section 20 under the terms of Order 190-14. R649-3-31 also applies to these lands since they are within the designated oil shale areas.
And finally, turning your attention to Exhibit G, please explain what this shows.
Exhibit G is simply a table illustrating Anschutz's gross working interest in both the Moose North and Moose South DSUs. We wanted to demonstrate that Anschutz does have the majority working interest in the Moose North DSU. Anschutz owns approximately 70% gross working interest, and the Moose South DSU, Anschutz owns approximately 52% working interest.
All right, now I'm going to direct your attention to the certificate of service that was filed in this matter. This is a pleading that was prepared by my office. I'm assuming you have a hard copy in front of you.
Yes, sir, I do.
Do you recognize the names and addresses in that certificate?
I do, yes, sir.
And who are those parties and how were their names and addresses derived?
They are production interest owners in the subject DSUs, including Sitla and the BLM, as well as the oil shale owner and lessee. The list was compiled from BLM records, Sitla records, Utah County Realty records, and from Anschutz's internal land records.
All right, again, there's no Exhibit Z on this one because it was regular mailed. With that, Madam Chair, that concludes my examination. Mr. Willis?
Division, do you have questions for this witness?
Mr. Willis, just a quick explanation. The Moose South indicate that non-op gross working is 48%. Is that because the southern section is just unleased? Like, where does that 48% come from?
Yeah, thanks, Andrew, for the question. The south parcel, Section 4, is partially unleased. That's correct. There are a few leases that we have been unable to obtain to date.
Okay. And I'm assuming that's fee land, multiple owners.
Correct.
And were those owners included in your, were those owners given notice of this agency action today?
Yes, sir, they were.
All right. Thank you very much.
Board, do you have questions? Mr. Church.
Just looking at the southern unit, your surface map showed rivers going through those leases. Is that the Colorado, or do you know which rivers?
I apologize. I believe those are roads.
It's the northern. Okay, those are roads and not rivers. Okay.
Yes, sir.
Thank you.
You're welcome.
Mr. Walker.
Yeah. Can you give me a little idea on, okay, you're not 100% leased at this point in time. How far off are you from getting to that? Because that's a pretty big portion that's unleased at this point.
Yeah, we've engaged every mineral owner that we could contact. We engaged these mineral owners upwards of a year ago. And there are a handful that we've just been unable to come to terms with. But we do believe that we will be successful in leasing the majority of the remaining balance that's unleased.
Okay, so it sounds like you're at least engaged with these other lease folks, or the other owners that haven't signed the lease at this point in time. Is that right?
Correct.
Okay, thank you.
Yes, sir.
Okay, please proceed, Mr. McDonald.
Okay, with that, I'll commence my examination with Goncher. Mr. Goncher, would you please state your name and business address for the record?
Yeah, my name is Zach Goncher. I work at Anschutz Exploration, address 555 17th Street, Suite 2400, Denver, Colorado, 80202.
And what's your current position with Anschutz, and how does it relate to these two drilling units at issue today?
I'm a senior staff geologist working Anschutz's Uinta Basin assets, including the proposed DSUs.
All right, I'm going to show you what have been marked as exhibits H through L. Do you recognize these exhibits?
Yes, I do.
And were they prepared by you or Anschutz personnel with your review and input?
Yes.
Turning your attention to exhibit H, would you please explain to the board what this shows?
This is a Lower Manco subsea structure map with a 500-foot contour interval, which also shows our proposed DSUs. The map shows formation depth increasing from east to west. I'd also like to point out cross-section line A to A prime that I'll discuss in an upcoming exhibit.
All right, turning your attention now to exhibit I, please explain what this shows.
This is a Lower Mancos isopac map with a 100-foot contour interval. It shows thick and consistent Lower Mancos interval ranging from about 2,500 feet to 2,700 feet over the proposed DSUs.
All right, now turning your attention to exhibit J, please explain what this shows.
This is our type log defining the Lower Mancos interval. The type log well is the Torreys fed 112432 29.4 MCH, which is located in the Tarn unit and is included on our cross section of A to A prime.
All right, speaking of that cross section, turning to exhibit K, please explain what this shows.
Yeah, this is a cross section flattened on the top of the Lower Mancos. That Torreys type well is on the left-hand side. And the cross section shows that the Lower Mancos is stratigraphically uniform across the area, including extrapolation to the proposed DSUs.
And that's because you have limited well control as shown on that cross section, is that correct?
That is correct. The wells on the map show all Lower Mancos penetrations.
All right, finally turning your attention now to exhibit L, would you please explain what this shows?
This is a interpreted maximum stress direction. On the top map, you can see the Torreys type well represented by the star, as well as our proposed DSUs, and then our general understanding of stress direction in this area, which is pretty close to east-west, which supports our desire to space stand-up DSUs. The map on the lower left shows an image from a publication that just supports kind of that general east-west stress direction in the eastern portion of the Uinta Basin.
All right, is it your expert opinion then that the Lower Mancos constitutes a common source of supply in each of these drilling units?
Yes.
Is it also your expert opinion that the extrapolated continuity of the Lower Mancos through each drilling unit makes it attractive for long lateral horizontal well development?
Yes.
Finally, is it your expert opinion that a stand-up drilling unit orientation should allow for intersections with fractures perpendicularly and increase the success for prolific production?
Yes.
Madam Chair, that concludes my examination. Mr. Goncher.
Division, do you have questions?
No questions for this witness.
Board?
Yeah, I do.
Seeing,
Yeah. Okay, back on K, where's the mahogany's here? Is it way up or where?
It
It's not
is
on
way
the
up
type.
there.
Okay,
It's close to surface.
okay, thank you.
seeing no more questions, please proceed.
Thank you, Madam Chair. With that, I'll commence my examination, Mr. Malik. Mr. Malik, would you please state your name and business address for the record?
Yes, sir. My name is Kamal Malik, and I work for Anschutz Exploration. Our business address is 555 17th Street, Suite 2400, Denver, Colorado 80202.
And what is your current position with Anschutz, and how does it relate to these drilling units at issue?
So my current position with Anschutz is Senior Staff Reservoir Engineer. I work the assets in the Uinta Basin, and that includes the 2 DSUs in question today.
All right, since this is your first time appearing in front of the board, would you provide a very brief outline as to your education, your work experience, particularly in the Uinta Basin or an analogous basin, and any certifications, license, publications, or other recognitions as an expert by other oil and gas commissions?
Yes, sir. So I have a bachelor's in mechanical engineering, and then I have a master's in petroleum engineering from Stanford University. I have 30 years of experience in the oil and gas industry. I have experience in the Rockies region, working the Powder River Basin, the Uinta Basin, and the Piceance Basin. I also have experience in the Williston Basin, working the Bakken Formation, and then significant experience in Canada in tight and unconventional analogous formations. I'm also a registered professional engineer with the Association of Professional Engineers and Geoscientists of Alberta in the province of Alberta, Canada, a member of their registration committee, and a long-standing member of the Society of Petroleum Engineers.
Thank you. With that testimony and his resume, and presuming the division has no objections, we'd ask that the board recognize Mr. Malik as an expert in petroleum engineering for purposes of this cause.
Division.
Yeah, the division has no objections.
Board. So accepted.
Thank you, Madam Chair. Mr. Malik, I'm going to direct your attention to what has been marked as corrected Exhibit M. Was this prepared by you or Anschutz personnel with your review and input?
Yes, sir.
Okay, would you please explain to the board what this shows and its significance to today's hearing?
So this just shows a proposed development plan for, as an example of the Mohi North DSU, which will constitute the 1,280 acres DSU. So our proposed plan for the Mancos, as Mr. Gonshore showed, is about 2,600 feet. So our proposed plan would be to drill up to 4 long lateral horizontals, which we believe will result in no waste and appropriate exploitation of the resource. Based on this development plan, the setback from the boundaries will be a minimum of 660 feet. The lateral distance between the two formations, let's say, will be at least 1,200 feet, and between the wells will be at least 2,600 feet. And based on this development plan, we believe that we could get up to 9 BCF per well, which will result in up to a 6% recovery factor and total of 35 BCF recoverable resource based on what is mapped in the DSU so far.
All right, and this is this from the petrophysical data from the Torres well that Mr. Gonshore talked about?
Yes, sir.
All right. Is it your expert opinion that up to 4 long lateral horizontal wells may be necessary to maximize economic recovery from the lower Mancos in these drilling units?
Yes, sir.
Is it also your expert opinion that the 660-foot setbacks from the boundaries with more than 2,600 feet of lateral and 1,000 feet of vertical separation should prevent waste and protect correlative rights?
Yes, sir.
Okay, now I'm going to turn your attention to the oil shale situation. Would you please outline for the board what are the exemptions that Anschutz is requesting, and what is the justification for those exemptions?
Yes, sir. So in regards to the surface casing grade, which is contained in the 190-13-3A, we feel that the requirement of the casing grade capable of withholding up to 3,000 pounds collapse appears arbitrary, and there's no technical justification provided for selecting this value. AEC's or Anschutz Exploration's wellbore design is engineered using safety factors, which are derived from expected drilling parameters and actual collapse strength calculations. This ensures that casing selection is designed to realistic conditions rather than an arbitrary threshold such as of 3,000 pounds. Mandating a 3,000 pounds high collapse grade casing does not enhance protection of oil shale resources and represents an unnecessary design in our opinion. Would you want me to go to the next one?
Yes, please.
With regards to the surface cement mixture contained in 190-13-3D, requiring a cement ultimate compressive strength of 4,000 pounds would require higher cement weights than historically proven designs in this area. Such weights would significantly increase the risk of cement losses into usable groundwater aquifers, which runs contrary to the stated purpose of groundwater protection. The 4,000-pound standard appears arbitrary, is not tied to oil shale protection or any specific geologic risk. Higher strength or weight cement in this section would lead to less homogeneous cement placement and greater risk of voids, which ultimately compromises the long-term well integrity and again runs contrary to the stated purpose. Should I move to the third section, electrical log?
Yes, please.
So with regards to the electric log requirement contained in R649-331-4, so after discussions with reliable cementing vendors, this goes back to the previous point, achieving the 4,000 PSI in this interval is not feasible with standard design considerations. An AEC, Anschutz Exploration, will be running measurement while drilling gamma ray logs through the surface hole section of the well to pick the surface hole casing point. So there will be gamma ray logged over the entire oil shale interval, which will assist in its detection. And further to that, the oil shale owner lessee also has expressed no concerns with these exemptions.
All right, is it your expert opinion then that the oil shale resources will still be preserved and protected with the requested exemptions?
Yes, sir.
All right. Madam Chair, that concludes my examination. Mr. Malik.
Division, do you have...
No, I think his testimony answered the questions and the concerns the division had, so we have no further questions. Thank you.
Board, do you have questions?
Yeah, one question. What depth are you going to set the surface casing at?
I don't have the exact number in front of me, sir, but I believe it's 2,000 or somewhere thereabouts. I can come back with the exact number after talking to our
2,000
professionals.
Okay, but you're only going to see about 1,500 PSI there. Okay. Okay, that's all I have.
Yeah, yes, sir. Thank you.
And these are the only changes to the oil shale rules?
Yes, as specific
Everything else
requested.
is in effect, and NFIT has agreed to all of these changes.
They have expressed no concern based on the letter of support that is on the file.
Okay. And I do have another question. Actually, this might be... Oh, I'm sorry. In terms of spacing, in a wildcat area, because there's no really existing production around there, is it usual to include half of a spacing unit that is unleased?
Again, Mr. Willis might be able to answer that, but I think that the position is that they have a majority interest in those lands, that they are attempting to lease as many people as they can.
Okay.
Everybody's been notified and nobody's expressing any objection to the drilling unit. And it will also help, if necessary, on a compulsory pooling to already have the spacing set.
Okay. Mr. Church.
So my question is, what is your anticipated program as far as drilling these wells with the unleased parts? Are you hoping to do it next year, and what are the takeaway opportunities? Where's the infrastructure as far as moving the gas from these wells?
I could take that question. So we're still working through our 2026 plan in addition to our 27 and 28 plan. When we think about actually drilling these lands, as we sit here today, we're still in the planning phase. We have not determined that we will drill these next year. But of course, this is one step in a multi-step process in order to be prepared to drill the lands when we're ready to drill the lands. I apologize, I forgot the second question.
Asking about infrastructure takeaway opportunity.
Yeah, I apologize. I'm probably not best suited for that, but I would say that that's part of the planning process, is identifying the most economical tie-in for this pad.
Maybe I can follow up with that question. How far away are these from your federal units that you've come in front of the board and What's the infrastructure tie-ins there?
The Moose, both DSUs are approximately 2 miles to 3 miles east of our existing federal units. And of course, we do have existing pipelines that we're moving gas through in our federal units.
So the star there shows one of the wells that's in that federal unit.
Isn't this close to the Houtman properties too?
This is, the Houtman properties are in 925. And so 6 to 7 miles south, yes.
And they have gas facilities there, don't they? They have a gas pipeline that's sufficient.
Yes, ma'am, they do.
Sufficient size. Okay. Any further questions? Back to you, Mr. McDonald.
Thank you, Madam Chair. That concludes our presentation in chief. At this time, I would move for admissions of Exhibits A through L and corrected Exhibit M. And to the extent necessary, if it isn't already part of the record, the letter of support from Enefit.
Okay. Mr. Walker has one more question.
I'm sorry about throwing this in late, but so if you don't want a 3,000 psi collapse casing, what are you proposing?
So as I mentioned in my testimony, sir, we feel that that's an arbitrary number and an over design.
Sure.
Based on AEC's experience in the area and their usage, we feel that something lower would be appropriate. The most common casing design that we have been using has a maximum collapse of about 1,600 psi. And based on our calculations and our numbers and our work in the area, even that is more than adequate for the maximum collapse that the surface casing could be subjected to.
Okay, I agree with you. Thanks.
Thank you.
Exhibits. Do you have any objection?
Nope, no objections.
Anybody have an objection? Seeing none.
Just one question.
Oh, one more question.
So you're just asking for an exception in your case to these 2 units as far as a change in the cementing program and the logging program. You're not asking division to rewrite their requirements out in this area.
That's correct. It's strictly for this area and with those designations of this particular area.
Okay, thank you.
The exhibits are admitted.
Thank you, Madam Chair. With that, I'll just reserve any comments after the division makes its statement.
Division.
Thank you. Yeah, as indicated, the division had some initial concerns with one of the exceptions, but based on the testimony today and the review of the exhibits in the RAA by the division has no opposition to this RAA.
Thank you. Board, do you have any further questions or comments? Seeing none, we're back to you, Mr. McDonald.
With that, I believe we've met all the statutory and regulatory requirements here. This certainly will result in further development with protection of correlative rights and without committing waste. We believe the oil shale exemptions that have been requested have been justified through the testimony and the experience that Anschutz has. And we would ask that the board approve the request as submitted. And again, thank you very much for a long day and paying your attention here. And to the IT people, again, for allowing the witnesses' testimony to be virtual here.
Thank you. Do I have a motion?
I'll make a motion.
Mr. Galecki.
That we approve the request for agency action as submitted.
And a second?
Second.
It's been moved and seconded. All in favor, please say aye. Any opposed? Motion carries.
Thank you, and I'll prepare the order and make sure that council has an opportunity to review it before it's submitted for entry. Thank you.
Thank you.
Thank you.
All right. Are you up for the last one also, Mr. McDonald?
Thank you.
We're done.
Well, we'd like you to testify regardless.
You can stick around if you want.
Okay. Oh, this is This is Gary again.
No, this one's Andrew's. That's the last one.
11.
Yeah, but it's going to be pretty similar to the one I did. It's on forfeiture.
This has your name on it. Just ignore it. Are you ready, Mr. Haynes? This is the final docket of the day. Docket number 2025-055, cause number 196-55. In the matter of the notice of agency action requesting the board issue an order forfeiting the bond covering identified and API numbers 5003 and 43-019-31455, and directing the division to orphan plug and or reclaim the well sites and facilities. Mr. Haynes.
Thank you, Assistant Attorney General Andrew Haynes, on behalf of the Division of Oil, Gas, and Mining. Today I have with me the Enforcement Manager for the division, Joshua Payne, and the Engineering and Geoscience Manager, Megan Crocker. They'll be here as witnesses in this matter, so I would request that they are sworn in.
Please raise your right hand. Do you swear that the evidence you're about to present is the truth, whole truth, and nothing but the truth? So help you God.
I do.
I do.
Thank you.
Thank you. The division is here today before the board seeking an order forfeiting the bonds covering the Paradox Basin 3 and the Handley 1 well, both wells located in Grand County, and hoping that the board will direct the division to orphan, plug, and reclaim the wells. The division further requests the board direct the division to recover costs incurred by the plugging and reclamation against the operator, Golden Eagle Exploration, LLC. Just some background on the authority for the board to perform this action. Pursuant to Utah Code 40-6-5, the board has jurisdiction over all persons necessary to enforce and regulate the production of oil and gas, including the forfeiture of bonds and the plugging of wells. Under Utah Code R649-3-116, the division shall take action to forfeit the bond if the operator refuses or is unable to conduct plugging and site restoration. Additionally, in the event forfeiture of the bond is necessary, the matter will be considered by the board pursuant to Utah Administrative Code R649-3-116.2. After proper notice and hearing, the board may order the division to proceed to collect the forfeited amounts as provided by applicable laws for the collection of defaulted bonds or other debts, and use the funds collected from bond forfeiture to complete the plugging and restoration of the well to which the bond coverage applies. Here's just a location map as to these wells in Grand County. I don't know if would you like to speak to where exactly these are?
Sure. The location of these wells are actually just north of Arches National Park, so it's not too far away from there.
And just for illustrative purposes, here's a picture of the Paradox Basin 3 well, and here's a picture of the Handley 1 well. So just some background on these wells. Golden Eagle is the recognized operator of the wells. The Paradox Basin 3 well was spud in January of 2010 and has been shut in and has not reported any production. The Handley 1 well was spud in May of 2006, has been shut in for most of the well life, with the last reported production on April 2011. On November 4th, 2020, the division issued a notice of violation for the subject well. They indicated that the wells have been shut in between 9 and 10 years and required Golden Eagle to submit sundry notices of intent to plug by November 30th, 2020, or file an extension for good cause and well integrity information. On June 2nd, 2021, the division issued another notice of violation for the wells, indicating that the wells have been shut in for over 10 years and requiring Golden Eagle to submit sundry notice of intent to plug by July 1st, 2021, and plug the wells by August 1st, 2021, or have full cost bonding in place by August 15th, 2021. On March 28, 2024, the division issued a notice of violation for the wells. This NOV indicated that the Hanley 1 well had been shut in for 13.6 years, and the Paradox Basin 1 had been shut in for 12.9 years, causing both wells to be in violation of R649-3-36, which requires that after 5 years of non-activity or non-productivity, a well shall be plugged. The NOV required that Golden Eagle submit a plug and abandonment sundry procedures by April 15th, 2024, and plug the wells by June 30th, 2024. The NOV was mailed and sent certified mail to the respondent. The NOV was subsequently emailed and mailed to the respondent also on April 24th, 2024 and May 22nd, 2024. The compliance deadlines were not met by Golden Eagle. The division was informed that the lease related to Golden Eagle's operations issued by the Utah School and Institutional Trust Lands Administration was canceled on May 8th, 2025, at which time Golden Eagle no longer held any rights to produce from the subject wells. Just for administrative purposes, those copies of those NOVs and the letter from Sitla, these are all in the exhibits that were filed with the REA. On May 12th, 2025, the division issued a division enforcement order for the wells. The DEO included a final penalty assessment of $400,000 due to the violations in the NOV reaching maximum penalty. The DEO required Golden Eagle to submit a P&A procedure within 30 days of the DEO and plug the subject wells by August 30th, 2025. Following the DEO on June 17th, 2025, the division issued a letter informing interested parties of an appeal request in division file number 2025-501-0. The hearing for that request was scheduled for June 26, 2025. Following this informal hearing, the division entered an order on July 31st, 2025, upholding the $400,000 penalty and requiring Golden Eagle to abate the violation in the most expeditious manner possible as outlined in the DEO. To date, Golden Eagle has failed to abate the NOV violations. And with that background, I'll just ask Mr. Payne. Mr. Payne, do those statements of background facts sound correct to you?
Yes, those are true and correct.
Do you have anything you would like to add?
No, but I'm open to entertain any questions from the board.
If the board has any questions as to those facts, yes.
So the photos showed the wellhead. Are there tanks and other facilities in the surface?
I don't believe there are any tanks on this location. It's just the wellheads.
So does that affect your reclamation costs?
The current estimate for the Hanley one is $120,000, potentially more, because there's a lot of uncertainty downhole and some surface casing related issues. And the Paradox Basin 3 is estimated at $80,000, so at least $200,000 to plug these wells.
And you have $60,000 each. Is that correct in bonds?
Yeah, here's the bonds here. Both wells have individual collateral bonds of $60,000 each.
Okay. Board, do you have any further questions? Ms. Sierra.
Golden Eagle, are they, did they declare bankruptcy, or are they just not willing to respond to our requests?
At this point, they're just not willing to respond anymore at this point.
What other types of remedy do we have to go after somebody like that that's still active, but beyond collecting more of the, so that we're not left holding the bag?
Yeah. So we're able to forfeit the bonds and then use those funds to plug wells and any deficiencies that there are. So if the $200,000 estimation is correct, we'd be short $80,000. So we would pursue that $80,000 from Golden Eagle.
So you will pursue the operator for any additional?
Yes. Once we know we can't pursue the money until we've actually spent it. So once we know the exact amount, we will pursue.
What about the penalty?
We can also pursue the penalty from Golden Eagle. it would be a discussion we have as to how viable that will be. But yes, that's definitely an option.
Okay.
Yeah, do you want to go for that?
So the penalty, just for clarification, the penalty stands alone aside from the plugging ramifications and costs that exceed the bond. And what happens with the penalty once they hit that max penalty and a penalty assessment goes out is we submit it to the Department of Collections and then they go after it. It's out of our hands at that point. But it's my understanding that that's in process. That's typically the way that it works.
So you guys don't do that?
No.
Okay. Okay.
How often do you get some money back from the Department of Collections?
I have yet to see any money come back from the Department of Collections, and that's typically because the companies that we're going after are no longer a viable asset nor have any funds.
So that's a state agency that chases down.
Correct. Yep. We have collected, just as a point of, I guess, interest, we have collected some funds from penalties, but it's been from reputable operators, and that's few and far between. When we're at this stage in the game, or the process, I should say, it's very rare that we see any money come back from penalties.
So do all fines and penalties go through the Department of Collections? Like even on some of these other matters, or is it?
No, we've collected fines just through the division. If they're reputable operators, as Mr. Payne indicated, they pay their fines.
Okay.
Where's this company located, and do they have other operations here or elsewhere?
No other operations that I'm aware of. I believe we sent out notices to Arizona, and there was a couple of addresses we tried to hit them with.
One thing I'd want to just point out is we're discussing our bond rules next month, and I think this is a great opportunity to think about, and maybe, as Natasha said earlier, is to review our bond rules and what we proposed to see if it's sufficient, because we want to prevent these kind of issues in the future and adjust our bonding so we have enough going forward.
Board, do you have any further questions? Seeing none, do I have a motion?
I move that we approve the division's RAA as requested.
Hang on, Mr. Haynes.
If we can jump to the end, that's completely fine with me. I'll just put up on the screen what we are requesting. Just
okay.
Just give you a quick summary. There you go.
I'm eager to end
it's
the
all
day.
It's all in the RAA. So yeah, we're requesting that we forfeit the bonds, have you orphan the wells, and direct us to plug and reclaim with the forfeited bond amounts, and then directing us to recover any excess costs in bonding.
Thank you. Now it's time for a motion. Mr. Church.
I move that we approve the RAA as requested.
And a second?
I second.
Been moved and seconded. All in favor, please say aye.
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 Any opposed? It's been approved. Please proceed with the relief requested.
I will take care of that. Thank you.
Thank you. And with that, do I have a motion? Can we do one more? No. You can. But you won't have a quorum. Do I have a motion to adjourn?
Make a motion to adjourn.
All in favor?
Aye.
Meeting is adjourned. We are off the record.